has accepted the claim of the plaintiff.
Yes.
Now, the court has, yes, Mr. Khatunia, you remember one judgment I delivered? You were there on one side, the other side, Mr. P.K. Goswami was there on that matter pertaining to some provincialization.
Nirupama Borong, my lord.
You have, has it been reported?
Uh,
Nirupama Buru.
I have the soft copy. I can check it out.
Yes, I wanted actually there in that judgment I dealt with the question of notification.
Yes, my lord.
Yes, so if you can give it to her,
Yes,
please. Yes.
Yes.
Now come to the point.
Yes.
So the trial court decreed the suit in favor of the plaintiff. The first appellate court also did. So there is a concurrent finding of fact. Then what it means?
It means is that lawsuit, both the trial court as well as the first appellate court committed grave error, presuming that this plaintiff was in possession of the land prior to lawsuit issuing the suit. Now, although lawsuit there was to sell registered children, but this plaintiff never took possession of the he did not even lawsuit step into the disputed land. There was no possession was handed over to the plaintiff. This is the issue.
But are you in possession of the entire 2 bighas?
No. My part. Only
the remaining is vacant.
Remaining was lawsuit earlier, the defendant number 2 was there. So
then
question is lawsuit regarding
what happened to the remaining land?
On the issue is that lawsuit. Now the issue is that they are claiming that land was lawsuit partitioned in horizontal basis, and our claim is that land was in horizontal basis, and they claiming that the land was divided mutually but vertical basis. Wherein lawsuit, the plaintiff
2 courts have accepted that
on presumption. No lawsuit evidence adduced to that effect. Lawsuit.
They must have stated some evidence is given.
Some evidence on presumption.
Why will the court otherwise come up and say that yes, this is it?
Yes, lawsuit will find the findings of the trial court.
Yes, let us come.
Page 55.
Let us see the issues.
Vital issues regarding this. Whether the plaintiff was in possession of the Schedule 2 land. Now, one more question will come, lawsuit. In this issue, lawsuit, court has tried to adjudicate all the Schedule 2 land. Wherein the disputed land is lawsuit only in
the cause of action, whether in the year 19. If required any way. So 3 and issue number 5 is relevant. Into What does the registered sale deed say?
Registered shall deed lordship, registered shall deed lordship, that is.
What is the boundary of the registered sale deeds?
Boundary of the registered shall deed lordship, they have
Is
not
it as
mentioned,
per the suit?
they have not mentioned the plain.
Is it based upon the suit?
Lordship, they have not mentioned the plain regarding the sale deed. Just mentioned that they have purchased the land, but nothing else.
Hurry. The sale deeds were brought in. They were exhibited documents.
They have exhibited.
Well,
Sale deed is exhibited.
now what is the boundaries of the sale deed?
Sale deed boundary lordship, sale deed boundary is not matching with the boundary mentioned in the plain.
In the plain.
Plain
Where?
boundary is lordship will find a complete defined boundary, and the prayer also defined lordship.
Yes, Mr. Majumdar, the sale deeds boundary is different from the schedule 2A and 2B.
Same. It was his stand is in the sale deed, the boundary given could not have been given because according to them, the partition between the two brothers
Did not happen.
did not happen. They are affirming that
That is okay. But whether the perusal of the sale deed
same. But
boundaries are same with the sale deed.
same, but they are
Do you have a copy of the sale deeds?
sale deed, they have not raised this issue. What they are saying is,
It's okay.
yes,
No, because then the question comes,
yes,
if the boundaries are the same,
my lord. Boundary is same. That is why
then in that case, without a challenge to the sale deed, they cannot succeed.
exactly, my lord. They have not
That is
challenged the
why
sale
I'm
deed.
saying.
In the prosecution here, it was question was put whether you have challenged the sale deed, whether you have filed a counterclaim. They said no. I know.
Therefore, my specific question to you.
Yes.
Otherwise, it is a question of fact. Both the courts have come to a categorical fact on the basis of the evidence.
Yes.
Evidence of PW2, PW3, PW4.
PW2 is the lordship mother-in-law of the plaintiff.
So what?
So,
Mother-in-law,
lordship,
daughter-in-law, but
they are
she is on the boundary.
yes.
But she is in the boundary.
But her statement has to be considered, lordship. What he has stated.
But she is in the boundary.
He is the lordship neighbor of the suit land. That is fine. That's we have admitted. But what he has stated, definitely in favor of his son-in-law. And lordship, the question is lordship, what he has stated prior to in 2007 suit and 2008 suit are different lordship. In the 2007 suit, he has stated that he was dispossessed from the suit land lordship.
In the 2007 suit, you said that there was a partition.
There was a
In the
lordship.
2008 suit, you
No,
said that there is
there
no
was-
partition.
Stated that there was lordship amicable settlement, not partition, that we were occupying the northern and southern portion.
So isn't that a partition?
Partition and
Isn't that
lordship, no,
amount to a family partition?
partition and settlement, what I have understood is different issue, different lordship connotation. Because the partition lordship and settlement, we may settle with my colleague that yes, for a time being you occupy this person and I will occupy this person. That is lordship settlement. And partition has to be lordship either lordship oral or lordship in usual process that happen in the rural area. So there must be something written lordship in partition.
Huh?
Or oral may be yes. Partition lordship to confirm that yes.
Kindly don't change the basic idea which I have of partition or settlement also. All seems to be clear on that. You have it, Mr. Majumdar?
Pilot.
And schedule also different lordship. They have mentioned is also different.
in the cross-examination, he clearly admits that Ratneswar sold his share of the land. My vendor sold his share of the land to me.
Now, here in the sale deed, I'm not getting the schedule. The second sale deed is 2A.
There are two sales. One is of 1985.
Second sale deed is
2005 was.
2005.
2005.
2005 one, the north is Bikrita Mati, that is north is seller. Okin Bulu Soikia. East. Ipali. S. Then, boundary is same 2A. You have not challenged the sale deeds.
And my lord, in the cross-examination,
Lordship will see the first page 12, Lordship.
What?
Which portion of land, Lordship? What is the disputed land in this suit, Lordship? The first they have to show that this is the disputed land. They have not specifically, Lordship, listed in their plain that this is the disputed land.
Mr. Counsel, this lifetime I don't have the opportunity to be a trial judge any
That is
further.
true. But apparently, Lordship,
Next lifetime I may be a trial
Lordship,
court judge,
right.
then you may explain this one. Not this one. This is not going to work out here in a second appeal.
Okay.
Okay, let me dictate. What?
Next week, Lordship, I will satisfy regarding the boundary of the sale deed. Boundary of the sale
Too
deed,
much
Lordship.
of time on this.
So, Lordship, see the page 17.
What is
Page
17?
17 is schedule.
No, nothing.
Which schedule, Lordship, the disputed land.
the last line, this is cross-examination. He admits that my vendor has sold his share of land to me. That is this.
That I won't much deal into because in a cross-examination, sometimes a person they may not understand. These type of things happen. But for that I should not on an order 11, rule 11 finish it off. But on the other way, you have no case.
Ego clash, my lord. Ego. I have purchased, sale it is not challenged.
How this petitioner,
He
how
says
this
no,
applicant
not
invest and
east,
access to
west,
his
west.
land. That is the
Okay, give your name. Or Mr.
issue.
And so the learned counsel, if you take the learned, learned counsel appearing on behalf of the appellant and Mr. P. Mojumdar appearing on behalf of the respondent. Respondent,
One man.
here also you have made them performer. Your sole enemy, your brother. Yes, he is the main cause of concern.
In his judgment, Lordship, they are never reflected, Lordship, so they will not.
He has sold the land.
Right.
And then also you have made him a performer.
in a claim,
No. The instant appeal is being taken up. The instant appeal under Section 100 of the Code of Criminal Civil Procedure 1908, for short the CPC, is directed against the judgment and plea dated 3/8/2023, passed by the learned of the civil judge Dorong in title appeal number 1/2022, whereby the appeal filed by the appellant herein was dismissed, thereby affirming the judgment and decree dated 13/12/2021, passed by the learned civil judge, Junior Division number 2, Moldoi, Dorong, in title suit number 56/2013. The instant appeal is being taken up at the stage of Order 41, Rule 11, to consider as to whether any substantial question of law can be formulated in terms with Section 100(4) of the Code. CPC code. For ascertaining as to whether the substantial questions of law so proposed by the appellant formulated, this court finds it relevant to take note briefly the facts involved which have led to the filing of the instant appeal. For the sake of convenience, the parties herein are referred to in the same status as they stood before the learned trial court. The respondent number 1 herein, as plaintiff, had instituted the suit taking declaration of his right, title, and interest in respect to the land described specifically in Schedule Roman II of the plain, a decree for recovery of past possession from the defendant number 1, who is the appellant herein, a decree for permanent injunction restraining the defendant number 1 from dispossessing the plaintiff from the suit land if a decree for recovery of possession is passed in future, and for other reliefs. The edifice on the basis of which the suit was filed was that the defendant number 1 and defendant number 2, who is the performer? Defendant number 4. Okay. Edifice of the suit was filed. Is that the defendant number, the defendant, the predecessor in interest of the defendant number 1 and 2, along with the performer defendant number 4, were joint owners of a plot of land which have been specifically described in Schedule Roman I of the plaintiff. The said land measures 2 bighas 4 kata 12 lechas and is covered by dag numbers 181, dag number 181 of KP Patta number 139, situated at village Khas Punapur in the district of Dorong, Assam, and is specifically bounded by boundaries stated therein. It was the case of the plaintiff that in the year 1980, there was an amicable partition between the predecessor in interest of the defendant numbers 1 and 2 with the performer defendant number 4 and the suit land, which have been more specifically described in Schedule 2, fell into the share of the performer defendant number 4. Thereupon, in the year 2005, by the registered deed of sale, the performer defendant number 4 transferred the land which have been specifically described in Schedule Roman 2, Roman A, small a, to the plaintiff by the registered deed of sale
Performer number 2.
dated 12/8/2005. Subsequent thereto, by another deed of sale dated 3/11/2005, the performer defendant number 4 transferred another plot of land measuring 4 kathas 6 lechas to the defendant plaintiff It is also specifically mentioned that after purchasing the plots of land, the plaintiff was possessing the suit land without any objection, let, or hindrance from the defendant number 1. However, on 26/2/2007, the defendant number 1 dispossessed the plaintiff from the suit land, and it is under such circumstances the plaintiff filed a suit being title suit number 11/2007 before the court of the had filed a suit being title suit number 11/2007. However, on account of formal defects, the said suit was withdrawn with liberty to file a fresh suit. It is under such circumstances the suit was filed, which was registered and numbered, seeking the relief which, as aforestated, which was registered and numbered as title suit number 56/2013. The defendant number 1 participated in the said trial by filing a written statement. In paragraph number 2 of the said written statement, it was the specific contention of the defendant number 1 that the disputed bag is yet to be partitioned between the defendant number 1 and the performer defendant number 4. It was mentioned that the description of the suit land was wrong. It was, however, mentioned in paragraph number 8 that in the year 1980, the performer defendant number, the predecessor of the defendant numbers 1 and 2, and the performer defendant number 1 had amicably partitioned in paragraph number 8, it was denied that in the year 1980, the predecessor of the performer defendant, predecessor of the defendant number 1 and 2, along with the performer defendant number 4, had amicably partitioned the Schedule 1 land by way of family settlement. And the portion of land which was specifically described in Schedule 2 to the plain fell into the share of the performer defendant number 2. It was denied that on 26/2/2007, the defendant number 1 had dispossessed the plaintiff from the suit land. Rather, it was stated that the plaintiff did not have his feet on the suit land. In paragraph number 20 of the written statement, it was, however, stated that the suit land was not formally partitioned. However, the plaintiffs have, the defendant number one was possessing the northern half of the suit land and gave specific boundaries to that effect. On the basis of the said pleadings, as many as 7 issues were framed by the learned trial court. Issue number Roman 3 pertained to as to whether in the year 1980 the pro forma defendant number 2 and the defendant number 1 amicably partitioned the Schedule 1 land in equal shares by way of family arrangement, and if so, whether the Schedule 2 land fell in the share of the pro forma defendant number 2, who possessed it since then as its exclusive owner. Issue number Roman 5 was whether the plaintiff acquired any valid right, title, and interest over the Schedule 2 land by way of purchase from the pro forma defendant number 2 by 2 registered deeds of sale bearing deeds of sale dated 12/8/2005 and 3/11/2005, respectively. Issue number 6 was whether the plaintiff was in possession of Schedule Roman 2 land since the date of his purchase and whether he was dispossessed therefrom on 26/2/2007 by the defendant number 1. The learned trial court, by its judgment and decree dated 13th of December 2021, decreed the suit in favor of the plaintiff. In doing so, the learned trial court decided the issue number 3 in favor of the plaintiff after taking into account the evidence which have been adduced by the plaintiff's witnesses, and also taking into account that there was an admission by the defendant number 1 in the earlier suit proceedings as regards the partition of the suit land amongst the predecessor in interest of the defendant number 1 and 2 with the pro forma defendant number 2. While deciding the issue number 5, the learned trial court also decided the same in favor of the plaintiff, and more particularly taking into account the deeds of sale which were duly exhibited as exhibits 2 and 3 respectively by the plaintiff. While deciding the issue number 6, the learned trial court also decided in favor of the plaintiff. That the plaintiff was in possession of the suit land pursuant to was in possession of the Schedule Roman 2 land since the date of the purchase, and the plaintiff was dispossessed by the defendant number 1 on 26/2/2007. The defendant number one being aggrieved by the judgment and decree dated 13/12/2021, filed an appeal being titled Appeal number 1/2022 before the Court of the Civil Judge Dorong. The learned First Appellate Court had decided the said issues, said appeal issue-wise, and affirmed the judgment of the learned trial court. It is against that the instant appeal has been preferred. This court have duly heard the learned counsel appearing on behalf of the petitioner appellant, who proposed two substantial questions of law, which, as per him, can be formulated in the instant appeal. Mr. D. Majumdar, the learned senior counsel, assisted by Mr. S. Biswas, submitted that those substantial questions of law, so submitted, under no circumstances can be said to be substantial questions of law. The learned senior counsel submitted that these are purely questions of facts and does not touch on the question of perversity, for which it under such circumstances, the question of framing any substantial question of law under section 100 of the code, 100(4) of the code, does not arise. This court had given anxious consideration to the respective submissions and would hereinafter analyze as to whether the questions of law so submitted, proposed by the learned counsel appearing on behalf of the appellant, can at all be formulated as substantial questions of law involved substantial questions of law. The first the question of law which have been formulated proposed is as to whether both the learned courts below were justified in decreeing the suit on presumption that the plaintiff / the respondent number one was in possession of the suit land prior to filing of the suit. This court have duly taken note of the judgments passed by both the courts below. From a perusal of the said judgments, the learned trial court, as well as the learned First Appellate Court, have duly taken note of the evidence, and on the basis thereof had arrived at a finding of fact that the plaintiff was in possession of the suit land as described in Schedule Roman 2, pursuant to purchase. This being purely a question of fact, in the opinion of this court, cannot be said to be a substantial question of law involved, and cannot be said to be a question of law. And more so, a substantial question of law involved. Next. The next question of law which have been proposed is as to whether the learned courts below were justified in decreeing the suit, holding that the plaintiff had duly executed the sale deed which confers exclusive right, title, and interest over the suit land without considering the possession and right to sale of the seller of the said land. The said question of law, in the opinion of this court, cannot be said to be a substantial question of law, inasmuch as there is no challenge to the deeds of sale. This court have also duly taken note of that the deeds of sale specifically describe the boundaries which are same with the boundaries as described in Schedule Roman 2A and Roman 2B. Without a challenge to the said sale deed, the plaintiff cannot raise this question. This court also finds it relevant to observe that by virtue of Section 44 of the Transfer of Property Act 1882, a co-owner would be authorized and competent to sell his portion of the land. There is, however, no quarrel with the fact that the defendant number 4, defendant number 4, defendant number 4 2 is
It
his.
should be 2 laws. Earlier also Lordship was taken in 4, but it should be 2.
Huh?
And number proper defendant number 2. He has sold out the land.
Before defendant number 2 had sold out the land, who was duly competent to do so. Under such circumstances, the question of law so proposed cannot, in the opinion of this court, be a substantial question of law involved. There cannot be a substantial question of law which can be formulated in terms with Section 100(4) of the Code. Considering the above, as there is no substantial question of law which can be formulated, this court finds no merit in the instant appeal, for which the appeal stands dismissed with cost quantified now. So in taking into account the stage at which the instant appeal is being dismissed, this court is not inclined to impose any cost.
As some paragraph Lordship was taken as number 4, it should be 2 laws. Obliged.
So you didn't have your luck for 2 weeks to put this matter before me. The sad part of it.
Thanks.
Panna 4. Yes.
My Lord, we have preferred the second appeal, challenging the judgment and decree dated 5/10/2023, passed by the District Judge Nalbari in Title Appeal number 2 of 2020, whereby the judgment and decree passed in the suit was reversed.
Then
The facts of the case was, my Lord, the original suit was a suit for partition. We claim partition of our ancestral land. Defendant number 1, basically against whom the whole allegations were, he contested the suit by filing a counterclaim also. In the counterclaim, the defendant number 1 alleged that he is the absolute owner thereof, of the suit land, by virtue of adverse possession against co-owner.
Then
So the suit was decreed, counterclaim was dismissed. Against that order, against that judgment and decree, one appeal was preferred, my lord. Only one appeal. By a perusal of the appeal, that is at page, my lord, at page number 93. The prayer portion of the appeal.
Both are dismissed. Counterclaim
Ultimately-
is dismissed.
I am coming to that part, my lord.
Ah.
If you produce the prayer portion of the appeal, which they preferred,
Oh, Mr. Counsel,
Yes.
kindly don't come to the prayer. I don't take judicial cognizance of that because this is not in the type of form. There is no prayer in an appeal.
I understand, my lord.
So whatever they have done, let us be ignorant of such things. Ignorance is bliss sometimes. Kindly come.
What I intended to say, my lord, was
Yes.
maybe the appeal was preferred against the dismissal of the counter.
Oh.
And the counterclaim remained dismissed.
So we let us take it as the appeal is dismissed against the year. Now, what happened? Why the appeal was dismissed?
The appeal was dismissed, my lord.
Who filed an appeal?
The defendant number 1. My
Okay.
suit was decreed.
Why it was dismissed? The appeal was allowed. Appeal is also allowed.
Allow.
Appeal was the suit of the plaintiff as well as the counterclaim of the defendant number 1 is dismissed.
Dismissed.
Means your counterclaim is dismissed.
No, that is not my counterclaim, my lord. I was the plaintiff.
Understood. But the suit of the plaintiff is also dismissed.
Yes.
Why it is dismissed?
What happened, my lord? In this case, my lord, it is not a case where we sought partition. We categorically mentioned that there were other ancestral properties.
So on the basis of not making those people a party, the appeal was allowed partly.
Part. And another ground was, my lord, that we did not include the whole ancestral property.
That is it. For both reasons.
For those 2 reasons, my lord.
What are the substantial questions of law?
My lord, this was not a case where the plaintiff suppressed the fact that there were other ancestral properties. We categorically pleaded that there were other ancestral properties. Regarding those properties, we have got no dispute. Our names are also mutated in respect of the other ancestral property. So far as the suit property is concerned, only with regard to that property, the defendant number 1 has got mutation. And he is denying the title of the other co-sharers.
And
on that count, the first appellate court took the view that because the whole ancestral properties are not included and dismissed the appeal.
now tell me, let us see the written statement filed by that person concerned.
Defendant number 1, my lord. That is at page 96, my lord.
Can you come to page 54?
Yes, my lord.
There is an appeal preferred against the judgment and decree dated 5th of October to appeal number 02/2020 by the Court of the District Judge Nolbari. Thereby, the appeal was partly allowed, thereby dismissing the suit and also the counterclaim. The appeal is admitted by formulating the following substantial question of law: whether the learned First Appellate Court was justified in dismissing the suit filed by the plaintiff on the ground of non-inclusion, on the ground of not including all the legal or not impeding legal representatives for not impeding the wife of late Dinesh Bhattacharya,
Bhattacharya.
H-A-R-Y, and the daughter of late Dayamanti Devi, and also for non-inclusion of all properties belonging to
Narayan Sharma. Original Pattadar was Narayan.
one Narayan Sharma, since deceased. Of issue notice making it returnable by 6 weeks. Steps be taken by way of registered as well as usual. In addition to that,
Much obliged.
what is this IA business?
There was a for stay, my lord.
Stay of what?
Stay of the impugned order, your lord.
Why?
Actually, they might dispose of
Take
the
on
property.
an application for stay of the impugned judgment and decree dated so and so. Taking into account that the suit had been dismissed as well as the counterclaim is dismissed, the question of granting a stay to the said order, said judgment and decree does not arise, for which and as such the instant application is misconceived, for which the same stands dismissed. Every time you are asking for time, let it go after vacation.
Lordship, kindly timing, Lordship. He'll come.
3 occasions. 10-4, 24-5, 12-6. Every time we are asking for time. What to do? Let's have it after vacations. At the request of the learned counsel appearing on behalf of the appellants, matter stands adjourned to be listed again on 15th of July 2024.
6.
Degree of reversal. Money suit was filed. Issue is, my lord, whether the claim would be covered by Article 21 or 22 of the Limitation Act. Admittedly, it was a loan given, my lord. But the learned appellate court, first appellate court, relying on a judgment of the apex court, has held that it is a deposit. I may take your lordships to the pleadings, my lord. At page 7. That is the plaint, my lord, starts at page 6.
Page?
Page 7, paragraph 4 of the plaint. I read, madam. That the defendant number 2 knows the plaintiff and his family members very well. Out of his friendly relation with the said defendant approached and persuaded the plaintiff to lend a sum of rupees so and so and so and so and 50,000 so and so. It is pertinent to mention here that the defendants borrowed the said sum of money in the name of the defendant number 1 so and so. Para 4, madam.
And number 2 knows the plaintiff and his family. On his demand. And
Article 21, if your lordship takes up, no. Has got it. For money lent under an agreement that it is payable, it shall be payable on demand when the loan
the
is
loan
made.
is made.
Loan is
So it will be within 3 years.
3 years. The suit was admittedly filed in 2007.
And what did the trial court, first appellate court held?
First appellate court, my lordship, comes to page 41. That is the finding.
Page 41.
Issue number 2.
But what was your written statement? You don't deny. You
Taking the money, I don't deny.
no. You don't also admit that it was on demand.
It is on demand, madam. That is not difficult because it is
No,
a
no,
loan.
kindly see what has been recorded.
Lordship sees my written
Defendants
statement.
in their written statement admitted that the plaintiff had paid the amount to the Imam voluntarily and there was no assurance that the said sum would be returned on demand to the applicant. If that is so, can you therefore take the plea?
The money lent to me, madam. Of loan.
21 will apply when? When there is a demand.
Money lent and when it is demand.
No. Money lent
That it will be
and payable on demand.
on him.
Then the loan, when the date of the loan. But if it is a money lent, but not on demand, then it will be the date of the demand.
No, madam. Then it will be for money lent. 19 will come, madam.
No, kindly come to 21. For
21
money lent under any agreement that it
Hello?
shall be payable on demand,
Demand.
then on the date of the loan.
on the date of the loan. Lordship comes to 19, madam.
For money lent, for money payable
for money lent.
when the loan is made,
Loan is-
it's okay. But 22, where for money deposited
Deposited.
under an agreement, there's no agreement.
There is no. And my lord, deposited, my lord, lordship would appreciate in a bank or he has given a deposit that you please invest it somewhere, my lord. There the 22 might come. Because if your lordship
The
sees the
instant
judgment
appeal.
on which the appellate court relies on, the judgment of top line should not, it's a two-page judgment, may I just place it.
Mr. N. Dekar, the learned counsel. The instant appeal. Directed against the judgment in
29/1/2024.
9/1/2000 passed in money appeal 2011, whereby suit of the plaintiff was decreed. Thereby reversing the judgment and decree dated 21/2/2011, passed in money suit number 2007. The appeal is admitted on the following substantial question: whether the learned trial court, first appellate court, was justified in applying Article 22 of the Schedule to the Limitation Act 1963 in respect to a loan, in respect to money lent when admittedly the plaintiff states in paragraph 4 of the plaint that it was to be payable on demand. Issue notice returnable by 4 steps be taken, 6 weeks LCR be called, steps be taken by way of registered as well. There be called. Is the matter for completion of the IA Communal Hall. Application 5 of the Code of Civil of the execution of 9/1/2000 Judge number 1 Kamrup Metro at Guwahati in MA number 02/2000 code by an order passed accompanying appeal being RSA number 94/2000 had already admitted the appeal by formulating a substantial question of account that if Article 19 or Article 21 of the schedule Act is applicable, Act 1963 applicable, then the suit would be barred by limitation. This court is of the opinion that the interest of justice would be served for staying the judgment and decree dated 9/1/2000 passed by the Court of the Civil Party in MA number 02/2011 till the disposal of the incident. Accordingly, the said judgment and decree dated
29/1/2024.
9/1/2024 passed by the Court of the Learned Judge number 1 instead with the disposal of the appeal. I stands disposed.
Ben,
I take it also. The respondents have filed a suit below for specific performance of contract
Hmm.
entered into by my predecessor. Now the suit went on ex parte method, and the Learned Trial Court has decreed the suit for specific performance in respect of a land which was not the subject matter of the agreement. Different the suit premises was decreed. Against that, they have preferred an appeal. And the first appellate court upheld the decree, upheld the decree of specific performance and modified the part of balance amount. The trial court has said that 2 lakhs balance is there, and the appellate court has said 1 lakh something is there. So my first substantial question of law, whether the courts below were justified in decreeing for specific performance, which was not the subject matter of the agreement. And second, at the time of passing the decree by the first appellate court has given time period, a specific time period for payment of money, balance, for execution of the sale deed, but did not impose any liability to pay the balance amount on the plaintiff concerned. So the decree is in violation of Order 20, Rule 12. And third question, they have, in their plain, they have said that I have rescinded the contract by sending a notice to them. And the board,
Where is the plain?
plain is at page 10.
Where is the agreement?
Agreement I have not annexed, but I have certified copy. I have certified copy. It will be.
What is this sale deed?
That was earlier salary, Milord. That is in respect of earlier occasion they have obtained.
No, that is okay. But this seems to be in conformity with the schedule. You are saying on the basis of the holding number.
Yes, Milord, holding number as well as Milord boundary.
Huh?
Boundary, Milord.
But boundary is also same.
Milord, western boundary is different, Milord.
Western boundary is one own shop. So here is also own shop of the plaintiff and the Tezpur municipal holding number. So and so.
Otherwise, in their
Own shop of the plaintiffs. Here own shop of the second party. So one and the same.
in the appeal, they themselves say that different with the time.
Let them say many things. It's a question of fact. And you are on, what is the decree pass? You are on
Decree.
order 20 rules 12A.
12.
Is it? The suit for, yeah, na?
Special performance. Degree is at case 59.
Why the amount was lessened?
Because court has come to pending that some amount was adjusted for the security. And operative party is at 60 million, 360.
Why there is no mention about payment of, there is already a payment, it is also the alternate deposit of the balance consideration of rupees 1,16,000 and furnishing of requisition in the court by the plaintiff.
That is after failing, man. After failure, in case if I fail below, but within that 120 days, no payment was made. No such order was made below.
Oh no, this means the same only. Here there is one comma, page 15 of the internal page 15. There should have been a comma. Without that comma, with that comma, everything makes the same. It's a typographical error.
Page below.
It's internal page 15 of the judgment. Why are you not paying the 1,84,000?
Below. I am the vendor leader
So you pay the 1,84,000.
to exhibit the other part of the degree. Other part of the degree.
You'd be happy. You think so?
Parties are unable to do that.
Then take that money. Makes it very clear. With this judgment, one should be very happy. It is also ordered that alternatively the defendant is to return.
Both are there.
So you should be happy with this. This should not have been given by the court.
Yes, either of the one.
Court should have given that in the alternative, if within this period he does not make the payment, you are to return. As per this order, you should be more happy. Return this amount. You can't put to execution. Once you return, that's a finish. Order is wrong. In fact, he should come.
But to my understanding, within 120 days, this was not ordered to.
There's a comma. Comma is missing. So for that, it's not a substantial question of law. You put a comma here. Kindly come to page 16. To the officer of the court as per the provisions of Order 21, Rule 34 of the CPC. You get the point? Internal page 16 of the
Yes.
judgment.
Yes.
Failing which the registered sale deed shall be executed in favor of the plaintiff through an officer of the court as per so and so of the CPC. You just put a comma on deposit of so and so. With a comma, everything makes a difference.
At the time of execution.
That is not Order 20 Rule 8. Okay.
Within that 120 days, if a specific order is not passed.
You file this, you will just file a cross objection and get away. You are in more trouble. Think about it. Ask your client. Give it time. Think about it. The moment you put a comma, matter finishes. Can't be a substantial question of law. Your substantial question of law is on the basis of 27, read with this, Order 20, Rule 12. I understand that. But this, on the face of it, is not a substantial question of law. Second is, you can very well pay that 1,84,000 finished. Categorically say, alternatively, it couldn't have been passed. I think it's an oversight on the part of the learned first appellant. He should come. That why that alternative, please. Happy? Think about it. The SAO, the learned counsel, appearing on behalf of the petitioner, that he may be appellant, submits that he may be given some time for the purpose of obtaining appropriate instructions from his client after the summer vacations. Take this. I think that is the best way. Save yourself in spite of, otherwise you are paying such a huge amount of money in employing Mr. S. Sahu to do all these matters. At the end of the day, he may spend the 1,84,000 on you only. Yes, Mr.
In this case, my lord, appeal has been filed, my lord. Title appeal. The senior division Baksa discussing this argument. My lord, here substantial question is that plaintiff.
Is this the case which happened after I passed some order? No, not this. Anyway, tell me.
But
It's a suit for?
suit for degree of right, title, interest, and recovery of first possession by eviction. So for right title, the appellant defendant has nothing to say, because he admits that he is a tenant. They are tenant under the plaintiff. But only point is that they are taking that stand that since they are tenant and plaintiff is a landlord enjoying the land on rent basis, so he cannot directly file a suit of recovery of first possession by eviction. That part of the suit, my lord, suit has been challenged, my lord. And there is a provision, my lord, under subsection 4, section 54 of the Tenancy Act, settlement.
What land is this?
My lord.
Land is not urban area. Where is the land?
Rural area.
Okay.
The rural area.
So you are a tenant, admittedly.
admittedly.
Then,
My lord, our point is that since we are enjoying the land on rent basis, so the suit so far relating to eviction is not maintainable directly. First, they have to obtain a decree for rent, recovery of rent. If they fail to pay, then only suit for recovery of possession by eviction is.
Fine.
Yes, that is the provision, my lord.
which provision?
My lord, subsection 4 of section 54 of the Assam temporarily settled areas tenancy act 1971.
So he was a tenant under,
Yes.
under that act.
My
He
lord,
was a tenant under the Assam temporarily settled area tenant is here.
my lord, that is the pleaded case, my lord.
Let us see why will he make a mistake?
My lord. Lordship, may I kindly have a look at paragraph 8 of impugned judgment. Page starts from page 16, relevant paragraph, my lord, 8 at page 20.
No, does the plaintiff admit that you are his tenant?
My lord,
No.
that is their pleading, my lord.
No,
That
where is it?
we are enjoying the land on rent basis.
Where?
Lordship will find their plaint is at page 7. 11 paragraph 4, my lord.
Are you an occupancy tenant?
My lord,
How?
we are occupying the land since
No.
1984. My lord.
No, you sold the land.
No, my lord.
Yes.
Part of the land is sold. My lord.
No, that only he is asking only for the 1 bigha.
Yes, my lord. We are also disputing only 1 bigha, my lord.
But that portion of the land you sold.
But we are occupying the land as we are
Gave
allowed to
you.
occupy the land.
No, he gave you. On one hand, you are saying that you are a tenant.
My lord.
That means you admit that the plaintiff has given you the land on Adhi.
My lord.
Then how is it possible?
My lord, there, my lord, my
You
lord,
sold the land to the plaintiff on 20/2/1984.
yes.
Then
My lord, seeing then, my lord, he unable to cultivate the land, and therefore we are allowed to cultivate the land.
no, you were only allowed on 33/2009.
No, my lord. That is the disputed fact, my lord.
What
My lord,
disputed fact?
we are occupying the land after sale in the year 1984. That is, my lord, we have stated in our WS, my lord.
Then what does the Munsif hold?
Lordship will kindly have a look at, my lord, our WS, my lord, under paragraph 16, page 14.
So what is wrong? Rightly,
My lord.
rightly passed. The court have
So
duly,
far, my
both
lord,
the courts
right
have
title,
duly.
we have nothing to say, my lord. Only of that part, my lord. We are admittedly we are occupying the land, paying some rent. And therefore he cannot file this suit, my lord, for
No,
recovery
you could not do
directly.
it.
my lord.
You admittedly, you admitted during the cross-examination that the last 3-4 years you have not paid the rent.
Because he is demanding exorbitant rent.
Whatever may be,
My lord,
then what to do? What does the provision say?
provision says that for enhancement of the rent, he should file a
When he does
claim
not,
under section
when he does
29.
not receive, what does the provision say?
May take up the matter any other day, my lord.
After vacation.
Right.
The request of Mr. A.R. Sikka, the matter stands adjourned to be listed after.
Fine.
Yes.
Well, this second appeal against even the judgment of reversal.
What is the case about?
It is a suit for specific performance of the contract. I were the defendant in the suit.
You are the plaintiff.
Defendant.
And the suit was dismissed.
Suit was dismissed.
What ground?
But the suit was dismissed on the ground that the agreement, that was not an agreement for sale, but it is a kacha deed of sale.
What is this Kacha deed of sale?
It is not registered deed.
It is not required to be registered. An agreement for sale required to be registered? No.
But that was actually not the agreement for sale, but that was a sale deed.
Huh?
That was a sale deed. Terms and conditions we sell deed. This is not an agreement for sale. It is in vernacular, my lord. The writing is that, my lord.
Where is the agreement for sale? With one.
One minute, the copy. This is minute in vernacular.
But this is supported by the other documents which says that there would be the sale permission.
Sale permission is,
So all these things are there.
yes.
So this document is further supported by those documents.
Yes, but the,
So even if any, whether there was an, let us assume that there is no, this document is not. But then also there is an agreement, oral agreement also.
oral agreement also it can be specifically.
Then- What is wrong?
Well, when it is a suit for specific performance of the contract, there must be under section C, readiness and willingness. In the page 8, paragraph 14 of the plain, the cause of action for the suit arose on such and such the date of execution of the agreement for sale on 30/8/2017. There is no explanation between 2001 to 2017. Therefore, the plaintiff has failed to prove his readiness and willingness to execute it.
Paragraph 10, he pleads. Of the plaintiff, he pleads that the plaintiff is still ready and willing to purchase the suit land, but the defendant is wrongfully avoiding
But
of the plaintiff.
so far cause of action is concerned, there is no mention from 2001 to 2017.
No, but this action, forget about that agreement for sale, whatever it may be, on 30/8/2000, the date of filing application before the Visa for land sale permission, was it a joint application?
That was a joint application with my
2017. So then also that also shows that there was an agreement for sale.
There was some
Then there
mistake.
is a sale permission given on 22/12, the date of obtaining so and so. I accepted, and the date of refusal to accept the agreement for sale and the cause of action still subsists in so and so. So then, no case.
There was no readiness and willingness.
The readiness and willingness is already there. Paragraph 10 days, he categorically pleads, and the proof is also must have been given, the evidence is given. Let us see what do you
2001 to
say in the written
2017.
statement. Huh?
2001 to 2017, there was no any date for readiness.
Understood. But as on 2017, you got the made an application. On that very day, both of you must have filed an application that I am willing to sell and he is willing to hear.
The original landowner was died in the meantime, my lord.
Whatever may be, the suit is against somebody else.
Yes.
The whoever it is, the legal representative. When you file an application, forget about Exhibit 1. There was an application out there by both parties saying that we are willing to sell, and as such seeking the permission. And on the basis of that, the permission was granted.
My lord, there was also another another thing, my lord. Their case, the plaintiff's case is this: at the time the PTC was there, the land sale permission was required, but immediately after the execution of the agreement, the deed, the BTC was not created. They could have obtained, execute and register the sale.
Understood, but that is apart from the point. On this date, you have filed a joint application by which you want the sale permission. Wouldn't that constitute an agreement for sale?
That is, of course, right.
Then,
And I maybe give some time to.
Better. At the request of Mr. A.C. Sharma, the learned senior counsel, matter stands adjourned to be listed after the summer recess.
Next item also same.
Summer recess.
Next item.
Next date.
The next item.
Same. Take it. Seven. Mr. Sharma, I ask you to bring on record the affidavits, bring on record the exhibits, the application for sale, as well as the sale permission. Next date, Mr. Plaintiff, the appellant shall bring on record the application for sale which was filed, as well as the sale permission so granted, which have been duly exhibited before the trial court.
My pleasure.
Yes.
Reversal, judgment and decree. My proposed substantial question of law basically on perversity.
On
Perversity. You
the
will find
perversity.
my plan at page 7.
Huh?
Page 7, annexure 1. Very short plan. Kindly peruse from paragraph 3 to 8. Plaintiff was Caro, who preferred a suit against insurance company, seeking declaration of insurance policy of 2013-14. Third person as applicant.
When did the accident happen?
It was taken place during existence of stolen
policy.
lordship 2011-2013.
So it was during this period.
The lordship.
Then what is your case?
My case was they denied to accept that policy on the ground that my sale was dishonored.
Take off
Dishonored.
the check for premium
Premium.
was dishonored.
Dishonored.
When?
That was not communicated to me. That was not communicated to me. That was true, actually.
Check was dishonored. As such, they have repudiated the policy.
Yes.
And for which you filed a suit. Now, when did you give the check? 22 to 2013 means prior to that?
Prior to that, actually.
And the accident happened on?
2011-2013, stolen.
Was it from your account?
Yes.
So well, you must be knowing your account have been debited or not.
That was.
Well,
If you
right,
lordship kindly peruse judgment of learned trial court, lordship will find.
Trial court, forget about trial court. The question is, if it was a third party, I would have considered. But it is the first party. Then, okay.
In this regard, Supreme Court 2012-5 SCC 234 is very much clear.
What does it say?
It says, lordship, that must be communicated.
Which one? Well, is it a case of third party?
First party, lordship. Before coming to that, if you kindly peruse some findings of learned trial court as well as first appellate court.
Yes, again third party. I told you, the law is settled. If it's a third party, then obviously they will pay and recover. That is another aspect. But here is a case where your check was there, that insurance policy have been issued, your check bounced, and you knew it. I would have understood 1-2 days year after thereafter. But this check was bounced much earlier. You must have given the check prior to 23/2/2013 before the check. Then,
But Lordship, that
Okay.
particular appellant Lordship, not regularly used set.
Huh?
In,
you for the purpose of 9 months did not know that your account was debited. Then pay these 4 lakhs. You should be more careful. What do you say, Mr. Vatsaji?
If your Lordship can,
The thing is that the premium has not been paid. So the policy has not come into play.
Absolutely.
So all these
And
things are not
third party would have been a different aspect.
No, what I know about insurance, until the premiums are paid, how can the actual policy come into play? Because you have not paid, that is all. So always so many explanations will not be necessary. So here the case is the payment has not been made. So the policy will not come into play.
the insurance company has also failed to communicate. That is.
So
true.
what? You knew it from your own account.
Nowadays there's an SMS also, my lord, in the mobile. Immediately after it, yeah. And when a check fails, they charge you also.
Don't give him any more idea about SMS. Now take your seat.
Can consider some days. If
After vacation. Tara Ali, the learned counsel, appearing on behalf of the appellant, seeks some time to take further instructions from his client, list the matter after the summer recess.
Matter does not relate to stay matter, because there was a direction for it taking steps by postal circuit. And my lord, 9/1, 9/2, and 12. Accordingly, my lord, we have taken steps and this affidavit is being filed. 12, my lord, straightway refused to accept. Rest of the witness, my lord, respondents are already served.
Mr. Purkasto, what are you challenging?
Now, I have challenged, my lord, if pair for appointment of Amin Commission.
Huh?
Amin Commission, my lord.
So,
Under order 26, rule 9.
you're wrong.
Payment of matters come for affidavit.
No, for not to extend. Not to extend the stay.
No, there is no stay. No stay.
No stay?
No stay.
Huh?
It's a
Interim
long
order passed earlier shall continue.
Hello, there's stay.
Then I won't extend the stay then.
That's it. I am not sure. I've forgotten my. Hasn't he stay?
We vacate the stay. As you are not aware that there is a stay.
Because, my lord, I was a little bit confused
Ah,
regarding the steps.
then
That
now
if
to
there is-
argue what is the wrong?
If there is a stay, let this stay be continued.
Absolutely no. These matters are for the first thing immediately to be finished off.
No, immediately after vacation, they did not even
No.
appear.
That is for the first time RSS. They should not get a shock immediately. This is for a 2016 suit, 2019.
19.
And do you know what is this interim order passed? That till the next date,
Yes.
the judgment shall not be pronounced.
My lord, even then, my lord,
And from 2019,
without,
5
my lord,
years you have done the
without raising any controversy.
Then calmly come to what is it? What is the wrong thing about the
My
order?
lord, today though I am not prepared, madam, because I have the impression that total first necessary order regarding affidavit.
Chalo. List the matter tomorrow.
Tomorrow, my lord, after vacation.
Absolutely, I'm okay.
After vacation.
Hawk. Mr. A.K. Purkasthar, the learned counsel for the petitioner, seeks for an accommodation. List the matter after vacation on 22nd of July 2024.
My lord, I'm sorry, my lord, extremely sorry. 24th,
Okay, 24th of July. 24th of July 2024.
my lord.
Full stop. It is also noticed that on 14/5/2020, the interim order was directed to continue till the next date fixed. However, on 28/4/2023, the said interim order was not extended.
And so far as my lord affidavit is concerned, or she kindly make an
Not
observation.
necessary.
My lord, notice is over.
Okay. I am not extending any interim order because there is no interim order, which is what I mentioned.
It is up to your lordship, my lord.
No, it is there. You see, last time when it came up before Justice Nandi, she did not extend the interim order.
My lord, she did not extend.
And that is why you were also right in coming to a opinion that there was no interim order.
On that day, my lord, I was not ever even, my lord, there was stay order and there was a lapse on my part to renew the prayer or to make it further.
So there is no interim order. What to do? Anyways, I may only recorded it, made it clear.
All right, my lord, then lordship may fix the matter on a particular date for disposal.
I fixed it on
All right,
24th.
all right.
50.
And my lord, so far as the affidavit is concerned, notice.
Not necessary. If I am sitting, these things are not necessarily relevant. Yes. What is this?
My lord, this, my lord, actually on the point of
Huh?
jurisdiction. My lord, I
By application,
I
Red
my lord,
Center
just-
is paid to stay the
I
further
filed a
proceedings
application before
pending before the court of Iman. Why?
My lord.
Why you want to stay?
No, my lord,
What are you challenging here?
I'm challenging, my lord, actually, he filed a suit, my lord, for, actually, one flat, my lord, the sale by the purchase, promoter to both, my lord. First, it was to me, my lord, then against me, the half price to him.
Huh?
I purchased in 2012
Huh.
at the cost of 23 lakhs and other, actually, I think the amount of 2,50,000, 25 lakhs. And my lord, I got the possession certificate. I got the registration also. In 2012, we got the possession certificate. I was in possession and it was registered in 2017.
In your favor?
My favor. But in the meantime, my lord, after my lord, completion of my getting my possession certificate, my lord, the same builder, my lord, sell it to my lord plenty gold.
After your possession?
After my lord giving my possession, after 1 month of giving my possession, my lord.
Sell it?
Sell it, my lord, in 2016, my lord. But
Before?
then sell it.
And yours is 17?
My sale 17, but the agreement for sale is 2011.
And his?
His, my lord, probably 16, my lord.
Then?
And he's very interestingly, it is in half price, my lord. He is getting 10 lakhs in Ulubari, a flat in 10 lakhs. My lord. Anyway, I'm not.
But you have not challenged it.
My lord.
You
No,
have not
I am
challenged.
I am in possession. He filed a suit.
But your sale deed is subsequent.
Yes, my
Then-
main sale is subsequent.
Then 48 will come in.
Exactly.
Isn't it?
Yes, that will
Then-
come.
Huh.
But I am not on that. What happened? He filed a suit, my lord. Then when suit was filed, I made an application. By this time, the SHRI Act has come into force. So my pair was there. So since it is a dispute between the promoter and the LOT, my lord, so it can be maybe sent to the.
Now, can the RERA set aside a sale deed?
No, my lord cannot. Correct, my lord. But so far is my lord, title is he cannot claim title from me, my lord. He can title from the promoter, my lord. Because I also genuinely purchased this.
No,
my
no,
lord.
no. When he claims a title from the promoter, it includes also the title from you, because you are now interfering his right. Your sale deed is also putting a cloud on his, isn't it? That is.
This is my suit, lordship. So
That is
contention
his
of
suit,
my plant
No,
will
my
say
lord,
the
I
jurisdiction.
did not came to the court because my lord, because I was not in, because it is also registered in my favor also. I am in position, my lord. So now he
So-
came, my lord.
Why not? The letters sale deed be there. All these things. Well, show me the suit.
Yes, Lordship will find kindly peruse first prayer portion. Lordship will find at page 23.
Mr. Ali, kindly come directly to the point. Where is your suit?
Page 12, annexure 1.
Page
12, annexure 1.
Where is the prayer?
Prayer at page 23.
93.
He also paid for recovery of possession.
Yeah, so rightly so.
Page 23, madam. There is page 23.
Page
Page 23.
23.
23.
Tulude is the person who made the problem.
Yes, sir.
Who sold this?
Lordship, my agreement for sale.
Who is Tulude? You are Tulude.
Yes,
And Gargi Associates?
is the builder.
Pranjal Bharali?
They are managing directors.
Okay. Put for declaration, realization, cancellation of the deed, realization of 10 lakhs. Are you asking money?
Lordship, damage and compensation.
Okay.
Page 23, my prayer. Declaration of right title interest in view of my salary that was registered in the year 16. Recovery of possession.
Possession of it so and so. When was the suit filed? 2018. In the meantime, the RERA Act has come.
Lordship, what happened?
Where is the RERA Act?
Issues were framed in the year 2019. Kindly peruse issue.
What? What is there?
They had also filed draft issues, Lordship. On the basis of draft issues filed by both the parties, these were issues were framed. Issue number 3 and issue number 4. That itself shows that except civil court, no other court can take up this case.
Take on you. Five-line order?
Really, my lord, this type of dispute always goes to that, my lord, because he may be allotted some other, my lord. I am also
Because can he cancel?
no, my lord. Promoter
Can he cancel?
No.
Let's see the power of RERA. Power of RERA to cancel. What they can do? And where is the bar?
No, Lord. Bar is 79.
70?
9.
No sale shall have duty to entertain any suit or proceedings in respect of any matter in which the authority or adjudicating officer or the appellate tribunal is empowered under the Act to determine, and no injunction shall be granted by any court. Where is the power?
My lord.
Yes, give this thing to Mr. Mohanto.
That must be between builder and flat owner.
Okay, let us see. Well, let us see where is the power.
Transfer of title is page 17, my lord. Section 17, my lord.
This has nothing to do.
Only there is section 31, 11, 12, 14, those are effective.
Filing of complaint with the authority. Any aggrieved person may file a complaint over as the case may be. Rules and regulate. So he can't file against you.
My lord.
Can he file it against you?
But he my lord claim title from me, my lord.
And he's not claiming title from you. He is claiming title from. He's claiming that he has title. He's not claiming title from you or even from Gargi. He says that he has the title on the basis of the deal.
That's true, my lord. What I am doing, your lordship, kindly see the preamble of this act, my lord. Why I am submitting this type of dispute, my lord. Promoter can immediately, because that is, if it is his genuinely purchased from the promoter, then definitely he will be allowed, because my case is also genuine, mine. Because your lordship, kindly see my hard-earned money in 2012, I have paid everything by bank account.
So you go to RERA. You are so happy. Go to RERA.
No, my lord, I am not been this time now. He's been.
No,
I
your
am not
title. He is also a sale deed. He has
Yes.
also a sale deed of 2016. In view of 48, he has a better right.
Correct.
So under such
No, so far, my lord,
circumstances,
so far, my lord,
now,
that-
so shouldn't you be advising your client to go to RERA? Go to RERA. If you want so much.
Definitely, my lord. I'm in possession. That's why,
Then-
my lord, he's claiming possession.
What
from
do you
me.
want? Withdraw, dismiss, which one?
No, only my pair was mean before the court below was that, but send it to ERA. That was my pair, my lord. That was rejected
You
again,
made
my
a very simple, innocuous prayer, which was duly, rightly rejected by the trial court.
lord.
And now you have made that innocuous prayer a hardened prayer and come before this court. And you got to stay. Therefore, we see the first order. What does it say? Testing order, first order. With due respect. By this application under Article 227 of the Red with 115 and Section A, or you could have also added another Article 226, everything. The petitioner has prayed for stay of further proceedings.
That is their exact aim, Lordship. That is their exact aim.
That's not the aim, my lord. You
Suit is
don't
of
say
2000.
Yes,
His was an innocuous prayer. Now he wants to give impetus to that.
No, actually, my lord, your lordship tell it then. Why this genuine processor will go now, man? Your
Go
lordship.
to RERA. You are happy enough. Why you are not
No,
going?
I am in position, my lord. I mean, that is
You
not.
are in possession, but your title is defective.
My lord, at that time, no, my title is not defective. My
Your
lord.
title, no, your title, in fact, if I was in your shoes out there, I would have very well not only asked for a suit or go to RERA, ask them that this is the illegalities which have been committed, ask them to take note of that. But what you are not doing is you are trying to delay only on the basis of an agreement. Yes, you have a due right in view of Section 19(1)(b) of the Specific Relief Act. You have a better right. But the fact is, unless you do anything, you can't be. You are trying to be act as a defense. Don't you think that your case should have been more offensive instead of being offensive out here in the High Court? Maybe Mr. Mohanto does not like to go to the trial courts.
That, my lord.
Yes.
Actually, my lord, probably that builder has committed wrong. Maybe, my lord, he can allot another flat in that building, my lord. Because
Then he will go to RERA for that.
he can also, my lord, go to RERA.
Why? You are not going. You should go to RERA. Your
My allotment was done, my lord. I mean,
Mr. Mohanto, why are you not understanding?
no, I
He
understand, my lord.
has a title on the basis of a document. You don't have a title on the basis of a document. You only have an agreement for sale. And an agreement for sale in terms with Section 54 is only to that effect that you have a right to get any other document. And RERA may help you more, not him.
That's why, my
Ask
lord,
for
that's
setting
why, that
aside.
is why, my lord, I make, my lord, pair the entire matter will go to, my lord, yes, that is coming to force in 2021. That RERA Act, my lord. That's why, my lord, to just sort out the problem, my lord. Otherwise, my lord, Goral will be in trouble, my lord.
So what to do? How many years did you got to stay?
No, it's one thing, this year.
Suit is of 2018. That is, this is filed in 2022.
20?
22. That's it.
2 years.
Yes.
The loss he has occasioned. Personally, Mr. R. Ali,
No, that's,
for his
my lord,
appearance,
that's too. Actually,
we take it every day, 12 dates in a month, 2 years, 24, 5,000, 24. That's been
no, that's my lord, your lord, you can
cost.
I'll leave it to your lord.
Eh?
My lord, no, my prayer was, my lord, on the.
Your
my
prayer
lord,
was
your-
very innocuous there, but now you have strengthened it here. What to do? Dismiss with cost? Which one? I think better
I'm
you
given
withdraw.
a liberty to go to RERA. Your lord,
You are always at RERA. Why should I ask you? You should always. I say that you want to also avail other opportunities.
my lord, they will take advantage of that. my lord.
Yes. You better withdraw. I'll dictate the order. Heard Mr. T.J. Mohanto, the learned senior counsel, assisted by Mr. P.P. Dutta. Who is this? So and so. Appearing on behalf of the petitioner, and Mr. R. Ali appearing on behalf of the respondent. The learned senior counsel appearing on behalf of the appellant, petitioner, submits on instructions that he would not like to further press the instant writ petition. The learned counsel submitted that in view of the Real Estate Regulation and Development Act 2016, which came into force in the year 2021.
No, that is in 70.
When did it come?
70,
The year 2017. And as such disputes would have been would have been better resolved before the authority under the said act, that an application was filed for referring the dispute, the dispute entitled suit number 381/2018 to the RERA authority. The learned counsel for the senior counsel further submitted that the learned trial court, however, rejected the said application, and it is under such circumstances the instant application has been filed. It has also been submitted by the learned senior counsel that the RERA Act is in relation to has fairly submitted that in terms with the RERA Act, some of the prayers made in the suit cannot be adjudicated. Be that as it may, the petitioner also is aggrieved by the actions of the respondent, the builder. He therefore submits that he would not further like to press the instant petition, but withdrawal of the instant petition should not preclude the petitioner to avail such remedies otherwise available under law. So, taking into account the above, this court therefore closes the instant petition with withdrawal. It is, however, made clear that the withdrawal of the instant petition shall not preclude the petitioner herein to avail other remedies which are available under law, more particularly under the Real Estate Regulation and Development Act 2016. The interim order so passed on 21/12/2022, 21/11, 21/11/2022. Where is it? 21/11/2022 stands vacated, and the parties who are duly represented are directed to appear before the learned trial court on when? The billing starts when? He doesn't go.
First week of July. So
On-
direction may be given. Also,
On
what
5th
happened,
of July
they were aviator.
2020.
They appeared as caveator in the year 2018 itself.
Enough.
Since then,
5th of July, go there. He is not going to appear. For him, it's a summer
the
holiday.
injunction petition is yet to dispose of lordship since 2018.
I am not here to take up
Yes,
all
sir.
this.
Deeply.
WPC 6909 of 2015.
It's the opinion of this court that the interdepartmental communication dated 25/2/2013 as well as the operational guidelines dated 7/5/2013 cannot limit the petitioner's entitlement in terms with subclause 1 and 2 of clause 6 of the notification dated 27/7/2007. Be that as it may, as this court does not have the expertise to decide as to whether the various components which the petitioner alleges the same ought to be included in the entitlement, as they were a part of the industrial plant and machinery as erected at the site. This court directs the respondent authorities, more particularly the respondent number 3, 4, and 5, to make assessment of the petitioner's entitlement purely on the basis of clause 6 of the notification dated 27/7/2007, without being influenced by the communication dated 25/2/2013, as well as the operational guidelines dated 7/5/2013. The said assessment be carried out by the respondent number 3 to 5 within a period of 3 months from the date a certified copy of the incident judgment is submitted to the respondent number 5, and thereupon the respondent number 3 to 5 shall do the needful for the purpose of providing the additional benefits to the petitioner if so entitled after making such assessment as directed herein above. The respondent number 2 is also further directed to take appropriate steps upon assessment being made by the respondent number 3 to 5 so that the petitioner is conferred the benefits if so entitled after the assessment made. The entire exercise be completed within 5 months from the date the certified copy of the instant judgment is served upon the respondent number 5. Okay.
Lordship, regarding item number 41,
Hmm?
item number 41, Lordship, I have an urgency. Upgraded, Lordship.
Item number 41, you have an urgency.
That is not taken up today, Lordship.
Okay, we'll take it up. Inform the other side.
The mobile number is not available in the.
You are there.
My learned senior counsel, Mr. P. Dekar, is there. On behalf of P. Dekar, I am here, my lord.
You are there?
Yes, respondent, for the respondent, lord.
Fantastic. We'll take it up after the stay matters are over. Ask your senior counsel to come.
In this case, I have taken filed an affidavit regarding justice service. The petitioner is unable to serve the notice. Specifically mentioned in paragraph 6 of page 33.
The person works where? Where does the respondent work?
The Honda company,
Huh?
at Aichol. Honda company. I mentioned the office name.
Hulda.
Yes, Lord.
Now you say out here that you went to this office.
Office both.
Petitioner went to the office of the respondent at Honda Bigwig Aizol, West so and so near Land Revenue Branch.
Yes, Lord. That is the office. There are two offices, Lordship. Visited two offices as well as his residence also. And this
Now there is only one office where you went.
the petitioner went to the
Went to the office of the respondent situated at so and so.
Honda so and so Aichol near Land Revenue and Settlement Department
And go to Honda.
and go to Honda. Oh,
Okay, we do one thing, madam.
and she went to the court, learned court below, Lordship. On that the case was fixed on first May. And handed over the certificate copy of the orders as by this honorable court to his counsel.
Okay.
Here,
Look, pursuant to the order passed by this court on 10/4/2024, the petitioner has filed an affidavit of service wherein the petitioner had stated that attempt was made to serve the respondent at his house at his residence at Lower Jorkhat, Rkawt near Jote Bakery, Aizol, as well as also in his office at Honda Big Wing, Aizol, as well as Go to Honda, GOTU, Honda. However, the service could not be meted upon the respondent. The petitioner also tried to serve a copy of the orders so passed by this court to the counsel representing the respondent before the learned trial court, which also remained unsuccessful. Taking into account the above, this court where is that court?
district, additional district judge Aichol, Lordship.
Okay. This court directs the registry of this court to send a communication to the court of the additional district judge Aizol, Judicial District Aizol, along with a copy of the instant petition so that the said court can effect service upon the respondent by way of usual process. and more so, taking into account that the respondent had approached the state court by filing the divorce proceedings. Pusto. The learned counsel for the petitioner is directed to file an additional copy of the writ petition of the transfer petition before the registry, so the registry can take appropriate steps. List the matter again on 2nd of September 2024. The interim order passed earlier shall continue till then.
2.
Yes.
May it please for your lordship. Lordship, in the present matter, we filed our Vakalataman entered appearance. Meanwhile, lordship, spread before your lordship that 1 week time may be granted to file our response with regard to the transfer petition filed by the.
What is that? He stays at where?
Lordship?
Dibrugarh.
Yes, lordship.
Right stage at Dibrugarh.
Stay in Dibrugarh.
Husband is at
Guwahati.
He stays in Dibrugarh.
Wife stays in Guwahati, Dibrugarh, and husband stays in Guwahati, lordship.
So, why she shouldn't be sent to Dibrugarh?
Lordship may give only 1 week time, lordship, to file.
No,
our
she has to
response.
come and appear before the court.
Lordship, meanwhile, the matter has already been stayed in the.
Understood.
Lordship.
But then also she has to come and appear. But in Dibrugarh, you can appear through your advocate.
Yes, lordship. But
So-
meanwhile, lordship, we needed prayer, lordship. 1 week time must be given to file our response, lordship.
Why? When did you receive the notice?
Lordship will enter appearance on 6th of.
You want a divorce?
Lordship.
No, isn't it your urgency?
Like I need to take
Okay,
certain
we can
instructions from my client, lordship.
we can adjourn it for the next year, July. July, what will be next year, July 15, 2025? How does it matter? How will she come out here every time?
Lordship, it's a discretion of the court whether the lordship may transfer or not. Lordship may just give 1 week time to submit my response, lordship, reply, lordship.
Only answer is, question is whether she stays in Dibrugarh.
Lordship.
So, matter over. I don't need anything more. Does she work? Does she work?
Lordship, I have to take instructions from my
Oh,
client.
you don't have instructions and you are appearing. Take your instruction over the phone. We'll take it up at 3. Does she work? Does she have a source of income?
Lordship,
There's nothing else.
yes, lordship, but lordship may just give me 1 week time, lordship, to
You-
find my
you-
response.
You say whatever may be. Matter is disposed then. Unnecessary. Transfer petition shouldn't be there for long. You want this transfer petition? When I came initially and joined, I was a judge. The transfer petitions of 2016 were pending. Now we find 2024 transfer petition. That gives such happiness and solace. Man,
Lordship may take up the matter any other day, lordship.
you want to file?
We file our response, lordship.
Why? Except material instruction, there is no other reason.
Lordship may
Yeah.
take up the matter tomorrow, lordship.
Does it have any other reason? Take your material instructions.
Lordship may take up the matter tomorrow, otherwise, lordship.
Why?
Not today, lordship.
Then we'll impose cost. The court's judicial time.
I will seek instructions from my client, lordship.
3 o'clock. Fantastic. Yes. What has happened?
Steps has been taken, lordship, and dusty service was also started, lordship, on 17/6, lordship.
You have served
If
dusty service.
filed, lordship, tomorrow we'll file the affidavit of service, lordship.
You have not filed the affidavit of service. When you are filing,
Tomorrow,
counsel appearing on behalf of the petitioner submits that tomorrow he would be serving. you will be filing the affidavit of service. Taking into account the above, list the matter again in the month of July, on 19th of July 2024. Interim order passed earlier shall continue till then.
Please, Your Chief.
Yes, what is this?
We have taken steps upon the response by the registered post that was returned answered. And accordingly, we have taken justice service and thus we have not yet as of the justice service. I'm praying before your lordship, kindly give us 7 days time, file the affidavit.
Huh? You have not taken steps, but
We have
why
taken
haven't you
steps.
filed the affidavit?
We have taken steps, my lord, through the justice service, but we have not yet received the status of the justice service.
Then we have to take fresh steps by way of justice. The counsel appearing on behalf of the petitioner submits that the justice affidavit of justice service could not be filed. Steps have not yet been received back. List the matter again on 29th of July 2024. The petitioner is directed to take fresh steps by justice upon the respondents and file an affidavit of service on or before 24th of July 2024. In addition to that, the petitioner is also directed to take fresh steps by way of registered as well as usual upon the respondents, taking into account that the office note dated 15/6/2024, wherein it has been mentioned that the service could not be meted up upon the respondent number 1 in view of the location being could not be traced out. Just list accordingly. Interim orders passed earlier shall continue till the next date. Yes, what is the urgency?
One document is for lordship. That document is to be exhibited lordship. Day after tomorrow is the last date given for filing fee.
What order did you challenge?
It's number 48 lordship.
Yes, then
Document is required to be exhibited lordship with DW.
what order is this? You are challenging 15/2/2024.
Yes, lordship.
Who has the tenancy agreement?
Tenancy agreement is with them lordship and
Have
we
it?
have one photocopy lordship.
Actually, my senior is coming. From my limited understanding from my senior, there is an existing agreement in the year of 2016.
2009.
2016.
2016 you're drawing it, but there is no denial to the aspect that there is a deed of agreement as per the impugned order.
My lord, my lord, my senior is coming. Lordship. My senior is coming. He is well acquainted with the facts of the case.
Who is your senior?
Mr. P. Deka is coming. He has
Mr. P.
P. Deka, Pinarden. He's coming. Lordship, he has just informed me. He's in the
Okay. Let us keep on waiting for him.
sorry, Lordship, for the
Then
Yes,
I told you at 2. You mentioned it at 2.
yes.
Then
I informed him, Lordship.
what should we do? Okay, we'll take it up at 3 along with the other matter. And this time if your senior doesn't appear,
Yeah, Lordship.
then nothing happens.
Lordship.
220 for order.
Have taken the steps, usual and for the
Yes. What steps should you take?
usual and usual and postal ID. Then process and
Huh?
postal ID and usual process.
What postal ID? This postal ID has not happened out here from 2014 and you are going to have it now. This can't happen like this. On the ground that the service have not been meted for the last 10 years, we should dismiss the appeal. What do you say? Fantastic idea. Without them, the court cannot proceed. I gave you a last opportunity what to do, making it very clear. Under such circumstances, the appellant hearing has to take recourse to an appropriate provision of law. If these appeals are to be further proceeded with, taking into account that without due process service upon the respondents in accordance with law, the instant appeals cannot be proceeded with. Then you need to go for paper publication.
Yes, paper publication.
Have you filed an IE? Have you filed an IE for that?
Yes, Lordship. After that, I have
When?
after one.
You have not filed. I gave you an opportunity. You have not done so. Yes, Mr. Bhattacharjee, what do you have to say?
I am appealing for the collector.
Yes, what do you have to say? The service have not been meted out. What to do?
Can we have that 50% of the money?
That was given in 2014.
Yes, that is
Then
2004. Yes.
Four.
And for that, after that 10 years had passed.
Not 10 years, 20 years.
Yes. 20 years. Yes.
Then?
And our papers also, my lord can have a look. They have faded and all the typing has disappeared.
Yeah.
For 20 years.
20 years, it cannot remain like this.
Chance for filing an I and for paper. Give the last chance.
I think this
Give the
needs
last
to
chance.
stop.
Give the last chance. Lordship. Just
Lahore. This court, by an order dated 27/5/2024, made it very clear that the appellant is required to take appropriate steps as per the provisions of law so that the service can be meted out upon the private respondents. Pursuant to that, the appellant have taken steps through usual by issuing usual notice as well as by registered post upon the respondent numbers 1 to 4. It is relevant to take note of that for the last 10 years, the appeals have been pending on account of non-service of notice. Under such circumstances, this court fixes the matter again on 19th of July 2024. 19 no, as you earlier, no. Fixes the matter on 29th of July 2024. In the meantime, if the appellants do not take appropriate steps, so the service is meted out upon the private respondents, this court has to close these appeals in order to bring a closure to the proceedings.
Drastic service.
What does the service? You don't know where they are and you want to take them. Go do dusty service.
Proper address and
Huh? No, cannot. Okay. This court, however, grants permission to the appellants to take effect dusty service upon the private respondent number 1 to 4 and file an affidavit of service on or before the next date. Who died when?
Respondent number 1 died, Lordship.
When?
Lordship, he died.
How many respondents?
There are some other respondents also, Lordship, but the respondent number 1 is the plaintiff, Lordship. He died on 27/9/2023, and we have informed them on 10/11/2023. Same way, Lordship, in the year 2019, I have informed them that appellant number
Sudut
1.
Kumar Roy died.
Yes, Lordship.
He got the decree.
Yes, Lordship.
Others become useless.
Lordship, they are vendors.
Okay. It has been brought to the notice of this court that the respondent number 1, who was the plaintiff, had expired on
27/9/2023.
27/9/2021. 21.
23.
It has been mentioned at 27.
No, Lordship.
No, it has been appellant number 1 expired.
Appellant number 1 expired. We informed thereafter, Lordship, after a long gap of 1.5 years, they filed Lordship substitution along with abatement and condonation. We have not objected, Lordship, is because we have urgency. That was allowed. Now, respondent number 1 died. We informed them.
Had expired on
27/9/2023.
27/9/2023. This aspect of the matter was duly informed on 22/11/2023, as is reflected in the order sheet. However, no steps have been taken for filing appropriate applications for substitution of the legal heirs or for setting aside the abatement. Under such circumstances, the instant appeal abates inasmuch as the respondent number 1 was the plaintiff. Consequently, the appeal stands closed.
Obliged.
What time? Closed.
Obliged.
You do whatever you like. The LCR be returned after 3 months. By the way. Interim orders, if any, stands vacated. 22. What is this?
IA is for condonation of delay.
And service?
Service complete. The respondent had filed Wakalatnama. Then the engaged counsel had drawn the Wakalatnama, and this information was.
How much is the delay?
1322 days.
What is your ground?
I was not aware about the final judgment, but I had explained in my statement is made in my.
This type of grounds, this court does not. Only Supreme Court can help you. Can't blame your lawyer.
But it is a reality, though.
So what? What have you taken? Have you moved the bar council?
Bar council, verbally complaint was made to the local bar.
What?
Regarding this delay, regarding information that verbally, I have communicated to the president of the local bar association.
Verbally doesn't work. You should have moved the bar council. This can't happen like this.
What should be, sir? A condonation. I am not arguing much more on this subject.
Huh?
Clear condonation is the purely discretionary power of the Honorable Court.
Absolutely.
I am living at the mercy of the court since 2019. So since 2019, there is a lots of up and down. The private respondent received the notice. She has filed the wakalatnama. She has withdrawn.
I'm not concerned with the private respondent. Here is a case where the delay is not successfully explained. Now, this is an application under Order 41, Rule 3A, read with Section 5 of the Limitation Act 1963 for condoning the delay of 1,322 days in preferring the accompanying second appeal against the judgment and decree dated 16/5/2015 passed by the learned civil judge at Gwalpara entitled Appeal number 12/2015. I've heard Mr. F.Z. Mazumdar, the learned counsel, appearing on behalf of the applicant. None has appeared on behalf of the respondent. The sole ground which have been taken out here in the application is that the applicant, pursuant to receipt of notice entitled Appeal number 12/2014 from the Court of the Civil Judge at Gwalpara, applicants have engaged the counsel Thereupon, the said title appeal so filed by the respondent herein was allowed, thereby setting aside the judgment and decree dated 16/9/2016 passed in title suit number 42/2012 on 16/5/2015. Thereupon, it has been further stated that the applicants could come to learn about the said judgment and decree on 1/5/2018 on their own source, and pursuant thereto, the instant appeal was preferred. There is no explanation as to why the applicant did not have any contact with the engaged advocate for almost 3 years, or for that matter, during the period when the appeal was pending. There is no mention as to how the applicants could come to learn about the order, judgment and decree passed on 16/5/2015 entitled Appeal number 12/2014. Under such circumstances, this court is of the opinion that the applicants have failed to disclose any sufficient cause for condoning the delay of 1,322 days in preferring the accompanying second appeal against the judgment and decree dated 16/5/2015 passed entitled Appeal number 12/2015. Accordingly, the instant application stands dismissed. Next paragraph. Taking into account that the instant application has been dismissed, the accompanying appeal which had been directed against the judgment and decree dated 16/5/2015 entitled Appeal number 12/2015 by the Court of the Learned Civil Judge at Gwalpara cannot be entertained as it had become barred by limitation.
One more thing, Lordship, already this dismissed, but on factual that I was in touch with the lawyer. He did not inform me about the outcome of the FIR. But during throughout this period, from my side, I have contacted him.
Where is it mentioned?
It is not mentioned, but it is also not
Very well.
mentioned, right?
Next.
Obliged.
Yes. What mistake have I done?
Oh, R.S. Chauhan,
Oh, this one.
out of state, you know.
Have you thrown them out from the forest?
Lordship, that I have to
Throw them out. Then there will be urgency. Otherwise, they are keeping the review matter pending. Throw them out. How many months, years you want time? You only want time in this matter? Months.
Weeks, 3-4 weeks.
This is yet another. You have filed your affidavit. This is yet another occasion by which the petitioners herein seeks for an accommodation. In as much as on various occasions the review petitioner have taken time. The conduct on the part of the review petitioner to delay the disposal of the review petition in spite of there being a specific order on 12/2024 is reprimanded. Be that as it may, this court, for the ends of justice, adjourns the matter to be listed again on 10th of September 2024. It is made clear on that date, if the review petitioner again seeks for adjournment, this court would construe that the review petitioner is not interested in the review proceedings. And Mr. Bhattakur, throw them out. Yes, what is this?
Please, Your Lordship. So, ma'am, for the respondent number 2, Lordship. Lordship, as per the order dated 03/05/2024, Lordship, Learned Counsel for the appellant has issued notice for the withdrawal. Therefore, the applicant has received.
Yes. This court, by an order dated 3/5/2024, made it clear that if the applicants are not represented, the instant application shall be dismissed for non-prosecution. Today also, none has appeared on behalf of the applicant. Under such circumstances, this court dismisses the instant application for non-prosecution. That is 3072 দিব হ্যাঁ এটু ও 3073 কব in view of the dismissal of IA number 3072/2022 for non-prosecution, the instant application cannot be entertained, for which the same is also rejected. Then we're going to Honor dismissed. Econo Divo 4311 Condivo. It's the matter on 19th of July 2024. It is made clear if the applicant is not represented on that date, the instant application shall be dismissed for non-prosecution. Yes, you have not been able to serve.
I have already been served, my lord, on 20 September 2000 as per office notice there.
And what is this type of
But not answered has been guided.
As you are aware, has been received from here, steps for service upon the respondent has not been received in the concerned section till date. What is this? And neither answer notice here, notice service is not complete. Huh? Service not complete. Test steps. Ms. A. Gain, the learned counsel appearing on behalf of the appellant seeks a further opportunity to take steps by way of registered as well as usual upon the sole respondent. 3 days time is granted to take such steps by way of registered as well as usual upon the sole respondent. List the matter after completion of service upon the respondent.
My lord, there's order.
Same order passed earlier. There's a stay. I condivo. The interim I 748/2015. One indicative. The interlocutory application order, the interim order passed on 23/2023 is extended till the next date. Did I fix a date? No.
Yes, I'll within 3 days.
It is extended until further orders.
26 and 27.
One day's time to file the affidavit. It's ready, my lord. I will be serving it right now, my lord. Just now I got it from the department.
What have you done?
That additional instruction, my lord, whether they have got the authority, there is a commissioner who gives us instruction regarding my lord service conditions.
Why is it taking such a long time?
My fault, they have sent it, my lord. Now, my lord, additionally, that paragraph was to be added.
You must have thought that I am taking up bench 1, so I have no jurisdiction, as it is a bench 2 or 3 matter. So bench 3 matter, this court number 17 has no jurisdiction.
Oh, not that, my lord.
Yeah? But you are not taking anything actively.
I will be filing it. Just now.
They have an urgency. He has now demoted. He ought to have been promoted.
He was already holding. Yes. In fact, my lord, similar matters are also pending, my lord, because of this issue. If it is settled, my lord, they will cover their cases. Same issue is going on, whether it will be graduation or my lord, high secondary.
Hello, how much time?
My lord, Friday also. Nothing there, my lord. Only that 3 or 4
Mr. B. Gogoi, the learned standing counsel of the Finance and Taxation Department, submits that he needs a week's time for filing the affidavit in.
I'm appealing for the state of Assam.
Wait, let me conclude. The affidavit in opposition.
No, additional affidavit.
The additional affidavit. List the matter again on 23rd of July 2024. The affidavit be filed without fail by 30th of June by 29th of June 2024. The petitioners, if so advised, the review petitioners, if so advised, would be at liberty to file their reply. Mr. K. Bhattacharya appears for the government of Assam. Will dispose it of 23rd.
28.
What is this FAO? Why the originals have been called?
That has been returned by last order.
Very well. Original has been returned. Okay, very well. Now, what is this FAO business?
I have challenged an order whereby injunction was rejected, not granted in my favor by the proceeding under Land Grabbing Act. So what happened, I initiated the proceeding and notice was served upon respondent number 1. There were 2 respondents.
How are you filing an appeal?
An appeal lies, under that.
Appeal lies to where?
It's an order 39.
Understood.
I filed a petition injunction.
Understood. But if the appeal does not lie,
no application there, my lord.
You filed it before the special tribunal.
Yes, an application.
An appeal lies to where? An appeal lies under the special tribunal to where?
Tribunal is there.
Appellate tribunal. Now the appellate tribunal is not there, so we exercise 227. Now, if an injunction is not granted there, and otherwise an appeal lies to the special tribunal and the special tribunal is not there, then where do you go? Yeah. But where, under what? 115 or 227? Why FAO?
My lord, I have filed FAO, my lord, because I have filed the petition, injunction petition under order 39 rule 1 and 2.
Fantastic. You have done the right thing there. But the question is that if appeal lies to a tribunal, appellate tribunal, and the appellate tribunal is not there, then under such circumstances, would an appeal lie to the High Court? Let us be more enlightened on your what you thought. Let us also, for me, I think the High Court cannot exercise the power of appeal.
I have filed it under order 43, my lord.
Fantastic. You lightly done it, or taking it in account that it is an order passed by the but it is a special tribunal. If it is a special tribunal, can you move under by filing an FAO? Otherwise, when a decision of land grabbing is given under the first provision, there are 2. One is the civil and the other is the criminal. The civil, we could have taken it as an RFA. Can we take it? Because the appeal doesn't lie to us. Therefore, we exercise 227. Similarly, in that case, if an appeal does not lie under order 43 rule 1R, because obviously this is not an order under 104 for us. Think, we'll have it some other day.
In the meantime, by last order, I was asked to.
In the meantime, we will. I have to proceed, I'll have to dismiss. Okay. Think about it. Did you get any order here?
No, there is an interim order, my lord. By order that it 7-8.
Hey.
That may kindly be extended. So they are trying to construct over the land that I own, my lord. Despite having notice from the learned tribunal below,
what are they constructing?
But presently, my lord,
a notice has been issued.
Notice was issued. I was directed to take Dusty. I have taken, and yesterday.
No, the injunction proceeding is pending.
Yes, notice was issued.
We convert into 227 and ask them to dispose of. You are appearing there?
Yes, my lord.
There?
Because the case was stayed, my lord. That was I could not appear.
Are you appearing there?
Yes, ma'am.
Fantastic. Both of you go and fight there.
But there is another one respondent, my lord. I have taken Dusty, he has not appeared.
Not necessary. This injunction orders status quo be maintained till the disposal of that injunction application.
Yes, my lord, yes.
That's all.
I'm looking for the respondent one, my lord.
The instant appeal is filed under Order 43, Rule 1R of the Code of Civil Procedure 1908. Being aggrieved by the non-granting of an ad interim ex parte order of injunction by the Land Grabbing Case Special Tribunal, Kamrup Metro at Guwahati in Miss Case number 75/2023. The order, no doubt, is an order passed in the proceedings under Order 39, Rule 1 and 2, read with Section 151 of the Code of Civil Procedure 1908. However, the said order was been passed by the order dated 21/6/2023 is an order passed by the Special Land Grabbing Case Tribunal, Special Tribunal. Under such circumstances, an appeal does not lie before this court under Order 43, Rule 1R, read with Section 104 of the Code of Civil Procedure. As the said order is not passed by a civil court but by a tribunal, wherein there is an appeal which lies before the appellate tribunal, but yet to be constituted. Under such circumstances, this court converts the instant proceedings in the interest of justice to a proceedings under Article 227 of the Constitution. Next. This court have been duly informed that the respondents have duly put in their appearance before the court of before the learned land grabbing case special tribunal.
One. Respondent one, my lord. Two,
You are here, not there.
I have no idea about two, my lord.
In Miss Case number 75/2023. Under such circumstances, this court is of the opinion that continuation of two parallel proceedings before this court as well as before the learned land grabbing special case special tribunal would not be in the interest of justice. Under such circumstances, this court directs the learned land grabbing case special tribunal to take immediate steps for disposal of Miss Case number 75/2023 by hearing the parties to the said application so filed under Order 39, Rule 1 and 2, read with Section 151 of the CPC. Taking into account that this court, by an order dated 7/8/2023 in IC number 2240/2023 have directed the parties to maintain status quo over the suit property and also clarified that no construction activity shall be undertaken by any of the parties. This court directs that this order shall remain in existence till the disposal of Miss Case number Miss case number 75/2023. Which arose out of
Land grabbing case number 31 of 2020.
land grabbing case number
31 of
special land
2020.
grabbing case number 31/2022. Good step. This court, however, makes it very clear that the learned land grabbing special tribunal, while disposing of the miss case number 75/2023, shall dispose the same on its own merit without being influenced by the order past hearing. Dispose words returned.
In the petition and the respondent lordship, and the entire amount was settled at 14 lakhs lordship. And the respondent has already paid an amount of rupees 7 lakhs to the petitioner lordship. And upon her failure or non-appearance, the 7 lakhs was pending before the party. And lordship, and subsequently he had to withdraw because he didn't appear. He failed to appear in the family court lordship. And upon that, he has again contested the case and filed a divorce case. And now he is subsequently filing some medical documents lordship. Now I have taken instructions from my client also lordship. Her father is running a nursing home lordship, and she is currently working there.
Nursing home?
Other I do not know about it.
So what? You categorically say that you are relying on the money from your parents. Well, so this is a double-edged sword, Mr. Gupta.
My father may be.
But you say that you are getting all the money from your parents.
Because this petitioner is
Your father has good amount.
This petitioner is suffering from cancer, my lord.
Who?
Petitioner. I have annexed the medical documents, my lord. She is under treatment, my lord.
But subsequently, lordship, they've concealed the fact that they've already received 7 lakhs from us, lordship.
And my lord, the earlier petition filed for divorce was dismissed for default, my lord.
Subsequently, lordship, a mutual divorce proceeding has also been initiated, lordship. Because the talk of amicable settlement has already been taken place, and the petitioner has already received an amount of 7 lakhs from us, lordship. That has been concealed in the petition, lordship. That is why, lordship, may kindly give a chance to file my written objection so that I can put the materials on record, lordship. Because all the witnesses are also from Guwahati,
But madam,
lordship.
she is suffering from cancer.
Lordship,
That will come all the way.
lordship, all the witnesses are from Guwahati also, lordship. Otherwise, lordship may kindly send the
You do one thing, very well. You give her a flat out here. And also maintenance of 25, 30. What do you do?
125, lordship, currently, earlier I was practicing in Delhi, but right now I'm unemployed, lordship.
You are a doctor?
practicing in Delhi, but currently I'm
What were you
unemployed.
practicing?
Currently I'm unemployed, Lordship. I'm staying in Guwahati, Lordship.
What practicing? What were you practicing in Delhi?
Pharmacology.
Do one thing, you give a flat out here on rent.
Lordship subsequently says
30,000 on that and 55,000 for monthly expenses, 85,000 till the divorce proceedings are over. Yeah.
Lordship, in the 125 petition, Lordship, the court below already granted 10,000 and I'm paying that, Lordship.
What? Nothing doing.
125
She has a
proceedings also.
divorce. She's suffering from cancer. How will she come every time here? It's a very difficult thing.
Lordship, may kindly send the matter to the mediation, Lordship.
For what?
Like the talk for amicable settlement, the matter may be settled, Lordship.
You don't want a divorce? You
Because
don't want a
already a
divorce?
mutual divorce has been initiated earlier.
They are living separately from.
Why don't you go for a divorce? If they don't want,
But what happened?
you ask for whatever alimony it is different.
What happened, my lord? Earlier also, my lord, the husband has filed one divorce petition at the family court, my lord. Petitioner filed transfer petition, then it was transferred to Dibrugarh, but he has failed to appear there, my lord. Thereafter also, my lord, one mutual divorce petition was filed.
Why does he have to appear? He can appear through his lawyer.
Lordship, the main crux of the facts is that in the mutual divorce, we've already paid 7 lakhs. Only 7 lakhs out of the entire settlement amount, only 7 lakhs was pending to give. But due to the failure of our non-appearance, Lordship, I had to withdraw.
Why didn't you ask for restoration of the divorce proceedings instead of filing another one?
Lordship, may just give 1 week time, Lordship. Because today my senior is also out of station. Your Lordship may kindly accommodate me for the
Who is
day,
your
Lordship.
senior?
Mr. MK Das, Lordship.
MK?
Das. Lordship may kindly accommodate me for the day, Lordship.
Okay. Should I not transfer this? Then
That's the
you
discretion
ask
of-
your client to be ready with 85,000 monthly.
Lordship, this is the discretion of the court, Lordship.
No,
Lordship
no,
may kindly
that is not a discretion. That is, I'm putting it on order. If you are not 85,000, 30,000 for house rent, 5,000 for month. Instead of getting the money from your father from the nursing home business,
Lordship is working in her father's nursing home as per the instruction of my client, Lordship. Lordship may kindly accommodate me for the day, Lordship.
the counsel appearing on behalf of the respondent seeks for an accommodation. File a reply. This court had specifically inquired with the learned counsel appearing on behalf of the as to why a reply is required to be filed. It has been submitted that the petitioner herein, though resides at Dibrugarh, but she is duly working in the nursing home belonging to her father and is earning a good livelihood. Taking into account the above, this court adjourns the matter to be listed again on 19th of August 2024. The respondents would be at liberty to file their reply by 12th of August 2024. In addition to that, the petitioner shall also file an affidavit stating on oath as to whether she is earning any livelihood out of the nursing home business of her father. In time order, partly shall continue.
Obliged, Lordship.
Pending item 41.
Yes, what do you have to say?
My lord, application filed, Lordship.
The originals are with you, Annexure 11,
The
Annexure
original
Roman 3.
Lordship, that original Lordship, as per the plaintiff Lordship, I have stated that the tenancy started from the year 2009. But whether the originals is with me, that statement is not there in the plain. Now, in the written statement, there is even stated that the tenant has a photocopy of it, but that exercise could not be completed at that point of time. Now, after that, an application has been filed. After around 5 to 6 days taking time for filing DWs, in the month of November, one application has been filed under Order 11, Rule 14. Now, the order, if your Lordship would see,
Have you given his DW?
I have already given my statement. I'm for the
No, what is the stage of the suit now?
for DW, for filing of DW. I have already given my PW, Lordship.
Okay, you are the plaintiff.
I'm the plaintiff.
He's asking for this document.
Document.
Now, if you read Order 11, Rule 14, it says at any time of the suit, you can very well file. Now, do you admit to the contents of this document, Annexure Roman 3?
That Lordship that is the exercise which has to be carried out by the trial court under Order 11, Rule 1 and Rule 12, Lordship. Now, if that exercise was carried out, then then after that, if 14 it was invoked, that's a separate issue. But now
No. The trial court rejects it because you admit the document.
No, Lordship.
Yes.
I have never admitted the document, Lordship.
What does the order say? Upon perusal, it transpired the agreement is not the matter of dispute. In this case, as both sides have agreed, the tenancy array was executed on the year 2009.
Yes, Lordship. The tenancy is of the year 2009. That is not in dispute. I am also not denying that. But with regard to as to whether the original is with me or it is not there with me, that exercise has not been done by the court, Lordship. Now,
So under such circumstances, the court ought not to have rejected this. Court should have asked you to produce it. If he had not, then he would have produced the secondary evidence.
now that exercise under Order 11
What about Order 11? He has done under Order 11, Rule 14. If you don't produce it, he has stated that it is with you. If you say that you don't have it, then he will take the appropriate steps for giving secondary evidence.
There for secondary evidence.
Yeah.
Yes. So if your Lordship,
The court should not have done that. Interfere with this order and directing that you have to decide that the application afresh as to for calling for the originals of the year and thereupon to decide.
Yes, Lordship, that is my humble submission, exactly, Lordship. Order 11, 1 and 12 has to be completed, then 14 if possible.
I do is Order 11, Rule 1. What is Order 11, Rule 1?
12, Lordship.
Then
Rule 12 has to be done. After that, 14 if that's the
why 14? Why
14
Order
they have filed an
Rule
application.
11, 12? Order 11, Rule 12? One can very well go under Order 11, Rule 14.
Because in the plain, Lordship, I have not stated two things, Lordship. In the plaint, I have not stated whether.
As he stated in his written statement that their document is with you.
Yes, Lord. They have stated, but
So he has done in terms with Order 8, Rule 1A.
my humble submission is that, Lordship.
Heard Mr. So-and-so, the learned counsel appearing on behalf, and Mr. So-and-so, the learned counsel appearing on behalf. The instant application has been filed challenging the order dated 15/2/2024 passed in title suit number 9/2019, whereby the learned trial court, that is the court of the civic judge, junior division number 2, Karbi Anglong Diffu, had rejected the said application filed by the petitioner, who is the defendant in the suit, under Order 11, Rule 14, for calling for the originals of the agreement dated 22/1/2009, or to allow the defendant to lead his evidence on the basis of the photocopy of the agreement dated 22/1/2009 as secondary evidence. It is seen that the respondent herein, who is the plaintiff, had filed a written objection through its advocate. Be that as it may, the learned trial court, by the order dated 15/2/2024, rejected the said application on the ground that there is no dispute as regards the agreement of tenancy dated 22/1/2009. Inasmuch as the main dispute in the suit arises as to when the defendant stopped paying the rents after July 2018.
So this tenancy is with respect to agreement of 2016, not 2009. Same statement.
Where is your written statement?
Statement in page number 13, lots. E lordship, page number 15. 10E. Yeah, next is the WS logs.
This court have duly taken note of the written statement filed by the petitioner herein, wherein in paragraph number 10A, he categorically mentions about the agreement dated 22/1/2009. In addition to that, in paragraph number 28, it has been also categorically mentioned that the original copy of the rent agreement dated 22/11/2009 and 11/8/2016 are in the custody of the plaintiffs. Specific leave was also sought for by the said paragraph for the calling for the originals of the two agreements dated 22/11/2009 and 11/8/2016 at the time of evidence. It is in consonance with the said, the application was filed under Order 11/14. The learned trial court, however, rejected the said application on the ground of relevance without the said document being brought on record. Under such circumstances, this court interfered with the order dated 15/2/2024. And directs the learned trial court, that is the Court of the Civil Judge Junior Division number 2, Kamri Anglong at Difu, to decide afresh the petition number 401.
Lordship, on the day of filing evidence, Lordship, I discovered that this document was not there.
What is 471?
So 470 was subsequently for alternate, adding alternate prayer, Lordship, I filed.
No, what is this number? It is 401.
Terms were filed with the same prayer, Lordship. One on 29/9/23 and another one is 7/12/2000. Same prayer, Lordship.
Of 401/2023. I think this is 401 and excess 6. So we direct only 401. Yes. After duly taking note of the observations so made, with the above, the instant petition stands disposed. The parties who are duly, the parties have duly informed that the next date fixed before the learned trial court is on
21/6.
21/6/2024. The learned counsel appearing on behalf of the petitioner is directed to place a copy of the instant order before, certified copy of the instant order before the learned trial court for further proceeding of the suit. Mr. Pinakaka, this is the case where you need to lose a battle to win a war. He wants that document, he does not want that document has no relevancy, and you have unnecessarily spent 6 months or 7 months now here, unnecessary. He should be allowed. While practicing in the civil court, I realize one thing, small matters you need to give it out, otherwise it comes out here and it only delays it.
Hello.
9.
The last order, we have taken justice services is completed.
Service is not complete. Upon 111213.
As per the last order, we have taken justice service because is appearing.
You are appearing for 111213.
All are responding.
LCR has not been received. LCR has not been received. No? The service is complete. However, the LCR is not received. The registry shall take appropriate steps for requisitioning of the LCR at the earliest. To establish the matter for hearing immediately, pursuant to receipt of the LCR. The council, the parties are given the liberty to file applications for early hearing of the matter.
Yes, 24.
Yes, what is this?
Readmission of the appeal.
Is for default. Delay.
There was no delay.
Then what is this? So many miscases.
So many miscases in other cases, substitution and bill payment and lot of. 24 for readmission of patent. Explanation in paragraph 2.
Where is the, which one? I?
Miscase 24.
$26.
4.
My goodness. It's on time.
On time.
Why was it dismissed?
My name was wrongly reflected, my lord. Therefore, I missed the case, my lord.
Huh?
Explain in paragraph 2, my lord.
Where is the order of dismissal?
Page 9, lord.
How many Siladittas are there? With the
Charge.
spelling.
No, my lord. When I searched the keyword, my lord,
You put the keyword. Fantastic. You are the only counsel who writes Siladitya only.
Right.
Then there cannot be another one,
charge, my lord.
isn't it?
In Wakalatnama, my learned friend signed the Wakalatnama SHI, but in the petition para 2, my learned friend has mentioned SHEE. Lordship, I have no objection for restoration. It may be restored, but such type of frivolous petition should not be filed. I have no objection because Lordship may be pleased to pay my affidavit in opposition. In the an earlier last page is the Wakalatnama filed my learned friend, where he has clearly signed as SHI. But in the petition, Lordship restoration petition.
The name itself is
Page,
SHEE.
last page of my affidavit in opposition, Lordship. SHI, Siladit.
SHEE. He writes like
The
that.
point is there.
Oh, he signs. It's double E only. Anyways, he
It may be
can't
restored.
take that excuse.
It may be restored.
So we impose a cost of 5,000 upon the lawyer.
But before RSA record reveals on sale, so on earlier many dates in RSA, my learned friend did not appear.
Only this reason, my lord, because the name wrongly shows, my lord. I will
No, don't come up with this silly excuse. You can't take this court for a ride. 50,000. 1,000.
My,
On you. You are the person who filed the affidavit.
it's kind of legal aid to my client, my lord. He even not even able to pay the professional fees, my lord.
You're doing legal aid.
Like a legal aid.
Show me where have you stated in the affidavit.
The application.
If he wins the case, what is he going to get?
Title, my lord.
Then, why you are doing legal aid?
Poor fellow, my lord, he cannot afford, my lord. That's why.
Nowadays we got good lawyers.
The application which I have filed.
Then is that the reason you didn't appear on many occasions? That's the reason, because the order by which it has been dismissed for default shows that the earlier IAs have been also dismissed for non-prosecution.
The same application has been filed because the reason is that my lord, name has been wrongly shown, my lord.
No, don't come up with that silly excuse. Go to Supreme Court. That is the ground you are taking. Go to Supreme Court. Supreme Court may think what is the difference between I and double E. Go to Supreme Court. Pay cost of 10,000 to somewhere good place.
My client not able to pay.
You? No, I'm not imposing your client to you. I'm imposing upon you. not to client. As you are doing social service, do some more social service to other people. Which is the best place to send? Yes, you are a social welfare council. Tell me where to send. Some Shishu Niketan or something out there. Better no? Do more social service. 10,000 for each application. 10.
I am not able to pay, my lord, because
Absolutely no. This is the encourages the grounds which you have taken. No. I'll make it very clear. I'll say it from the affidavit. All orders, it has been shown as SHRI everywhere. Everywhere it has been shown. Earlier you didn't complain in respect to the instant matter when your name has been reflected as Siladitta, and now you are making all these things. There has to be a more ingenious approach. Not satisfied. Dismiss it. Better. Go to Supreme Court. Oh, this is an application for restoration of the RSA number 226/2014, which was dismissed for non-prosecution on 16/2023. The application has been filed on time, but however, the reason which have been assigned in the instant application by the lawyer does not inspire the confidence of this court, taking into account that in all orders passed in the instant proceedings, his name has been reflected as SHILADITYA and not SHEELADITYA. Under such circumstances, this court reprimands the conduct of the council in filing an application in such a manner. Be that as it may, taking into account the interest of justice, this court restores this court, taking into account the interest of the appellant, who would be prejudiced on account of the fault of his counsel, allows the instant application. Thereby restoring the RSA number 226/2004, thereby recalling the order dated 16/2023, passed in RSA number 226/2004 and restoring RSA number 226/2004 to the file. I stand disposed. What is this 2026?
there was substitution application also.
This is also Siladitya.
Yes.
Same now. Okay. Restore to Dipo. Reprimands. 23, reprimand. 22, reprimand. But these were much delayed.
A delay application was there.
Then, like you can reprimand, delay is there. How much delay? I would delay anything. Delay কোনখন আছে?
The application is IA 950/23.
That is for
But this is for default matter one substitution application matter.
IA for restoration of IA.
IA.
Filed for substitution. Then
my lord, IA 876/23, my lord, that is for delay confirmation application. This is on substitution. IA 951/23. Then this case, my lord, 26/23 for substitution. 23 and oblique 23.
IA কিখনত লেখক delay condonation. Yes, what do you have to say?
Be allowed. Delay is 114 days. Allowed.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. Piroy, the learned counsel appearing on behalf of the respondents. An application is This is an application for condonation of the delay of 114 days for restoration of IAC number 1770/2022. The explanation so given in the instant application by the counsel. Oh, delay, how can you file? How can you file delay?
Before.
How can you file a delay application? You can file a restoration. How can you file a delay? You can't swear the affidavit. Any? We can't do that.
It was most probably swear by the petitioner.
Absolutely no. That is again with Siladitya as LEEE. Then all these affidavits are done by you.
I have filed my affidavit in opposition.
Now, he cannot do that.
No, cannot.
You cannot file a delay application. You may file a restoration application, that is permissible, but how can you file a delay?
In substitution.
Now, delay of restoration of the substitution, can you file a delay?
But only the question of knowledge of the parties, Lordship, the advocate
Because
cannot.
knowledge derived from me, my lord, because my name was not reflected. So facts were, my lord,
Your name was properly reflected. Only your name everywhere. Not wrongly reflected. That is the name you have. You change your name whenever you feel like. There's only one name which is being mentioned out there in the cause list, Siladitya, that is you. You don't look into it. And how do you appear in all other matters?
SHRI, my lord. I searched the keyword is.
Where is the cause list?
Yes, today it's also, my lord. It was came as SHRI, my lord.
Today it has come as double E. And at that point of time,
when in the
where is the cause list you have enclosed?
In the order sheet itself, my lord, this was reflected as.
Where is the cause list you have enclosed that day?
Was not enclosed.
Order, not done.
Even in the order sheet, my lord, name was.
The counsel appearing on behalf of the petitioner. The counsel appearing on behalf of the petitioner shall bring on record the cause list of the dated 16 to 2023. by way of filing an affidavit. उसका order करो. No. Is a stay? Or stay has been vacated.
I'm the plaintiff. After vacation,
You file whenever you may file after 10 years. That is your lookup. You may again search your name.
Lordship, in this case, Lordship, I'm sorry, Lordship. As the sole respondent,
What is this, madam?
I'd say Lordship.
IA for what?
I am for Lordship, detail Lordship.
How much?
85 days Lordship.
119. How much is the delay? $119 delay.
My lord, the name of Mr. A. Sattar is wrongly shown in the process, my lord.
Huh?
My lord, the name of Mr. A. Sattar may be struck off, my lord. It is wrongly reflected in the cross list, ma'am.
Now service?
Notice has been answered.
Name has been struck off. Struck off the name of here. Notice have been issued to the sole respondent by steps by usual post have not been received by section 20. Service not complete. The office note dated 23/4/2024 shows that the service is not complete. Accordingly, list the matter after completion of service.
My lord,
It IA 201618.
my lord, if I may, I pray for the name of Mr. A. Sattar to be struck off.
Has already been
Yes.
struck off.
Hello.
I can't help it.
Hello.
The name, already there is an order.
Yes.
Apply.
I is for condonation of delay, Lordship. Notice already issued and all the respondents received a week service.
For condonation of delay, others have received.
Yes. For office not dated.
How much is the delay? Hello, we condone the delay. Service is complete upon others.
9/11/2000.
This is an application filed under Order 41 Rule 3A of the Code of Civil Procedure, read with Section 5 of the Limitation Act 1963 for condoning the delay of 78 days in preferring the in filing the accompanying regular second appeal directed against the judgment and decree dated 19/12/2022 passed in title appeal number 15/2020 by the learned court of the civil judge Borpeta. Full stop. It is seen that the service upon the main defender respondents have been duly complete. However, none has appeared on behalf of the said defendants. Be that as it may, this court, having taken note of the grounds which have been assigned in the instant application, is of the opinion that the applicants have duly explained the applicants herein have duly explained, have shown sufficient cause in preferring the delay in preferring the accompanying second appeal. According the delay stands condoned. The registry is directed to register the accompanying second appeal and list the matter under Order 41 Rule 11 of the Code immediately after the summer recess.
Apply.
I stand dismissed.
For condonation of delay, but as per official data 56, service on respondents are not complete. Lordship.
Complete?
Not complete.
I am for 224. and 11213.
Who is one?
One was the original respondent. Look.
How are you connected with one?
Because they are the legal.
One, somebody has appeared, 1A, 1B, 1C. 2 to 4. Who is 5? Who is 5? Anywhere connected with Mr. Sahu?
No.
Who is 5?
That's Sahid.
And how much is the delay?
475.
Okay, we dismiss it. Why should we go into all these things? Service has not been able to be considered. Dismiss it. Don't take all this pain of affecting against service. Why do you spend unnecessary money?
Explain.
So what? You have blamed your lawyer? Then what is the other ground?
Prayer number 3, Lordship.
What is your ground?
Ground is that the second appeal is pending before this honorable court for final disposal. In the meantime, the respondent number 1 has died. But that fact was not informed to the lawyer. But whenever they in 2023 came to inquire about the matter, then during the conversation, they informed that respondent number 1 died.
Then
the lawyer advised them to file the application.
This is for what? IA for?
For condonation of village substitution.
Substitution?
Yes.
Okay. Who is appearing for respondent number 5 earlier?
Earlier also perhaps not.
The proceeding ex parte? Who was appearing for respondent number 5? And why do you need the performer respondents?
But the respondent 5 is the main respondent.
Yes, main one is 5. And
it's not.
there's a stay, Mr. Sahu.
Look.
Stay.
Perhaps you don't. No. Because
They
were the plaintiff, they have come.
So, you're a plaintiff. So you have no urgency. Okay, fantastic. The office note shows that the service upon the respondent number 5, along with a host of performer respondents, are not complete. It's the matter after completion of service. 2815. Yes, you have received everything. The BKJ hearing on behalf of the review petitioner submits that the review petitioner have received and the entire amount, and as such would not further press the instant review petition. The GC Bora, the learned standing counsel of the ASTC, submits that all amounts have been duly paid to the review petitioner. Taking into account the above, the instant review petition is closed. Yes, what is this?
Also, this review petition has been filed against the order dated 1811. The scheme under which the respondent has done the work was a central and state government.
Yes, you are appearing.
I am paying, Lordship. As per
For?
the petitioner. Lordship, I was the petition in the writ petition, Lordship.
What has happened? What is the mistake we committed?
Not
Oh, there is a direction be given out there for the purpose of making them a party. The direction.
Yes, Lordship. Ministry of Jal Shakti, Lordship.
Without the Ministry of Rural Affairs, it is difficult.
Jal Shakti, Lordship.
Huh?
Ministry of Jal Shakti, Lordship.
Without Jal Shakti, you cannot comply.
Yes, Lordship.
Then why didn't you inform this court at that point of time?
Point of time I was unaware, Lordship.
Is he entitled to the amount?
Yes, Lordship.
Have you stated on affidavit? File it. Counsel appearing on behalf of the respondent, appellant, review petitioner shall file an affidavit as to whether the petitioner is entitled to the amount of rupees 24,99,741 after the verification which this court had directed to be carried out by the Chief Engineer, Water Resource Department, Chennai. List the matter again on 22nd of July 2024. Once it is being done, then we will take appropriate action.
Published.
Yes.
Your Lordship, I had taken steps. However, Your Lordship, I apologize that we could not take steps to justice. I'm praying that at least
Service?
week's time may be granted to me. Your Lordship.
For
I've
what?
taken steps for dusty service, Your Lordship. I've taken.
You have not taken. There was a direction I gave you yeah, stay. You have not. We vacate that order. Immediate.
A week's time, Your Lordship.
No. Sorry. This is a long-term order. You have been taken. You have not taken steps by way of dusty.
I apologize for this.
Yes. Can't help it. Is he your not brother?
No, Your Lordship.
Who is he?
A different person.
And the suit is pending?
Yes, Your Lordship.
What has happened to the suit?
It's still pending. They have not appeared. They have not appeared, Your Lordship.
So?
I'm only praying for a week's time, Your Lordship.
No, nothing doing. I'm vacating that order. You gave all the address which is wrong. Sorry. Keep it. Dismissing your appeal. What is the next date of the suit?
August, Your Lordship. 22 August.
22?
August 2020.
What happened on 21?
They didn't appear, Your Lordship.
Huh?
In stepped upon them, they didn't appear.
They have not appeared. Then? Lehok, IA 1380/2024. This court, by an order dated 17/5/2024, directed this court, by an order dated 17/5/2024, though passed an injunction order, but inadvertently did not issue any notice the instant application. Is directed to the appellate court, therefore, Now, you have not been able to communicate this order to the other side.
Yes, Your Lordship.
Have you?
No, Your Lordship. I have not been able to communicate. Your
Then
Lordship.
what is the sense of this order?
It will be a week's time, Your Lordship. Week's time, Your Lordship.
For what?
For dusty service, Your Lordship. For dusty service, Your Lordship.
No, you have not taken steps. I gave you on 17/5. Today it's 6.
I agree, Your Lordship. He was not well, Your Lordship. Considering that aspect, Your Lordship.
Sorry, Mr. Deori. I can't help it. Could that person stop coming after this order?
They have not come, Your Lordship, after this order.
After this order, but before passing of this order, they came.
Yes, Your Lordship. After this order.
And you have not been able to communicate this order.
Yes, Your Lordship.
How? How did this happen?
I don't know, Your Lordship, but they had not come after this order.
This is too magical. You have not been able to communicate this order, but just before the order being passed, they have come.
To Your Lordship, they came, Your Lordship.
How do they know about an order being passed?
I am not aware of it.
You filed a suit also. You go there. Nothing doing. I protected you for some time because the next date is fixed on 21.
2 August, Your Lordship. So on that day, Your Lordship.
It was fixed when? Before the learned trial court?
21/4.
Huh? 22/6. When is the next date?
22 August, Your Lordship.
No, the earlier order.
The earlier order, it was 6/6/2024. 6/6/2024. At page 96, Your Lordship, of my IA.
What happened on 6/6?
They didn't appear on 6/6, Your Lordship.
So, should we continue a parallel proceedings? If you have not taken service. Sorry. Oh. The instant appeal was filed being agreed by the order dated 18/4/2024 passed by the Court of the Civil Judge, Senior Division Number 3, Kamrup Metro at Guwahati, whereby the learned trial court only issued notice but did not grant the ad interim ex parte injunction, thereby fixing 6/6/2024 for service report / objection in Ms. J case number 357/2024 arising out of title suit number 195/2024. This court, taking into account the urgency shown, passed an ad interim ex parte injunction on 17/5/2024 in IAC number 1380/2024, thereby directing the parties to maintain status quo as regards possession of the suit land which have been specifically described as Schedule A to the plaintiff of title suit number 195/2024 till the next date, that is today. This court also had observed that the instant proceedings as well as the order passed herein shall not be a bar on the part of the learned trial court to proceed with the injunction application. This court further takes, while perusing the office note, it is seen that the petitioner, the appellants herein, did not take steps by way of dusty as so directed. In addition to that, the addresses which were mentioned of all the respondent numbers 1 to 6 were insufficient addresses, and as regards 1, 2, 3, 4, 5, and 6 were insufficient addresses as has been mentioned by the process server remark. Further to that, in the service of through the service so try to be meted out through usual process, it has also been shown that the addresses of the respondent number 3, 4, and 6 were also not found. Under such circumstances, this court is not inclined to further continue with the another parallel proceedings before this court. That too, when the injunction proceedings are still pending before the learned trial court, that is in Mize case number 357/2024. Accordingly, the instant proceedings stands closed. However, this court makes it clear that the interim order so passed on 17/5/2024 in IAC number 1380/2024, thereby directing the parties to maintain status quo as regards possession of the suit land, which have been specifically described in Schedule A to the plaint of title suit number 195/2024 shall continue till 8/8/2024. That is the date on which the learned trial court had fixed the injunction proceedings. With the above, the instant appeal stands disposed. The learned trial court shall adjudicate the said injunction proceedings in accordance with law without being influenced by the orders passed by this court today, as well as the order dated 17/5/2024. Appeal stands disposed. I, so and so, stands closed.
I'm deeply obliged, Your Lordship. It is 22/8, Your Lordship, not 8/8/66.
22/8. But Mr. Deori, this court is very dissatisfied with your conduct. Next time onwards, you won't get an injunction. I'm taking it for granted. This is not what you expected from a lawyer of yours. Yes.
Restoration petition, my lord. My lord, the direction had been passed, my lord, to take steps, my lord, thereafter, my lord, steps.
Where is the order?
Order is at page 17, my lord.
Oh, none appears for a further to that on the earlier occasion, none has appeared. Then why should we? Nothing out there.
The fault of the, my lord, petitioner who was before this court, my lord.
Huh?
It was not the fault of the petitioner who was before this court, my lord. The basic, my lord, petition which was filed here, my lord, the cause was, my lord, non-acceptance of the statement.
I'm not concerned.
Yes.
We are not concerned with that. We are concerned with why the council out here did not appear. Not once, not twice. They were directed to take steps, nothing doing. You couldn't have taken things for granted. Who was the council? Then, can't help it.
Well, the client should not suffer, my lord, kindly consider, my lord.
Hello, we impose cost.
My lord. My lord.
I want to suffer, that is his lookout.
Yeah, residents of Calcutta.
On request of via matters St. John, service is not complete. The
Sir,
office
give me
note
3
under
days time,
survey.
my lord. Within 3 days, I'll take steps, my lord.
Iman, you did not take steps in spite
My
of
lord,
direction
give me 3
being
days time,
given.
my lord, I'll take steps. This is my undertaking to the court, my lord.
Huh?
Kindly give me 3 days time, I'll take
steps, my lord, kindly restore it, my lord. Allow me to, my lord, press the main application, my lord.
Why? This was done recently.
My lord.
Cost? What is the suit for?
First for, my lord, a partition, my lord. Declaration of right taking interest and partition, my lord.
The written statement was not accepted.
Written statement was filed, my lord, beyond time, my lord. On the last date of 90 days, my lord, an application was filed, my lord, to accept it. It was not accepted. Thereafter, on the next date, the written statement and that, my lord, objection was also filed. But because of the earlier order, my lord, that was not taken on record, and when we came here, my lord.
Inspire a confidence. We have to issue notice.
Restoration is between the court and the, my lord.
Absolutely no. Have a right to hear other side. And they'll be picked on restoration. How can we restore without issuing notice? Tell me.
Restoration, in my humble understanding, my lord, restoration is between the court and the, my lord, applicant.
Did it happen without the dismissal? Did the other side appear? And okay, then we can leave. An application for restoration of for recalling the order dated 29/4/2024 passed by this court in CRP number IO number 427/2020, which was dismissed for non-prosecution on account of the failure on the part of the petitioner to take appropriate steps . For restoration of for recalling of the order dated dismissed for default on account of the petitioner having not appeared on 29/4/2024 when the matter was called. This court, having taken into account that taking into account the grounds stated, is of the opinion that that interest of justice could be met. Application is allowed thereby restoring the CRP IO number 427/2023. However, this court is also of the opinion that certain cost needs to be imposed. As much as the was duly informed by the order dated 1/4/2024 that the petitioner is required to take steps. Under such circumstances, this court imposes a cost of ₹11,000, which shall be deposited by the petitioner before the yes, madam. Social service?
Ashalai, my lord. Let it go to Ashalai, my lord. Say, if sent home.
Huh?
The orphanage, my lord. Ashalai. Let it to Ashalai, my lord.
Ashalai?
That is taken care of by the selection sisters here, my lord.
Ashalai?
Ashalai. It's in Chanmari.
Address?
Chanmari. Chanmari, that Krishnanagar area, my lord, just below that Holy Child School.
Anything else? Shishu Niti? Shishu Saruthi, Shishu Niti.
All the same.
Saruthi. Shishu Saruthi. I think it's office at Any- এখন list এখন বানাবো, possible all will go now. Today I could see in Allahabad High Court and all this Bombay High Court, they gave it. In one case, there was a judge who, within 5 years, could impose costs upon the litigants and deposited almost 30 crores. Let me also try to break that record.
No, my lord. Already your levels of, my lord, 1 lakh per day is causing, my lord, disturbance. Oh, my lord, kindly don't go to that level.
Yeah, Bombay High Court, they put 30 crores.
Bombay and Assam, my lord, is a far difference, my lord.
Tell more litigation. At least the বানাবো। তো কারো এন্ডক না সব money will go. All this go to these non-government. Shishu Sarathi, just find out from there the address. Shall be deposited in the before the at the Shishu Sarathi, and a receipt shall be placed before the registry within 4 days.
Can I then, my lord, replace the receipt before trial court, my lord?
No, this matter will come before this court. You want the restoration here?
Yes.
Why will you give it to the trial court? Before the registry of this court. So upon the said, the matter be listed. The revision application be listed before this court. I stand disposed.
And, my lord, that order was vacated, that my lord, order be.
That will remain. You deposit?
My lord, let it be after 1 week, my lord. People are in Calcutta, my lord, from Calcutta.
In 1 week. In 1 week. And shall, so the matter, the CRPIO shall only be listed after the deposit of the said amount, a receipt of the said amount be deposited before the registry of this. And the liberty would be given to the petitioner to mention the matter, the accompanying CRP
In the meantime, my lord, the
revision
address of the
application
CCRP will be given by them, my
upon
lord.
payment of the after deposit of the after deposit of the receipt before the registry.
My lord, they will give me the address of the CCRP.
What?
Give me the
You
address of
find it out from the internet. They are also going to find it from the internet. You also find. Yes. Yes, what is this?
My lord, the person to order it at 29.5, my lord. We have taken the steps, my lord. There is the usual as well as dusty, my lord.
Then what
And
happened?
so for the dusty is concerned, I filed the affidavit today.
Very well.
My lord, the copy of affidavit is.
Okay, Mr. Brigadier submits that the affidavit of Dusty has been filed today. The same is not on record. List the matter immediately after the summer vacation, bringing on record the said Dusty service.
My lord,
Affidavit of this.
kindly fix the date, my lord. Keeping in view urgency, my lord.
Okay, on 19th of July. 19th of July. Bringing on record the said affidavit of Dusty.
They filed the dusty affidavit.
You filed?
Yes.
Yes, then?
39 and 40, both matters they filed the dusty affidavit.
Huh?
Item 39 as well as item 40.
Okay, what is this matter about?
So this matter, my lords, pertain to pleadment, my lord. The pleadment was allowed.
Oh, yes, yes, Mr. Singh, where are you? He didn't want to argue when the matter was initially taken up. On the ground that Mr. Singh only knows I can't argue. I still remember a good friend of mine when I was a lawyer. Whenever the judge asked him, he said, I would not say anything, my senior would only say. Yes. Tell me.
There are two separate cases going on side by side between the same parties, landlord and tenant. During the continuation of the landlord filed an application saying that I have already sold the suit property during 2016, and this application was for the first time filed in the year 2020. That since I have sold out the entire suit property, I have lost interest, and purchaser, who happened to be one of the witness on behalf of the plaintiff, they have purchased and they should be brought on record as plaintiff. And in another suit where I have filed the suit, my lord, where I have prayed for repair of the tenanted premises which had got gutted down, my lord.
Who are the respondent number 2, 3, and 4?
They are the legal heirs of the original landlady.
And who is respondent number 1?
They all are legal heirs. Son, son-in-law, daughter, and granddaughter.
Nazrul Hussain is who?
Nazrul Hussain happens son of the landlady and also the power of attorney holder. Subsequently,
Who is 2, 3, and 4?
2 is son-in-law because he had married the daughter of the landlady.
And how does he have the connection with Nazrul?
Brother-in-law.
Did they give the power of attorney
They are
to
friendly.
Nazrul?
Nazrul also took power of attorney from his brother-in-law subsequently.
From Nafisa also?
Right.
Did they exhibit this document before anyway?
Yes.
That they have exhibited the power of attorney?
They submitted, my lord, before the learned trial court, and on the strength of the power of attorney, he submitted the application for substitution of the new purchaser, saying that our name needs to be struck off and the purchaser should be brought as a plaintiff in their suit. And in the suit where I am the plaintiff, my lord, he said on behalf of the defendant that my name as a defendant should be struck off and the purchaser should be brought in as a defendant. Now, our humble submission, my lord, is so far his suit is concerned, if he has no interest in his continuation of his suit, he can very well wait. But he cannot come and make an application that his name should be replaced and another set of plaintiffs should come in. So far my suit is concerned, my lord, I am the dominus litis. And there are, my lord, judgments also which says that it is the assignee who can approach the court under Order 22, Rule 10. It is up to the assignee. They may approach. But here the assignee has not approached the trial court.
Who has approached?
The seller, my lord. The original plaintiff or the original defendant, we can say. In my suit, he is the defendant, my lord, who has sold the property and who remained silent for at least 5 years, my lord, because the property was sold in 2016 and the suit is continuing. At that period of time, my lord, one CRP was before this honorable court between the same parties. They never spoke about selling of the suit property. It continued. In 2022, they made an application saying that the property has been sold out and our name should be struck off and it should be substituted by the purchasers in their own suit and in my suit also. In their suit,
they are the plaintiff.
They are the plaintiff, my lord. They had filed the suit on twin grounds that the suit property is required bona fide for their own purpose, and also there was default in payment of rental for 1 month in the year 2009. My humble submission, my lord, is that if it is bona fide requirement or default in payment of rental, can they say in 2022 that since I have sold in 2016, new plaintiff will come and he will have the same cause of action to continue with the suit? It can't be, my lord. A new purchaser under the PP Act under section 55 subsection 6 can claim rental from me, no doubt about that, from the date of purchase, but he is not coming before the court.
But the old purchaser has no interest in the suit.
Can abandon his suit, my lord. Nobody can force him.
Then what will have the impact if he abandons? The new one has to file a fresh one.
Definitely the purchaser has a right, independent right, my lord, to file a suit against me. But he has chosen to remain silent. And interesting part.
And your suit is what?
My suit, because during the pendency of the original suit filed by the landlady, my lord, the property got gutted down in a fire incident. And one part of the shop room, it survived. I made an application for repair and renovation. That is the suit.
And
it is continuing.
Now you want to execute a decree against the old one?
Against the old one, my lord, because
who has no interest?
Who has no interest? But the law is quite clear, my lord. A place before lordship.
Is the judgment?
Purandar Prasad Singh judgment, my lord. The assignee, my lord, the purchaser, he can approach the court, no doubt about that. He has a right to approach the court. And it is not that he is unknown. He purchased the property knowing full well that the litigation is continuing for two reasons I am saying, my lord. My lord, kindly come to paragraph 6 and 7 of Dhurandhar Prasad judgment. In order to appreciate the points involved, it would be necessary. I am reading para 6, my lord. Refer to the provisions of Order 22, Rule 3 and 4, whereof prescribed procedure in case of devolution of interest on the death of a party to a suit. Under these rules, if a party dies and right to sue survives, the court on an application made in that behalf is required to substitute legal representative of the deceased party for proceeding with a suit. But if such an application is not filed within the time prescribed by law, the suit shall abate so far as the deceased party is concerned. Rule 7 deals with the case of creation of an interest in a husband on marriage, and Rule 8 deals with the case of assignment on the insolvency of a plaintiff. Rule 10 provides for cases of assignment, creation, and devolution of interest during the pendency of a suit other than those referred to in the foregoing rules, and is based on the principle that the trial of a suit cannot be brought to an end merely because the interest of a party in the subject matter of suit is devolved upon another during its pendency. But such a suit may be continued with the leave of the court by or against the person upon whom such interest has devolved. But if no such a step is taken, the suit may be continued with the original party, and the person upon whom the interest has devolved will be bound by and can have the benefit of the decree, as the case may be, unless it is shown in a properly constituted proceeding that the original party, being no longer interested in the proceeding.
But Mr. Singh, if tomorrow,
my lord,
can you execute a decree against that person?
Yes.
Because here is not a case of a sale, the suit property being the title of a suit property coming into.
But he knows, my lord, about the pendency of the suit for two reasons. I am
so what is the problem in bringing him there? In
my
the
lord,
suit?
kindly come to para 7. I think the answer in this judgment or in other connected judgment will be made, Your Honor. Under Rule 10 of Order 22 of the court, when there has been a devolution of interest during the pendency of a suit, the suit may, by leave of the court, be continued by or against person upon whom such interest has devolved, and this entitles the person who has acquired an interest in the subject matter of the litigation by an assignment or creation or devolution of the interest pendent light or suit or any other person interested to apply to the court for leave to continue the suit. So assignee can approach the court for a leave, my lord. But it does not follow that it is obligatory upon them to do so. If a party does not ask for leave, he takes the obvious risk that the suit may not be properly conducted by the plaintiff on record. So far assignee is concerned, my lord. And yet, as pointed out by their lordship of Judicial Committee so-and-so, he will be bound by the result of the litigation even though he is not represented at the hearing, unless it is shown that the litigation was not properly conducted by the original party or he colluded with the adversary. It is also plain that if the person who has acquired an interest by devolution obtains leave to carry on the suit. I pause for a moment, madam. In my case, the person who has purchased the property, he adduced evidence on behalf of the plaintiff as PW2. So he was knowing very well about the pendency of the suit. Moreover, my lord,
understood. They filed an application to bring on record them. So what is the
not by
wrong?
the assignee, my lord.
So what?
But
now they want to bring to the notice of the court that look here, now we have already sold, we are the people whom we have served. It is for the court, you see the words out there, the court may, it's not only them, the court may also proceed. Be continued, by leave of the court, be continued by or against person upon whom the interest have devolved. So it may proceed because Order 22, Rule 10, the strict rigors out there, which is there in the Order 22, Rule 3 and 4, is dispensed with.
That is not.
So it would be tomorrow, if you want to get the decree executed, here for you to get the decree executed against him. You may, if he is made a party out there, you can very well point out that there is no bona fide relief. There cannot be a bona fide. You may have a very good ground. How does it matter?
That is made, my lord, that may apply to my suit, but that cannot apply to the other suit where the plaintiff says that I should be replaced by a new set of plaintiff. Can he say so under what law? Because assignee can definitely come and say that the person has sold out the property to me. He is no longer interested, or even if he is continuing, I shall also join as a plaintiff.
Okay.
That is fine, my lord.
Just for example, otherwise the suit becomes useless. He may not be interested.
Oh, my lord, the apex court clarifies the suit doesn't become useless, my lord, at this moment of time. It is my choice. Since I am the dominus litis, I can impede them, substitute them. But since he knows very well, my lord, kindly look at the conduct since 2016. The seller knows that he has sold out. The purchaser knows that he has purchased. All are remaining silent. In 2022,
how about passing an order to the effect interfering with this and thereby giving the liberty to the assignee to approach and upon approach the court shall be at make them the plaintiff.
my lord, he doesn't need any leave. He
No,
has the
if I
option, my
give
lord.
it,
He has the option.
Mr.
why
Mr.
we-
saying we are in 227.
My lord.
27 one can do.
My lord, kindly look at
At the end of the day, it will be the same. He may not be interested, that is why.
I have no objection to that, my lord. But how can he dictate terms to me and say that you...
But tomorrow, if his suit is dismissed,
His suit, my lord.
his suit is dismissed, it's good, all in your favor if he's not interested.
I
You
have
still
no-
have the ground that there cannot be a bona fide requirement. Because his bona fide requirement and his bona fide requirement will be different.
Cannot be
There are
the
many
same.
judgments.
Cannot be the same. Or moreover, he cannot ask for
So the
default,
bona
my-
fide requirement will be different. Now, as regards that, default also would not come in. So you will have all these grounds to be taken.
my
How
lord,
does it matter?
Why to carry forward a useless suit on imposed upon me? If the plaintiff is interested, so far he has shown interest, my lord, he can continue. But my lord, am I saying more when I say that where from he can come and say that you replace my name by his name?
He is only bringing to the attention of the court that look here, I have already sold this property to him. Now he is the owner. He's bringing into the attention of the court. Now, what is the duty of the court?
My lord, then the court will also look into the fact that 2016 onwards there has been 2 CRP. This plaintiff never bothered.
That is immaterial. That is immaterial.
Can we look at the other judgment, my lord? And look at the other judgment, what it says, my lord. For 2015 judgment, my lord, where Dhurandhar Prasad Singh has been referred to and relied upon.
Yes.
I read para 6, my lord. Their reading of the provisions of Order 22, Rule 10 makes it clear that the legislature has not envisaged the penalty of dismissal of the suit or appeal on account of failure of the assignee to move an application for impleadment and to continue the proceeding. Thus, there cannot be dismissal of the suit or appeal. I'm reading para 6, my lord. On account of failure of assignee to file an application to continue the proceeding, it would be open to the assigner to continue the proceeding, notwithstanding the fact that he ceased to have any interest in the subject matter of dispute. He can continue the proceeding for the benefit of the assignee. Para 6, my lord.
We'll do one thing.
One more judgment before your lordship.
So, Mr. Singh, we'll do one thing. We'll have it after the vacations. We'll deem the service upon the year on the basis to be complete. And then we will have it on immediately on the vacations. Let us see. Yes, yes. In both the cases, you have filed the service, na? You got a beleg order. Pursuant to the order passed by this court on 13/5/2020, the petitioners herein have effected service by way of dusty. The service, however, to registered and usual is yet to be completed. Either as it may, taking into account the affidavit of service, this court deems that the service upon the respondent number 1, 2, 3, and 4, the instant proceedings to be. This court fixes this matter again on when? August 2024. On the said date, if the respondents are not represented, the instant proceedings shall proceed in their absence. I said, if they don't appear, we'll proceed.
The next date, otherwise, matter is fixed on 24th.
What?
Learned file, submission of copy of the order. Trial court is also, what order is passed.
The learned trial court, the counsel appearing on behalf of the petitioner shall duly apprise the learned trial court about the pendency of the instant proceedings.
Public.
But I am the respondent, my lord, in RSA, and my lord filed a, I am, my lord, praying for my lord injunction, because my lord, after my lord filing the, my lord, RSA, the sole respondent, my lord.
You are the?
Started, my lord.
You are who? Respondent or appellant?
My lord, I am the respondent. I won the case in the lower appellate court, my lord, with the degree. Other side, my lord, prefer RSA. And having lost, my lord, they, my lord, they started, my lord, filling up the land, my lord. And now, my lord, after filing this, I started erecting, my lord, RCC pillar.
You are the plaintiff.
Yes, my lord.
You won the suit.
My lord.
Appeal was dismissed.
Earlier it was dismissed, but appellate court allow my decree. Appellate court, my lord, appellate court, my lord, allow.
So your suit has been decreed. Now again, he is there in possession.
My lord, he is in a possession and he come in appeal.
What is he constructing?
My lord, and now RCC pillar, my lord, erecting.
Huh?
RCC pillar erecting, my lord. Photocopy I could not get because my lord, this I am, my lord, remain left to I twice a price, my lord, because my lord, in paucity of time. That's why, my lord, although I filed my lord on 6/5, my lord. In paragraph 8 and 9, my lord, I have stated, my lord. Paragraph 8 and 9.
Why? Why are you filling out?
Oh, my lord, here, my lord, the first thing, I have not received the copy of the IA as well. And secondly, my lord, very interestingly, my signature has been obtained in the notice. It is not my signature, my lord. Lordship, kindly have a look, my lord, at notice, my lord. And if this process is going on, my lord, we will.
Anyway, we will not go into those trivial aspects now for the time being. You give a copy. Then we issue notice. Let him file a reply.
But that is his, my lord, because my lord,
He is going to fill up the earth.
no, not that all, my lord.
Your allegation is that he is trying to fill up the earth.
He is filling up, my lord, and now my lord erecting RCC pillars.
That is not a part of your petition.
Exactly. My lord, RCC pillar, I have not stated because my lord, after filing this, my lord, because
So under such circumstances, let him fill up the earth, make it more better. It is a highland or it is low lying.
Low lying.
So it is very good when you win the land. He shall not claim any equity. Don't worry. Okay, we'll issue notice. Notice this is an application under Order 39, Rule 1 and 2, the Code of Civil Procedure for grant of an injunction, thereby directing the restraining the opposite party from constructing any structure on the suit land till the disposal of the connected second appeal. Connected second appeal has been admitted.
Yes. On 26 February.
Issue notice upon the respondent, upon the opposite party. The beach tree accepts notice on behalf of the opposite party. A copy of the instant application be served upon him by Friday. Friday, give the date. The opposite party shall be at liberty to file reply to the instant application. List the application for further consideration. 19th of July 2024. Stop. You lost before the trial court, first appellate court.
No, but in the
appellate court, I
Munsif, my
won.
lord, before the Munsif, their suit was dismissed.
No, we are not concerned. First appellate court, you
Yes.
lost.
I lost.
The appeal has been admitted.
Yes.
So you don't construct anything.
Lordship.
Don't construct.
Here, my lord,
You have already suffered a decree, Mr. Shetty. Don't construct.
no,
Till
my
the
lord,
next date.
that part I do not know, my lord, whether his allegation is true or
But
false.
therefore, I am saying, till the next date, the parties herein shall maintain status quo as regards construction. It shall maintain status quo as regards construction, as well as filling up of the earth. In respect to the suit land, so described in the plaint of the suit.
But my lord, I do not know. That is why, my lord, simply they are making the
Therefore, I am
allegation.
saying status quo. Because you have already suffered a decree, you are on appeal. So any construction, if it is being made, it would not look proper. On one hand, this court have admitted the appeal, and you are on the other hand constructing with impunity.
Unless I filed the reply, my lord, I cannot say, my lord. And I telephonically took the information, my lord. They say no, only that part which was broken by the storm, my lord, recently it was happened. That has been constructed. That's all.
So that you have the
That
storm
broken part, my
storm is long over in the month of May.
now it is not there, my lord.
So it's okay till the next day.
Yes.
This is within time, first new application.
No, my lord. My lord, I pray for an adjournment, my lord. Mr. A.
Why?
Is to appear in this matter.
Huh?
Sir is to appear in this matter, my lord.
Hello. The counsel appearing on behalf of the applicant seeks for an accommodation matter to be adjourned to be listed after the vacations. The order is written. Full hawk. You appear? There's some mistake. The
Yes,
direction
there's
being
some
given.
mistake. Actually, at that moment, point of time, Lordship, it was disbursed by the Assam implementation of Assam Accord Department. Right now, what is the position? I don't know that actually. Actually,
T.R.
not.
Gogoi.
T.R. Gogoi.
Mr. T.R. Gogoi appears on behalf of the government of Assam and seeks some accommodation for obtaining instructions. List the matter again on 22nd of July 2024. Full stop. In the meanwhile, Mr. T.R. Gogoi shall obtain the necessary instructions by the appropriate authority whom the directions ought to have been passed.
Possibly.
Yes, Mr. Mahmood, what are you doing? This is the last of the matters. Who fixed the matter for hearing?
Court 10, Lordship. Court 10.
Huh?
Court number 10.
Oh, no, there, court today. I don't fix matters for hearing. By this court.
None of the courts are kept.
Okay, this is what?
This is for my lord, delay condonation for substitution.
No,
First
time.
my lord,
Lordship, in this case, what happened, Lordship?
All this, issue notice.
3 persons died and only 5 applications are filed, Lordship. And moreover, Lordship, appellant number 3, substitution application for appellant number 3 filed. And before that, wakalatnama for
Anyway, let the notice be issued. You are appealing for all.
For respondents, Lordship, all respondents.
Issue notice. Miss So-and-so accepts notice on behalf of all the respondents.
Died, Lordship. 1 respondent died.
You are appearing for whom?
Other respondent, except Lordship, that respondent number 1.
No.
1 died.
Are you appearing for the
Earlier, I was appearing, Lordship.
Now, are
Now,
you appearing for the newly substituted one? No.
after substitution only I can appear, Lordship.
That is where notice has to go.
Lordship.
The case is notice. Issue notice returnable on after 4 weeks. Steps be taken by way of registered as well as usual. Full stop. Miss R. Chaudhary appears on behalf of
Respondent number 2 to all respondents, Lordship.
2
All
to how many?
principal, Lordship. 2 A to 2G 3, 4, 5, 6, 7.
Appears on behalf of the respondent numbers 2 to 7.
2A to 2G, Lordship.
All respondents except
Lordship.
all opposite parties except opposite party numbers. Substitution is done. How many are there?
No. After tomorrow is legal heirs.
One. How many legal heirs are there?
my lord, 3.
So 1A, 1B, 1C it would be.
Lordship, whether your Lordship will issue notice in these applications is because, Lordship, the applicants are not the legal heirs, Lordship. Other appellants file these applications for implement or substitution of some of the appellants, Lordship, without any wakalatnama.
List the matter on Monday, Wednesday. And liberty is given to the parties to mention the matter for. And list the matter on Wednesday. Next give you on 24, 26/6/2024 at 2 p.m.
May I pray, my lord, on 27 or 28, 26 of election.
What?
Day of our by-election, my lord, 20.
What are you going to do with the by-election? Stop all this election business with you.
My lord, I am one of the.
Don't.
My lord.
Ask anybody else.
Except 26, my lord, I need.
No.
27,
26. You don't need to contest. Don't contest in elections. Stop contest.
Or 27.
No. You are contesting for president. And furthermore, you should not.
Or 27.
No. Okay. Rakamgura. List the matter after the vacations.
Obliged.
Yes, Mr. Mahmood. I don't take up hearing in this manner.
On Thursday, my lord.
Absolutely no. Tomorrow. No. This can't happen like this. 46, 47, 48. I'll do one thing. Not before me. Let it go to court number 10.
Right.
They mentioned the matters.
What
Na?
is the reason?
You mentioned the matter before them. How did the matters come up today?
Heard by the court number 10, part heard, Lordship.
Which one?
But item number 46 and 47, Lordship.
Part heard.
Part heard, but it is not written as part heard. The court wanted to complete the hearing today itself.
Okay, it has been brought to the notice of the.
Oh, well,
Recorded
part
Lordship.
hard, how it,
As it is not reflected
Not
as part
part heard,
heard, so
not
it
part.
cannot be recorded, Lordship.
Huh?
Otherwise, recorded, Lordship. As
No,
it is
I won't record in that manner. It has been submitted at the bar that item number, that RSA number 132 of 2018. Both are connected.
separate, Lordship. Councils are also different.
That a बेलेग होता है. What is the order written? Last order written? The order लिखी थी सबसे पहले की. 47.
many times some
13.6, it will remain.
arguments are hard, but unless it is recorded as part hard, why you should treat it like part hard?
On request.
13.6, Lordship, left over. Before that, 11.6.
Okay, we will have these matters. I can't fix it now. We'll have it there because I am taking the roster. With this order, I can't help you.
After vacation, Lordship.
These matters be listed by the put it the beleg order. The instant second appeal be listed for hearing immediately after the summer recess.
That may can be fixed. That may be fixed.
Eta dibo, first to dibo 6th of August. Second to dibo 8th of August. The third to dibo the unlucky 13th of August.
Our lands are under their occupation since long. Only consider this.
These are very new matters.
Hello?
These are very new matters.
No. It is since Gualpara it is coming. By title suit, then first appeal, then second appeal.
Yes.
Actually, in first appeal, my lord, by title suit, we won the case. Only possession was not given. Landed district has said, you have declared the right title in interest of the party. Then why possession is not given? District has gave possession, only possession. Then against that they have come.
Liberty is given the parties to lend at the power grading.
Before that point.
Huh?
Before that day.
That order will be there. It's on so and so. Liberty is given to the part. Mention the matter for appeal.
July, long time.
Whoever wants.
We are enjoying the fruits of my land.
So you want to mention it, you can very well mention it for upgrading on that day. You don't want it, okay. Remove that.
I only want a short that may be fixed. This is my only prayer.
Do you want to come during the summer holidays? I'm free.
That means,
Is holidays?
vacation.
Vacation.
Yes, I have no objection if my learned friend agrees.
And then I'll ask the Chief Justice. A bench is to be given. You want it in the vacation court? Vacation court is there. No?
Definitely there.
You want to do it in the vacation court?
But my learned friend subject because nobody can complain her to come on the same holiday unless she agrees.
Okay.
I
Yes.
filed an IA lawsuit for vacating the interim order because we are the selected candidates and due to the
Next
interim
week.
order.
Next
Friday lawsuit,
Next week.
on Monday lawsuit.
What is the nature of the interim order?
We are the selected candidates. Due to interim order passed by this honorable court, our appointment.
Why was the interim order passed?
Interim order
Ground?
was passed on
No, what was the ground?
ground that select list was valid up to 1 year. That is the.
What is the mistake?
No, there is lawsuit.
Next week.
It is on Monday lawsuit. Lawsuit.
Lordship, one pension matter, your Lordship has fixed it on Friday. I file another petition pertaining to the recovery purpose. Obliged.
Listing matters, please give it to him. No problem. Apni cycle next week. Yes.
I recommend item number 66 supplementary list, my lord.
60?
66, my lord. 66. Concerned advocate Mr. N. Hawk, my lord, will be out of station, my lord. Example matter for the day, my lord.
What was the issue here?
I am concerned advocate, my lord, that is right.
Non-payment of salary, I suppose. Who is SR Borvian?
N. Hawk, my lord.
N. Hawk. On a prayer made on behalf of Mr. N. Hawk, comma, who is stated to be out of station today, comma. I'll raise you to list this matter again next week.
Next. Obliged.
May I please, Your Lordship? I beg to mention item number 9, Lordship. Lordship, matter may kindly be taken after vacation.
9 to 5. Wait for it. Better to be called up.
Another item to mention, item number 37, Lordship.
What is left here?
Lordship, I am not the concerned advocate.
Whoever the concerned advocate is, let him come. We will see. Admission into Agriculture University. Let him come. We'll see. Call him.
May I please, Your Lordship? I like to mention item number 18, Lordship. 1H, Lordship. Motion matter.
1-8.
Lordship. Maybe as on.
No adjournment. No adjournment.
May I please, Your Lordship? With the consent from the other side, I beg to mention item number 54 and 55. As my senior, Mr. S.K. Mehdi is out of station.
Have you taken the consent of the other side?
Yes, I have submitted adjournment slip also. Yes.
Oh, yesterday you submitted. On the prayer made on behalf of Mr. S.K. Medil and counsel for the petitioner, who is stated to be out of station, registry to list this matters after 4 weeks on a date to be fixed by it. On a date fixed by it.
Well, in item number 20, in para number 2, I have the typographical mistake. May I correct now, Your Lordship?
Let it reach. Let it reach. Let it reach. We'll see. Yes, Mr. Ajay.
Please, Your Lordship. Okay, I beg to mention for listing of a motion matter on Friday. One another matter for next week, admission matter this one. Obviously.
Today's daily course list, top of the list, item 4.
Wait, the list is over. Yes, anything? Anything? Nothing.
That 26 only we got. And irrespective of fact finding by the authorities, we got. I ought to have get an opportunity.
Okay, that's the only thing. Anything more? You were already under mercy. Clerk to GD.
Yes. Rifleman. That was different chapter. Now
Continuing chapter. Dispose of.
No. Not I was transferred to.
Sorry.
Not because of.
Mr. Sorry, Sao. And that too after 10 years would be difficult. Sorry.
Item 5.
May it please your Lordship. Lordship, in this matter, the petitioner seeking for pay priority Lordship, stepping up of his basic pay as to the respondent number 8.
Who is appearing for the respondents here? PWD. Get a PWD standing counsel and then inform him. We'll take up the matter. Okay.
Supplementary course list, item 61, 62. Top of the list.
GLT pump again. GLT pump 2011 4 GLT pump. 11 4 GLT.
Wait, please, Lordship. Lordship, I'm appearing in this matter, Lordship. In this matter, the Standing Counsel, General Administration Department is supposed to be there because we are representing the Archives Department. But what has happened, my lord, is that
I'm not here. I'm hearing the matter. If you are not there, we will draw adverse presumption.
Our name also.
2012 matters, we are not adjourning.
My lord, it's true, my lord. My lord, will give us some time because my
We need not give you time. You have filed your affidavit. We have read it. Only a clarification is required. Let them place that clarification. We will pass orders. 2012 matters. I'm sorry, Mr.
But my lord, we have been.
I can give you time till 2 o'clock. If you have to receive some instruction, get it.
Then I leave it to your lordship.
You leave it to me. 2012. Why was this prayer not made yesterday? If you had difficulty, why was it not made yesterday?
My lord, yesterday, my lord,
We had heard this matter yesterday. Why was this prayer not
problem
made?
was that, my lord, the name, if your lordship checks the list.
No, forget it. What is your problem today?
My lord, we just got the file today, my lord. So
You got the file today.
just now we got it.
Only that much.
My lord, because you have to.
Only that much. Nothing more.
You have to get instructions.
Yesterday, I passed an order. I wanted certain documents. I want that today. Mr. Soikia had appeared for Director of Archives, and I had directed specifically
My lord, P.
Soikia that the document should be produced before me or your director is coming. Because there is a very serious allegation level that the earlier interim orders, passing of the earlier interim orders, were communicated to the advocate who had appeared in Mr. Sharma's client's case. But the advocate did not place it before the court. And the statement of the advocate as recorded in the order is that she was never given any information. So I wanted those documents.
The issue is, my lord, that we also have newly come.
I don't know.
We are not the government advocate.
Whoever is your director, you know your director?
Now we know, my lord, because
You
we have
know
paid
your
about it.
director?
Now we know, my lord.
You know your director? Try to get that document or ask him to come here at 2. Mr. Chaudhary, you are appearing for? Oh, I'm sorry. This nature, because if you see the affidavits filed in the matter, categorical statement, because see, there was a stay order operating.
Yes.
That was not brought to the notice of this court. And this court proceeded to direct, I think, he is representing one of those, you are with both, a direction to appoint them. Is it not a fraud on this court? And the allegation of the director is that we had given all these documents to the government advocate. And the government advocate's statement is, I have not been posted with 2-3 dates were given by this court. We'll have to remedy that situation.
Not submitted on that.
We'll have to remedy that situation. Mr. Fukan, Mr. Chaudhary, you are here today?
Yes.
2 o'clock. You get that documents. Or if your documents are not there, I want your director here or a competent officer of that with the records here at 2 o'clock. This we will not tolerate, Mr. Fukan. This is not done. I only want the documents. No. The documents. Yesterday I passed an order. Mr. Soikia, he is vanished today. Why?
I am not the government advocate, my lord. We have just been informed that the Directorate of Archives is in this matter. So we have been
whoever is there, yesterday somebody had represented him. We passed an order. You go through that order. and get those documents. I'm giving you time till 2 o'clock.
Right.
Or we do it like this, Mr. We'll not put him to trouble. We'll have it tomorrow. But if I don't get the documents, you'll be in trouble. Your directorate is in trouble. Maybe I may not be in a position to now dislodge them, but heavy exemplary cost I'll impose.
Tomorrow then.
Tomorrow morning. First item. First item tomorrow. But if I don't come up with a plea that you have not been able to contact the director, it is directed that file to Dixon. Next. This court had fixed the matter today and had required Mr. P. Soikya, learned counsel appearing in the matter, to produce the documents annexed as Annexure 9, 10, and 11 to the order to put go. Pune Lucian Society order to Jogali. It has not even been recorded. You are safe. Mr. A. Fukan, learned counsel, appearing for the Director of Archives, shall produce the communications, originals of the communications available at Annexure 9, 10, and 11 to the affidavit filed in the matter by the said by the Commissioner, Lower Assam Division, in WPC number 1076/2015. Also, they said communications were issued by the Director of Archives No. Communications dated Annexure Roman 12, Roman 13, Roman 14, and Roman 15. Which were issued by the Director of Archives to the Junior Government Advocate Assam, appearing in the matter in WPC number 6148/2012. Also, the originals of the said communication, along with having the endorsement of the receipt of the same by the Office of the Senior Government Advocate Assam, shall be placed before this court positively tomorrow. That is 26, 2024. Also, in the event the said communications are not being in a position to be produced, the Director of Archives shall appear in person before this court at 10:30 to answer to the queries of the court, along with the records as maintained in the office in connection with the proceedings involved.
Lordship, tomorrow at 2 p.m.
10:30. Yes, Mr. Soikya, what happened? You were supposed to bring those documents?
My lord.
What happened?
Here, P. Nayok supposed to be appear, my lord. He will represent for the department, my lord.
Then why did you appear yesterday?
My lord, earlier government appeared, my lord, subsequently that given to the standing council.
We'll see tomorrow.
My lord, at 2 p.m., my lord, I'll get my instructions by 2 p.m. tomorrow.
We want it at 10:30.
Yeah.
First item. Kali, first item.
Delhi Coast List, motion item 6.
Heard Mr. M.K. Chaudhary, assisted by Mr. B. Sharma, learned counsel for the petitioners. Issue notice, returnable 4 weeks. Petitioner to take steps for service of notice upon the respondents by way of registered post with AD files. Steps within 3 working days from today. Also, register to list this matter after 4 weeks, along with a report with regard to the status of service of notice upon the respondents.
Make please, Lordship. Lordship, in the previous case, can I get a copy of the order, my lord?
No.
So I can send it.
You download it.
Item 7.
माइक ने उठा दिया है तो उठा दिया क्या माइक अपलोड कोई है तो
Wait, please, my lord. Well, it starts at page, order starts at page 7. Apparently, for Lordship will find it page 13.
Okay.
Last
Heard
paragraph.
Mr. Chi Chakraborty, learned counsel for the petitioner. Issue notice, okay? Step sole respondent.
Item 8.
Yes, Mr.
Page 11, Lordship. Order.
You are in the nick of time,
Yes, Lordship.
just on the brink. Heard Mr. S. Nath, learned counsel for the petitioner, issue notice, returnable 4 weeks. Sole response.
Obliged.
You are
Item 9.
appearing.
Item 9.
Yes. Mr. Sisti,
Yes.
have you received?
Yes, I have received the instruction. Hey,
Please.
Palan, in that way.
What is there, Mr. Sisti?
Yes, the date is 9/11/2023. Lordship may kindly peruse this. Hey, what a mail question. Thank you. No.
Yes, what happened? Nothing is clear.
And this is the report from the Lordship District Elementary Education Officer, Lordship.
Hmm.
He has verified the record, the website of that SSL Lordships, and it was found that
there is no date in the details from the portal.
Yes.
You can have this video. Hard copy 9/11, no problem.
Yes, Lordship. And in the website also it is 9/11.
Where do I get it?
No. last page of the instruction of the DO lordship.
9/11.
Yes.
Yes, Mr. Counsel. What is this? Playing with your daughter?
Yes, my lord.
You're playing with your daughter.
No, he's not understanding. Actually, my lord.
You want to be a president by projecting your daughter?
No, my lord, that was
By
not
resorting to
my
falsehood with your daughter?
That
I have
was
the
not-
data now.
But my lord.
Give him a copy, mister.
Yes.
Give him a copy.
Yes. Yes, I am.
So you contend that on 8/11/2023,
My lord.
a meeting of the school authorities was held and you were nominated as the president.
My lord.
So the basic requirement is that your daughter should be studying there, son
My-
should be studying there.
My-
You said your son or daughter is studying from 1/11,
My lord.
right?
My lord.
But the data we have now shows
My lord.
that the admissions were on 9/11. Why this falsehood?
But online, my lord.
Online is with me. 9/11. Online 1/11 cannot be 9/11 admission. It should be 9/11 only. It is with me. Give it to him. Admission date. You come
My
to the
lord.
last
My
page.
lord. My lord.
9/11. In your 4.2.2, you have shown as 1/11/23.
My lord.
We are asking for a investigation by the CID into the matter.
Yes, sir. My lord. Yes. My lord.
Mr.
So in
Counsel,
my online copy,
I
my
don't
lord.
want to put your daughter into trouble. Small kid.
My lord, as far as
Your political ambitions,
My lord.
she will be the sacrificial
I
gift.
also, my lord, obtained from my lord online, my lord. That, my lord, shows my lord.
How come they are showing it
So it
as
should be, my lord.
you go
If I-
verify it, come back tomorrow.
My lord.
Verify it and come back tomorrow.
My lord.
I'm otherwise imposing exemplary costing,
My lord.
not less than
It should be
50,000.
then,
Mr. Counsel, not less than 50,000.
my lord. As per instruction, my lord, this. was
Whoever it
supplied
is,
for-
now the government has brought it.
My lord.
You check up, let
I-
me know.
It was also supplied by the client, my lord. With online copy.
That's why he'll pay 50,000.
My lord.
Kali.
Yes.
On the prayer of the learned counsel for the petitioner, lives this matter again tomorrow.
My lord, Friday, my lord, Friday, my lord.
Tomorrow.
Yes.
Item 10.
May I please your lordship? Lordship, director has written a letter to the DEO, my lord, for taking necessary steps with the district commissioner concerned for compliance of the instruction laid down in the aforesaid honorable court's order. In this connection, it is mentioned here that here is the
What is it?
my lord, kindly some time may be allowed, my lord.
Yes.
She has written a letter to the DEO for taking necessary action, my lord.
Madam, the case of the petitioner is already recommended by the DLC.
My lord.
This court had required the director, the deputy commissioner to look into it. He looked into it. He has also come up with a
Please
plea.
pass the order.
No, he has also found the petitioner to be teaching the subject social studies. So why are you not taking the matter forward? SLC, government, finish it out.
Kindly some time may be allowed.
Why? Why? Why do you want that time? Because I had clearly said two things. Why the deputy commissioner did it, we forget that. We say why the case of the petitioner for provincialization of their service.
Scrutiny committee.
District level scrutiny committee already done. Done with. Matter comes up before this court. This court for some reason says deputy commissioner look into it. Deputy commissioner looks into it, comes to the claim that Anwar Hussain has a better claim. Right? Now the matter has to be taken up by the state level scrutiny committee. Why is the matter not being placed before the state level scrutiny committee? Can you have that instructions?
No.
No. Can you get that instructions? Not today. We'll not trouble you in every case. Don't worry. Which case can wait? We'll wait. Monday. On the prayer of the Learned Council for the parties, list this matter again on Monday. On the next date of listing, Mr. N. Fukan, Learned Standing Council Elementary Education Department would receive instructions as to why the case of the petitioners have not been placed before the state level scrutiny committee, as it is projected in the petition that the district level scrutiny committee had already recommended their names for provincialization against the subjects indicated therein. Also, list Monday.
Please, Your Lordship. Lordship, matter pertains to my lord, there is some private respondent has been approved for the post of my lord headmaster, my lord, page 47 and 48, my lord. Well, there are a series of matters, my lord. I am directed to implique the private respondent in this case, my lord.
Heard Mr. S. Hajorika, Learned Counsel for the petitioner. Also heard Mr. U. Sharma, Learned Counsel, representing the respondents number?
Respondent number one.
Yes. Who appears for BTC? Mr. Chaudhary
S. Bora.
S. Bora. Mr. S. Bora, Learned Standing Council, BTC appears for the heard Mr. So-and-so, heard Mr. U. Sharma, Learned Standing Council, Secondary Education Department, and Mr. S. Bora, Learned Standing Council, Bodoland Territorial Council. Issue notice, returnable 4 weeks. Also, Mr. U. Sharma, Learned Standing Council, Secondary Education Department, accepts notice on behalf of the respondent number one. While Mr. S. Bora, Learned Standing Council, BTC, accepts notice on behalf of the respondent number 2, 3, 4, and 5. Also, no formal notice is required to be issued. However, petitioner to hand over requisite extra copies of the writ petition to the Learned Council for the respondents. Petitioner to take steps for service of notice upon the respondents number 6 to 88 by way of registered post with AD. Steps within 3 working days from today.
Date may be fixed after vacation, madam.
4 weeks, you completely will come back.
Obligation.
May I please, Your Lordship? If Your Lordship, the petitioner is being aggrieved, Your Lordship, by the action of the authorities, Your Lordship, not allowing them to, Your Lordship, log in to upload their institutions, Your Lordship, in Dorpan portal, Your Lordship. Now, Your Lordship, what has happened, if Your Lordship may kindly come to page 71, Your Lordship. Earlier round of litigation, Your Lordship. Their schools are also eligible, Your Lordship, but has not been provincialized, Your Lordship. On the ground that, Your Lordship, there is DICE data is not available in their data is not available in dashboard, Your Lordship.
All these teachers belong to one school or different schools?
No. Now, Your Lordship, one school, Your Lordship, the present petitioners. But the
5 writ petitioners, 1 school.
Lordship, one school. Now, what has happened, Your Lordship? There is a direction by this honorable court, Your Lordship, Your Lordship will kindly come to page 99 of my writ petition, Your Lordship.
That is with regard to provincialization of your services.
Now they are not doing it, Your Lordship.
That is for the government.
The government is,
Now,
the matter is
what
now,
is the matter with the council?
now council, Your Lordship, come up with the, that we are, Your Lordship, they are specific.
There is three categories there.
Lordship.
Government, provincialized, private.
Lordship.
If you don't
Now
fall
they
in
say-
provincialized, you will fall in private.
Lordship.
What is the harm?
No, Your Lordship, they says it, Your Lordship. Your Lordship may kindly come to para 3 of their affidavit, Your Lordship.
When did they file that affidavit?
We have received
12/6,
copy, Your Lordship, on 12/6, Your Lordship.
That affidavit is not on record.
But that affidavit, Your Lordship says, Your Lordship, that affidavit is, will be important.
Yes, Mr. Surya, what is the problem?
No, problem is there, my lord. They have not taken any permission either from the council or from the, my lord, the DSC. So that's why board had.
Means you mean to say when they set up the school, there was no permission from the council?
Yes, my lord, for hotel to include their, my lord, in Dorpon. Dorpon, there is a provision, my lord.
Forget them as a provincialized school, but they should be there at least as a private school.
No, my lord, finance maybe, my lord, without any permission, but that should be.
Permission is to be given by you, Mr. Council.
Oh, that's why they don't apply. Lordship Kalisi, our Lordship Kalisi, our affidavit. We
have a copy.
Our affidavit.
Extra copy.
Para 3, Your Lordship may kindly go through.
Lordship may go through my affidavit, my lord.
This is Kasari Mahal HS school, right?
Lord.
What is this prior permission
Permission
from the prior established the school?
Also establish the school and also open the classes like that, my lord, class 8.
That government permission.
Not permission, my lord.
Then?
We have informed them, my lord, our affidavit page 116, 114, continuous frame, page, my lord, 114. We informed twice, but they did not turn down. 14 June 2022, principal head of the institution, all the registered institutions at Dorpon portal, how they will have to have the permission. They will have to take permission from the DHE also, Director of Elementary Education also, my lord, and also from council.
Yes, Mr. Vodakar, what is this?
Which one, Your Lordship?
What is this permission? Permission for Darpan.
Lordship, so far as the permission from the government is concerned to establish that, I have annexed, Your Lordship. That's at page.
That is there.
That is there, Your Lordship.
Then
Your Lordship, we have, Your Lordship, applied. If Your Lordship comes to my petition.
103.
3, Your Lordship. That's we have submitted, Your Lordship, to the state Assam Higher Secondary Education Council.
But you submitted it only in April.
Lordship.
But they wanted it much back. What is the date of this application?
This is, Your Lordship, 9/4. 29/4, Your Lordship.
So that is after the window was opened. Window was opened from 8/4 to 19/4.
Lordship.
Then why this on 29/4 you make this application? And this admission year is also gone now.
Lordship.
Period. We'll consider.
Lordship may take it up, Your Lordship, next week, Your Lordship. In the meanwhile, Your Lordship, we will file an affidavit, Your Lordship.
Reply.
Lordship.
It is stated at the that the Assam Higher Secondary Education Council has filed an affidavit in the matter on 12/6/2024. Full stop. The same is not tagged to the records of the case. Full stop. Registry to list this matter again next week on 27/6/2024, along with the said affidavit stated to have been filed by the respondent number
3 and 4, my lord.
Respondents number 3 and 4. Also, petitioner is at liberty to bring on record a rejoinder to the said affidavit, if so advised.
In fact, your lordship, this year's admission is actually over.
Over.
Only thing, your lordship, another round of admission will be taken place, your lordship, after
And
compartmental
see, you
results
don't
are-
have a permission for second year.
Lords.
Then,
No, in the second, another round.
so how have you been operating this school till today?
No, the second year students are there, your lordship.
But you have a permission for first year only, as per that application.
No, your lordship, so far as the this year concerned, and last year we have, your lordship, through Zarpon, your lordship, admissions were there, your lordship.
Done.
Till last year, your lordship.
Bring that on record.
Yes, your lordship. I have annexed, your lordship, that
Okay.
also. Deeply online.
Item 13.
Obliged, my lord.
Yes.
I have received instruction from the Inspector of Schools, madam.
You want to file an affidavit?
Yes, madam.
Mr. N.J. Khatonia, Learned Counsel appearing for the Learned Standing Counsel appearing for the Secondary Education Department submits that the instructions in the matter has been all furnished to him, and accordingly he prays that he be given 2 weeks' time to bring on record the stand of the said respondents by way of filing an affidavit. Also, registry to list this matter immediately after the ensuing vacations. Also, it is expected that before the next date of listing, the respondents in the Secondary Education Department shall bring their stand on record by way of filing an affidavit.
Obliged.
Item 14.
Yes, what happened?
Lordship, I have received instruction, Lordship. Lordship, may kindly see the third page, Lordship. The closing balance of it was shown as 6,47,000.
Third page.
Third page.
So this has been cleared.
No, Lordship. There is some, Lordship, the next page, Lordship. In March 2017, a 70,000 has been deposited. That is not a contribution of GPF because always the regular contribution is 4,000. So we sought a clarification from the Inspector of School, Lordship, at the third, it will be, fifth.
If it is deposited by her in her account,
No.
give it back to her.
No, Lordship, that's whether this is an area DA or not. They said that it is not area DA. So that amount has been deducted and the whatever with the amount has been paid. Now this is
So
lying
this
with
70,000 is not her money.
not her money. So we sought a clarification from the Inspector, Lordship, the last page. We sent a letter yesterday only, Lordship, asking the Deputy Inspector to clarify whose money is this. So let them reply, it's her money, we'll give her to her.
You release the other part.
Oh, that has been released, 5 lakhs and
No, 6 lakh something.
no, Lordship, we have already released, Lordship, 5,87,000, the figure which is correct. The balance is only 60,000, which she is claiming.
That why don't you release?
Oh, that is the Lordship, that is not because of this 70,000 deduction and all.
This 70,000 came in 2017.
Yes, Lordship.
And till date, it is there. You have not taken any steps. Why?
No, Lordship. We have wrote to the Deputy Inspector of School. Which
Today?
one is this?
You wrote
Let them-
today.
Yes, Lordship.
Today you wrote?
The last page, Lordship.
But this money is in his account from March 2017.
Lordship.
Why was it not looked into?
No, at
Till
the
date?
time of filing calculation, we calculate all those things.
Why?
We have shown the calculation.
Is it
Lordship.
not required that when he retired? When did he retire?
17, my lord.
17. Is it not required that this should have been looked at that point of time?
Lordship, in 2020, we have released it.
When did you release the PF dues to her?
2020.
March, madam. Sorry, madam. In the month of March 2019, I retired.
19?
19 March.
2019 March?
Yes.
the amount was released?
No, amount was balance, deducting that was released after retirement.
You retired in March 19?
Yes.
And the amount was released? Yes. When was the amount released, Mr. Chakraborty?
Lordship, after receipt of the communication on 21/2/2020 from the Deputy Secretary, we have released. That was stated in the instruction, paragraph D, Lordship.
Okay.
Because initially it was sent directly to us, Lordship, but it has to be routed through the government, Lordship. We return back, then it was properly sent, then thereafter we release the amount. After the calculation shown on the next page at paragraph E, Lordship. Now let the instruction come from the deputy, so whose money is this? We'll release, Lordship.
So there is an area salary also 4 lakh something. Okay, things are moving. Let it move. When can you get this instruction? Before vacations.
In this case, I have also received instruction, my lord. As per my instruction, we have already submitted the area proposal.
You have given to me. I've got it.
My lord.
Very good. Mr. Pukhai, so wait for some time. They are doing it. We'll give them some time.
Yes.
In terms of the directions passed by the order dated 12/6/2024, both Ms. S. Chutia as well as Mr. D. Chakraborty, representing the Education as a Department and the Accountant General A&E Assam, bracketed the A&E Assam, have placed on record instructions received which shows that the matter pertaining to clearance of the dues receivable by the petitioner on her retirement is under active consideration of the authorities. It is stated that the said amounts would be released finally to the petitioner within how much, madam? How much period? You give me a date as per your convenience.
Let me take instruction on this letter, my lord.
That letter is sent, everything is sent. So it will be done in a particular manner. How long?
Regarding my lord, financial approval is
Active consideration, and the learned councils submit that they would place on record the date by which the petitioner would be released her dues on the next date of listing. Accordingly, list this matter again on 25/6/2024. On 25th, you tell me by which date you can release this amounts.
Lordship, only after we get the confirmation from them, Lordship.
I don't know, that's you. You are holding it from 2017 and we have taken note of that.
If she has a genuine date, we get it.
When we pass our final orders, we will deal with that.
Yeah, please, Your Lordship.
Too much of activity is also sometimes bad.
Lordship.
My Lordship.
But
I
in
have
this
been
case, my
deprived
our
of
instruction
my
is awaited, my lord.
office and salaries for last more than 3 months, my Lordship. Multiple transfer order was issued, and the latest transfer order was issued on 5/4/2024. Till date, the incumbent DO Patna Gandhi have not given the charge.
My instruction is awaited, my lord.
My Lord, this is last time also instruction. I am without salary for more than 3.
The second time, my lord. I'm praying for.
Had Mr. S.B. Loskar, learned counsel for the petition, and also Ms. S. Chutia, learned standing counsel, elementary education department. Ms. Chutia submits that she is awaiting her instructions.
Notice has not been issued, madam.
She is awaiting her instructions in the matter. Accordingly, she prays that the matter be taken up on 27/6/2024, on which date she would apprise the court with regard to the stand
of the authorities in the matter. Full stop. Accordingly, list this matter on 27/6/2024. Say, this man, you had subjected him to transfer not once but twice. If you can't get your own order implemented, very bad state of affairs. If your officer is some BEO there is superior to your director, very bad days. You transferred him, he comes before this court. Then there is another transfer order issued. That order is modified, but still now nobody is moving and this man is hanging. He is without pay. So arrange for his pay. We will give you breathing space. But on 27th, apprise is that. 27th, Mr. Lachman.
Item 16.
Yes, money paid. Have you received your salaries?
No, Lordship. Lordship, I've got my instructions, Lordship.
Oh, what is it?
There's a case which has been pending connected to this case. There's a stay there.
In our High Court?
Yes, ma'am. I would like to place the whole report. One whole report they have sent. And of this MEM's madrasa, ME madrasa.
I don't understand.
My lord, Abdul Razak, there's a case, my lord.
That is in 21.
21, my lord. And
that went up to the division bench in 24.
my lord.
Division bench dismissed that.
So, my lord, they're calling for a hearing, my lord, because both the parties they've already had a hearing.
I'm sorry, your director is trying to overplay,
Okay.
overreach this court.
Because there was some.
Mr. Fukan, don't make submissions. You'll be in trouble. These factors is already there. This order, 12 to 24. That is the last order, right?
12 to
Matter
24.
was remanded to the tribunal,
Yeah.
right? That is here on record.
Then my lord will direct them to.
Why should I direct? I'll call them. After attempting to so and so, proceedings be initiated, it is made there shall not be influence. Writ appeal is dismissed as withdrawn. This writ appeal was filed by Abul Hussain. And you are?
Chanmia, lordship.
Chanmia. Abul Hussain, Zahidul Islam, Rohizuddin Ahmed. And who is this Abdul Razak?
He has also filed, my lord. He had filed initially. He is also the, my lord, the candidate who was aggrieved and who had filed a WPC 4652 of 21. That is why, my lord, since the matter is sub judice, my lord.
4652 is pending.
That, my lord, have to.
Check up and tell me. Where is the order of provincialization?
What's in my appointment letter is on page 12, lordship. .
Was this withdrawn? No.
No, Lordship. And I joined on 6th February 21, Lordship. Joining letters in 12A, Lordship. Annexure 1.
Where is that copy of the High Court order? Enclosed?
Lordship is in page from 17, Lordship. Sorry, Lordship, from page 20.
Okay. Now, Mr. Pukon,
Madam.
got it. Come to the last paragraph of page 2. Just above the names given
Madam, of the report, Madam.
of the report. Right?
Madam, page 2, the second page.
Second page. In this connection, got it? It is mentioned that the post of the following teachers were provincialized, as tutors, but due to court cases, their wages were not released till now. Now, just get the court cases wherein there is a interim order operating, restricting their release. You take it, you give it to me, you get it, check up. We'll have it after the admission items.
Oh.
And Mr. Pukon, take it from me. If you can't show me an order restraining them, I'm directing the government to release their salaries along with interest to be recovered from your offices. This is not done after the division bench has passed an order. So kindly have your instructions in the matter. Only show me the order which bars you to make payments to them. The last paragraph, right? And those 3 persons named, Chanmia and the others, they are before this court. Okay, have your instructions. After admissions, we'll take it up.
Item 17.
Or we'll have it at 2 p.m. Mr. Pukon, 2 p.m. You are challenging the subsequent.
Yes.
You will issue a notice. Heard Mr. P.P. Borua, learned counsel for the petitioner. Madam, all size in the man correct heard Mr. P.P. Borua, learned counsel for the petitioner. Also heard Mr. A. Fukon, learned standing counsel, Elementary Education Department. And Mr. P. Soikia, learned standing counsel, Director of Pensions. And Mr. R. Bopujari, learned standing counsel, Finance Department. Issue notice, returnable 4 weeks. Mr. Fukon appears, Mr. A. Fukon appears and accepts notice on behalf of respondent number 1, 2, 3, 4, and 5. Mr. P. Soikia, learned government advocate, accepts notice on behalf of respondent number 7, and Mr. R. Bopujari, learned Bopujari accepts notice on behalf of respondent number 8. The notice upon respondent number 6 be served through Mr. B. Sharma, learned standing counsel, AG. Post office. On the returnable date, Mr. A. Fukan shall apprise this court with regard to the stand of the respondents in the Elementary Education Department with regard to the claims as made by the petitioners in the present proceedings.
A GPF amount,
Huh?
GPF amount to be GPF.
That we will not say. That they can't stop also. Why should we come in?
Item 18.
Maybe pass over for the timing also.
19.
Similar issue or a lot of issue notice. This was same issue, minor, nothing was issue. And it's a date minor. Here's the order by the passed by the page annexure 19, page 1119.
You are relying on 111.
Yes, my lord.
Page 111.
111, my lord. Same, my lord. Same order was passed 109, my lord. They have
No, 111 I am replying because here petitioner number 3 therein is the present petition.
present petition.
Yes,
And
Mr.
same order was already complied with, my lord, page 109.
The problem, see, right, wrong, there is an order
No,
covering them.
no. After this, my lord, Purnima Hore came to be decided. Purnima Hore is a.
I'm sorry. I'm sorry. This is a decision between you both. Let there be hundreds of decisions coming up. When this decision holds the field, how can you go back and develop something new?
No, here the issue will be if, my lord, if it is, my lord.
Two order has been passed, one order already given the
You
benefit.
forget it. There is a direction. Accordingly, this court is since I'm so and so, their cases are also covered by the old pension scheme and not by the new pension.
Therefore,
maybe it's a wrong thing, but it is between you.
So therefore, in fact, that was my humble submission. In fact, Purnima Hore also says that in case of stipendiary teacher, they will be entitled. Now, whether they come within the ambit of stipendiary
We
teacher.
did not go into that, Mr. Until and unless this order stands, we will not go into
No,
that.
this
Already
order,
complied with,
this
my lord.
order
That
is
order
not-
was complied with.
Mr. Hazarika, Barpujari, sorry. Once there is a decision by and between the parties,
My lord, I take it, but my lord,
you do things to undo this order.
No, my lord, this decision is pertaining to the facts and circumstances of that case.
Which case?
My lord, the earlier case, which has
That
been
is why, Mr. The present petitioner is petitioner number 3 there. I'm not saying it's a similar case. It is the same person. Others, why should I be so emphatically saying? You come to page 111.
Yes. 111.
Then?
My lord, P3.
P3. Then, if that is the order, till it stands, does this court's order not have any value? Then?
Page 126, page 124.
Mr. R. Barpujari, learned counsel for the petitioner, submits that he be granted 10 days time to examine the issue arising in the matter and make his submissions in the matter. Do whatever you like, 10 days time.
Along with this matter.
Race to list this matter along with WPC number 2948-2024. Mr. Barpujari, if you find that this order is standing, we will have to follow that and direct now.
No, madam, I am on
You,
that.
no. I'm asking, I'm giving you time. You go examine it. If some steps has to be taken, take. Nothing, no problem. But do what is to be done in a legal manner.
Absolutely.
That's all.
I cannot resile, my lord.
You cannot.
I cannot resile.
You can only file a review or an appeal.
I will try my.
That's all.
10% were already given benefit.
No, my lord, I am obliged. I'm
10
obliged.
days, these are public money. If they have something, may have left out something, let them do it.
Well,
I am obliged.
That is a lot.
There is a case where the respondent number 5 he is having 3 date of birth. As per the official records, your lordship kindly come.
I've seen it. Heard Mr. R. Day, learned counsel for the petitioner. Also heard Ms. N. Fukan, learned counsel.
Yes, ma'am.
Also, Ms. N. Fukan submits that she will receive instructions that she be granted 10 days time. She be granted
2 weeks, madam.
1 week time to receive instructions as to the manner in which the respondents now propose to address the grievance raised by the petitioner in the present proceedings. List this matter again on 27/6/2024. Done? Your work is done? Your work is done now? You go and sleep. My only concern is, Ms. Fukan, that if a person can have 3 dates of birth,
Yes, madam.
maybe can have, but only one is recordable under law. You tell me on the next date which is recordable under law and why it is so. That
Yes,
much. only.
Deeply observed.
May I please, your lordship? May I please, your lordship? Lordship, there are two schools in question, your lordship. First one is GAUHATI High School. The petitioners are associated with it. And another.
Tell me first thing, first question, madam. I know it's an amalgamation. Sorry for interrupting you.
Pertains to amalgamation.
You come to para 2,
Para 2 of main petition, your lordship.
main petition. I think there is only one petition,
Yes,
para 2.
yes, lordship.
You have projected yourself to be the president of a school management development committee.
Yes, your lordship.
Petition number 2, vice president. When was the school managing committee constituted?
No, they are associated with the GAUHATI High School.
That's why I'm saying, you say that she is the president of school management and development committee. Which school? GAUHATI Kamal.
Yes, your lordship.
So when was the body constituted?
When the school was established long back.
Long back. It's a government school.
Yes, your lordship.
So that there is a tenure for that.
Yes, your lordship.
So when you filed this petition,
Yes, your lordship.
whether these people were still members of that body?
Yes, your lordship.
Where is the document?
That I have not annexed.
1. 2. If this is being so taken up, where is the resolution of your school managing committee? Empowering them to come before this court, challenging that.
Lordship. There is another WBC, your lordship, which this Lohit Pathak Seniram Rabha High.
That has gone. It has gone now. It is in the grave. It has already finished.
Yes. According to that, the proper evaluation was directed by the
Of a governing body or a managing committee. Now show me from when this managing committee was constituted, whether on the date of filing of this writ petition,
Yes, sir.
you were a member.
Yes, sir.
Because see, the affidavit is not shown by somebody who belongs to the managing committee. He is a villager.
Yes, your lordship.
What headache does he have?
Affidavit has been sworn in by the
Petition number 6.
Yes, your lordship.
Who is a social activist.
Yes, your lordship.
So show me whether you are still the managing committee members. When can you get those details?
Day after tomorrow.
Day after. Done. On the prayer of Ms. Pidas, learned counsel for the petitioner, raised it to list this matter again on Friday. Ms. Pidas on the next day shall place materials before this court to demonstrate that the petition number 1,
2, 3, 4.
2 and 3
Yes, sir.
are still members of the school management committee of GAUHATI Kamal High School. Right?
Yes, your lordship.
Headmaster is against you.
Lordship.
Headmaster is against you.
No, no,
He is
lordship.
with you.
Yes, your
Why
lordship.
did you make him a private respondent then?
No, no, he is with me.
He is with you. Then it's okay.
I'll clear everything, your lordship.
You get me this first.
Yes, your lordship. They.
Friday.
Yes, your lordship. Deeply obliged, your lordship.
I know you did not file an affidavit. Get me the orders.
Yes, your lordship. Deeply obliged, your lordship.
2.
Yeah, please, your lordship. Lordship, matter pertains to.
Hogendranath. You want application of Hogendranath, right?
Lordship. I've annexed the same in the Annexure 2, Your Lordship.
I was part of that,
Yes, Lord.
but I did not argue. It was argued by Mr. B. Sharma. Yes,
Lordship, Lordship may kindly issue notice.
you are appearing for?
Sir, Lordship SSA.
What does SSA to do with this?
Lordship, I'm appearing for respondent number 4 on behalf of Mr. P.
He
Nair.
might have worked with you as CRCC. You are not going to release the amount. The amount will be released by madam.
Kindly notice me.
Miss P. Das, Learned Counsel, Learned Standing Counsel, Secondary Education Department shall receive instructions as to why the leave encashment benefits of the petitioners to the maximum extent of 300 days. You have not been paid a single naira. You have been paid
I have
part.
paid. I have paid, Your
To the extent of 300 days as payable to the incumbents, even in a vacation department, in terms of the directions passed by this court in the case of Khagendranath Deka and others versus State of Assam and others, reported in 2011, bracketed 5 GLT 9 was not so released to the petitioner. Registry to list this matter again on 17/7/2024.
Much obliged.
Madam, they are entitled to 300 days.
Yes, Your Lordship.
Provided that amount is there in their credit. They were given a part 200, 150. Rest, why? Your only plea can be that they don't have that leave to that credit. Finished. Get those details, place it, we will dismiss this. But if the leave is there, then you will have to release. Pendency of this writ petition would not be a bar to the respondent authorities to release to the petitioner the leave encashment benefits for the remaining days if found so entitled to. Done with?
Yes, sir.
Much
Deeply
obliged,
obliged.
Lordship.
Regarding non-payment of salary from 16/11/19 to 28.
Mr. Counsel,
My lord.
you come to your regularization order. Page 27, right?
24.
Right?
Lord.
Date is 15/9/21. Regularized from 16/11/2019. Come to that page 27.
Lord.
Right?
Lord.
15/9/21. Regularized 16/11/2019. Right?
My lord.
Now just tell me. Come to your prayer. You have prayed for arrears salary from 16/11/2019 to 28/2/21.
My lord.
Why not?
No, my lord.
How did you receive the salary from March?
My lord, from March, I received my regular pay scale, my lord.
How?
Earlier, I was, my lord, appointed as OBB teacher initially, my lord. For 1800 was my fixed salary, my lord. After completion of my DLED, my lord, I am entitled to get my regular pay scale from 16/11/2019.
No, how did you get your salary from 1/3/21?
My lord,
Where is that document here?
Page 28, my lord. Page 28 and Vivek would be, my lord, page 29, my lord. This is non-royal certificate issued by the block limited education officer, my lord.
So you mean to say that you were authorized the scale of pay
My lord,
from 1/3/21
21,
on the same ground, DLN?
my lord.
Okay, but subsequently they had issued this order.
But even their own order itself reflects that I am entitled to get.
No, I'm no doubt about that.
Lord.
But I'm only clear. Doubt was why do you only limit it to 28/2
My lord.
and not
15-9.
Mal.
That was my doubt. So you mean to say from 1-3 you are getting?
Lordship.
Okay. Heard Mr. DFA Ahmed.
J. Lordship.
J. Loskar, sorry. J. Loskar, learned counsel for the petitioner. Also heard Ms. S. Chutia, learned standing counsel, Elementary Education Department, and Mr. R. Borpujari, learned standing counsel, Finance Department. Issue notice, returnable 4 weeks. Ms. Chutia accepts notice on behalf of respondent number 1, 2, 3, 4. And Mr. R. Borpujari accepts notice on behalf of the respondent number 5. No formal notice is to be issued. However, the learned counsel for the petitioner shall furnish to the learned counsels for the respondents requisite extra copies of the petition. Full stop. The pendency of the writ petition shall not be a bar for the respondent authorities to compute and release the area salaries of the petitioner with effect from 16/11/2019 to 28/2/2021.
Obliged.
With your lordship. Before start, I would like to say to your lordship, there's a small correction in page number 4 cost title lordship. The respondent number 3 should be the Director of Elementary Education. It is here, it has been written as secondary education.
You mean to say 3?
Yes, Lord.
It should be Director of Elementary Education. Fine, go ahead.
Lordship, the petitioner was suspended on Lordship on 21/3/22, Lordship. That is page number, Lordship. Kindly come to page number 22, Lordship. In connection of the criminal case, the petitioner was suspended, Lordship. But subsequently, what happened, Lordship? The charges level against the petitioner, that has been the petitioner discharged from the criminal case, Lordship. So now there's at present there's no case against the petitioner, but Lordship, the petitioner submitted representation regarding stating all this, stating all the. Lordship, kindly come to page number 25, Lordship.
25. Okay. Read.
Yes, Lordship, the petitioner paid, Lordship, the respondent number 4 to, since he has been discharged from the offense, then he should be, the suspension should be revoked and he should be reinstated in his service, Lordship. Accordingly, Lordship, the respondent number 4
Has forwarded the matter.
forwarded the respondent number 3, Lordship. And respondent number 3, nothing as no action has been till date taken against the representation, Lordship. That is my humble submission, Lordship, that since there's no charges against the petitioner is discharged from the office, so suspension will be revoked, Lordship.
Yes, Mr. Dear.
This is notice, my dear. Or I may be allowed to take instruction whether any DP is pending or not.
Can't be. You have suspended him because he was arrested in that criminal case.
Right.
Criminal case gone. What is left?
My lord. The DP may be.
See, unnecessarily you are putting this. He required it. His actions required it. He is bashing up a teacher in the school itself. So I think he has got it. He has got it. Sustain injuries, parts of my body. Why did you go and trespass into the school?
This is false allegation.
False. Okay, have your instructions next week. Let her one opportunity. Ms. S. Chutia submits that she be granted a week's time to receive instructions with regard to the decision as arrived at by the authorities pertaining to the order of suspension of the petitioner herein. Full stop. It is noted, it is to be noted, it is noted that
The petitioner herein was suspended with effect by an order dated 21/3/2022 on his arrest in connection with Lahual Police Station case number 43/2022. Full stop. It is submitted that the said police case and the corresponding GR case number 420/2022 has since been concluded with the discharge of the petitioner from the charges so leveled against him therein. Full stop. Ms. Chutia shall complete her instructions and place the same before this court on 26/6/26.
I'm praying for extra copy, ma'am.
Huh?
Extra copy, ma'am.
Madam will give it. Give her extra copy. And if you don't get the extra copy, don't take instruction. Simple as that.
Obliged.
Supplementary course list, item 63.
Ma'am. In this case.
Same thing, same issue.
Same issue, madam.
There was one matter today.
One today, it is.
When did I fix it?
Item 13, madam.
When did I fix it?
And date is not fixed, madam. Date is not.
13 to get edition. Huh? Raised it to list. We'll issue a notice. That is better. Or you don't want a notice.
My lord, your lordship may issue an interim, my lord, observation may be given that not to proceed with the.
That will not help you in any manner because that proceeding will still be there. Right?
No adverse action may be taken while this observation.
That if they take within the short time, you come back to us.
Again.
No, file a IA. If a disciplinary proceeding is concluded so fast by following all these steps, then I will dismiss your writ petition if the government does it. I'll dismiss your writ petition only for the fact that they have done it promptly. They will not do anything. Heard Mr. B. Purkhaista, learned counsel for the petitioner. Also heard Mr. U. Sharma, learned counsel appearing for all the respondents. Issue notice. Mr. U. Sharma accepts notice on behalf of all the respondents. Full stop. No formal notice is required to be issued. However, the requisite extra copies of the petition be furnished to the learned counsel for the respondents. Full stop. The petitioner has prayed for an interim direction in the matter. Full stop. Consider the materials available on record and accordingly, it is provided that while the disciplinary proceeding instituted against the petitioner is not being restrained by this court, however, before issuance of final orders therein, leave of this court be taken.
But it may come along with that item 13,
list along with
WPC.
register to list this matter on the returnable date along with WPC number
265324, madam.
265324.
64-65.
None has appeared for the petitioner on call. Raised it to list this matters again after the MC. You are there.
For the respondent. In the first petition, my lord, I have no instruction to appear. In the other petition, my lord, I am for the petitioner. They have filed a, my lord, IA for vacation of the interim order. I took time for, my lord, filing the reply.
My lord, would remember the last date, my lord was.
You take up the IA.
My lord.
My lord, lordship granted us 10 days time, my lord. The 10 days is not offered.
10 days is not over.
No.
My lord.
Oh, this is on 25th June. Why is it today?
My lord, because
you made a mention for this.
No, my lord.
Then how is it listed today?
Because my lord, 2884/2024.
This
2884/2024 was listed today, my lord, along with 1941.
okay.
I did not.
2884/2024. List this matter again on 25/6/2024 along with WPC number 1941/2024. Cool. We'll have it on 25th.
Daily course list, admission item 25.
My lord, as per lordship direction, I have communicated on 4/6. Thereafter, my lord, deputy director communicated to the Delhi office, my lord, assistant director legal. Thereafter, assistant director communicated the assistant director legal. And
Forget
legal-
your communication. Tell me what has happened.
My lord,
Have you got the
recently, my
undertaking?
lord, on 13/6, assistant director legal has communicated assistant director seal and design development. They are the proper authority. They can decide how the amount has been collected.
So have you got the, you were
No.
supposed to place that instruction today in writing.
My lord,
I'm not concerned with your,
My
who is
Delhi-
writing to whom.
without the consent of Delhi legal, this branch, my lord, local office cannot, my lord, write.
So we are directing with interest, 12% per annum. I can't
Lordship,
help
my
it.
lord, kindly see.
No. I gave you 2 dates.
My lord, that
2
means, my
dates, 2 dates. On this, we are not concerned. I'm not required to look
My
into
lord,
this.
Guwahati office cannot, my lord.
Who
write,
asked you? Did I ask you? You said we have already sent it on the last occasion. Should I play that video back?
my lord.
Then
But they are the proper authority, my lord, seal and design development, my lord.
whoever is the proper authority, I'm not concerned. I only want an undertaking that you're paying. That's all.
The payment, the amount, the pre-receipt has been signed, that amount will be released, my lord.
When?
As per my lord,
Okay, you release that amount to him by Friday.
my lord.
Friday. By Friday.
Some process is required. my
Oh,
lord.
I don't know. You said it will be released. It is ready. Pay him.
You know, my lord, the process, my lord.
What process? Mr. Bhattacharjee, first determine what you want to say.
My lord,
You be
they are
clear.
ready to write in prayer.
Who are they? Why are they not paying? Why are they retaining that money? If it is his due. When was the amount due to you? 2,50,000? Not that your designer fee. Other part? 2,43,000 or something. When was it due?
2 lakhs.
It was from 28th of February 2013.
13. So 13 till here,
Yeah,
9% interest. Pay that amount. Shall I pass an order?
That amount will be paid, my lord.
Paid by with interest of 9%. Admitted amount, not paid, 9%. He has given a pre-receipt also.
That is their fault, my lord. They did not receive the amount at that moment, my lord.
No, that was not given to them.
They have not
They have
released.
not released to you.
not released, and
Mr. P.S. Bhattacharjee submits that the amount of rupees 2,03,660 660
Yes, ma'am.
being the second and final installment of the grant in rate as released to the petitioner society was not received by them, and accordingly the same remained in arrears. Full stop. The above aspect of the matter is strenuously disputed by the learned counsel for the petitioner. Mr. Bhattacharjee on the next date of listing shall place on record the material documents to show that the petitioner society had refused to accept the amount of rupees 2,03,660 as offered to them. List this matter on 27/6/2024. In the event the documents as required are not produced, the personal appearance of the competent authority would be ordered on that day, making the person to appear before this court on 28/6/2024. Show me that you have given them and they have not accepted.
Well, they have signed the pre-receipt also, my lord.
You show me that the check was given. You will not give in cash, you will give in check only. Show me that check was given, they refused.
That's all.
There was some process, my lord. There is some process.
Mr. Bhattacharjee, you made a statement. You go back home, see the video. You made a statement that the money was released, but they did not receive.
Financial year was over, my lord, at that moment. That is the reason they could not receive the money, my lord.
You gave him a check.
But that I have to.
Get it? If there is no check given, they have not denied, they have not accepted, fine, no interest. But if no check is given, Mr. Counsel, was any check given to you?
Oh, no,
2,03,000, no check given.
they have not received that instruction. I have, whether they have given or not, that instruction I do not know.
Check it. Both of you. If not given, if given, not accepted, forget it. No interest. But if not given, from that day,
We are ready to
it
pay
will
that
be,
amount.
you'll be ready, 12% on this interest. A small society did a work for you and you deprived them. That designer fee you have disputed, I'm not even going into that. That we will give them liberty. If they want, they can go before the civil court. But this amount, 12%. Okay? Counsel, get your instructions. On 27 question, huh? 27 corridor. On 27. Last one line to continue. Personal appeals now.
Okay.
All right. 26.
Have you got the materials? Mr. Soikia's smile says it all. So, how can we help you? I can't help you.
Order passed into lawsuit order, my lord, earlier order, my lord. The mission director passed an order. Hereby, my lord.
They have filed an affidavit here, Mr.
So this order was not next. Last line, my lord. Price data of preceding years has already been frozen by the ministry. That is why correspondent they could not find the earlier data as my lord.
No, this can be. Where is Mr. Bora?
Because my lord, in the affidavit,
Yes.
the SSA authority.
Mr. Bora, please go through this. Yes.
They say that my lord, the old dice code is the dice code my lord, which I am claiming.
704304. That is no dispute on that. So they say page 104, para 5 is not found. It's not there. Right? And this frozen data can be opened once in a year, I suppose, na? The data used as data is opened once in a year.
No, my lord. Entire year, my lord. The SSA can put in the data. As the message comes from the principal that this, they can put it. But in the month of November, first week or second week, it freezes. Then the SSA authority will not be able to earlier year or that particular year.
That does not mean that you can't look into it.
Yeah, that you can look in, but doesn't mean that we can tamper with it.
Mr. Soikia, you approach the appropriate authority. Do it. Don't make me pass orders here.
Well, please for 84.
Huh?
Page 84, man. Page 84, my lord. Of the affidavit filed by the, my lord, the respondent number 6.
all this thing gone. All this thing gone with the affidavit now.
The price proposal.
If you can show me that this affidavit is perverse, fine. Erroneous.
That is why I am taking.
No, blameworthy. No, that those things will not. Categorical statement.
This sent it.
And you can't show me. And those papers that day you showed me, that in the market you will get many like this. I can also make it. There is no problem. Because those are my documents. I create. But the document would be one which the SSA accepts and then uploads.
What I could not understand, my lord, in this case, my lord, that dice data, which was, my lord, claimed by the petitioner school in the year 2009 and 2010, basically, my lord, which, my lord, my school has been provincialized. The same data, my lord, is retained till today. Same number. Number has not been changed. If it was generated in the year.
See, that is the problem. That is the problem. Once the provincialization took place, then these issues came up. Then inquiry was made. During inquiry, it was found that 9, 10 onwards till 14, 15, 13, 14, your data is not there. Then the director writes to SSA. SSA reports. And that stand of the SSA from that date till date is same.
What I am saying, that if the dice data number,
that number, Mr. There may be 101 reasons in education department. We can't say what it is. But as far as this court is concerned, not disputed that prior to 14, 15, it's not there. Or you saying, no, it's from 9, 10. My data is there. They say, no, your data is from 14, 15. Mr. Soikia, it becomes a disputed question of fact, which this court will not do.
Page 84, the mission director himself says that my own data number is this at page 85.
Where is that 85? There is nothing here. No
Page
data.
85, serial number 15, my lord.
Page 85.
Page 85 of the my lord affidavit filed by the respondent number 6, my lord.
Oh. What is the internal page number? No. What is the date of that order?
Page 84 order, my lord.
84 is some RTI.
Yes, no, ITO.
No, my lord, regarding dice code.
Specific report on dice code. 4/6/2016. What is the date of the letter?
16/11/14, my lord.
16/11/14. Wait, there is some mistake in the, maybe in the numbering. It is not part of your writ petition.
It is not part of my writ petition, my lord. It is the affidavit filed by the respondent number 6.
Okay. Respondent number 6.
6. Voluminous affidavit, my lord.
Huh?
It is voluminous, my lord. Affidavit filed by the respondent number 6, my lord.
Not here.
It contains, my lord, 97 pages.
Not here. In the present writ petition. In this writ petition.
Yes, ma'am.
There is no reference of respondent number 6 affidavit.
No, I'm sorry, my lord. This is not in this present petition, my lord. I'm sorry.
So, you approach the appropriate authority. If I have to pass, that will be the nail in the coffin. Appeal is there. That's a different thing altogether. You go before the education tribunal, go before the civil court, go wherever you want, establish your right.
As this, my lord, even if the dice code was not there, as this amount put in the petition held.
I'm not accepting it.
Dice data number is secondary requirement. And
You are an LP school.
LP school.
LP school dice data is the primary requirement. We have held high school, higher secondary school, no dice data is required. Can't help it. What do you say? You want me to pass an order? We'll pass an order. But Mr. Ayat Soikyal and counsel for the petitioner. And I'll dispose of the idea.
27.
And Mr. Soikyal, at any point of time you find that the statements made by Mr. Bora is wrong, bring those materials, file a review, we will come with you. Yes. What is your grievance?
The withholding of my DCRG without there being any departmental or criminal proceeding pending before against me. The FIR was lodged in 2016.
Oh.
2018, I retired.
Hmm.
They have to start the departmental proceeding.
You mean to say that the charge sheet is not filed?
Not filed.
Till date?
No.
Charge sheet has been filed, my lord.
When?
Recently, my lord. On 14/3/22, my lord, 2022.
That is after 4 years.
14/3.
2022.
Charge sheet filed.
Yes, my lord.
Now tell me. The pension and pensionary benefits,
Yes.
on which date it has to be considered?
My lord.
Can it keep on waiting till the charge sheet is filed? Or it is required to be considered on the date he retired, with the materials available on that date?
My lord, regarding other pensionary benefit, he may be entitled, but in case of gratuity, my lord.
No. Gratuity, you come to the Act of Pension Rules. Have you got the Supreme Court judgments?
Yes.
Latest one.
Latest one.
Which one you have? What is the name?
Jitendra Kumar.
Huh?
Jitendra Kumar.
Central Rule 9.
Yes.
Huh? Rule 9 case. Come to 21. Explanation. Right, Mr. Goswami?
My lord, 22/1, my lord.
No. I'm on 21.
Yes.
First 21. Explanation. A. B. Here it will be a judicial proceeding. A judicial proceeding shall be deemed to be instituted in case of a criminal proceeding on the date on which the complaint or report of a police officer on which the magistrate takes cognizance is made. That means report under 173.
Yes.
6. So, on the date when he retired, this was not there.
My lord, my submission is that cognizance.
You are appearing for whom?
For respondent number 3 and 4, my lord, principal and the governing body.
Who are you? Why are you so worried?
My lord,
It is the government.
I have no objection, my lord.
It seems that there is some personal axe to grind somewhere. Yes, Mr. Abhamanyu. The charge sheet is filed only on
2022, Lordship.
22. You retired on?
2018.
18, Lordship.
So, how was his DCRG with him? Why was his DCRG with him?
We'll have to get the instruction.
No. This matter is pending from 2021. You have not got the instruction. This man might be in wilderness now.
Lordship,
And he is a part of a big group.
Yes.
what is his exact nature of allegation against him? That is also not clear.
Lordship, can it come on Friday, Lordship?
No issue.
I will get the
Only satisfy me
why his DCRG has.
that 21 and section 22, for application of 22, you will have to have 21 explanations satisfied,
Yes, Lordship.
right? So police report that came in 2024. He retired in 18. Whether on that day his DCRG could have been, with some material to stop his DCRG. And what is the decision you are relying upon?
The links. Can it be on the links?
You want to keep it close to your hearts. There is one decision, recent.
Satyanarayan Prasad Gupta.
Hmm?
Satyanarayan Prasad Gupta.
Maybe a month back, right?
No, Lordship. This was earlier, Lordship.
This is month or two back, maximum. I have written it somewhere. Let me see if I can get it. Okay. On the prayer of Mr. D. Upamanyu, Learned Standing Counsel, Finance Department, raised it to list this matter again on Monday. Monday. Yep.
28, 29.
And in this case, I have received instruction some time to file affidavit.
What is your case?
The petitioners queried the
Now tell me the characteristics of the word tutor. I'm confused after reading. So explain. What is a tutor?
as per Act.
Can a tutor be a headmaster?
No, my lord.
No.
No, my lord.
Because the definition of tutor itself, so you cannot be a headmaster.
My lord.
So you are tutor or you are tutor science.
My lord, fact is that, my lord, in case of any school, my lord, as per RT Act, my lord.
We are not concerned. That for
100
that,
students-
Mr. Patgiri, you will have to challenge your that in a different proceeding in a
And,
different
my lord,
manner.
Schedule of the Act, my lord.
Come,
Remuneration
show me.
part, my lord.
Show me in the schedule.
Schedule, my lord.
That schedule cannot override the body of the act.
My lord.
Body of the act, tutor is excluded from the purview of headmaster. It says tutor will never be the headmaster. So if you have the qualifications,
My lord.
you have to be appointed. Put a challenge to that appointment order in the manner required. We will consider. But how come we can pass the order here?
My prayer is a twofold, my lord. First of all, my lord, below 100, more than 100 students, my lord.
That,
It is the
Mr. That would be sanctioning a post of headmaster.
My lord.
That would be a different ball game altogether. Because you have not challenged your appointment. We'll not go into that. Second is, give me the scale. 12,000. We can't. Because you have regularized as a tutor. And those orders are not under challenge.
My lord, I have to complete my lord TET qualification, my lord. TET.
Whoever, whatever you do,
5 years, my lord. But till that, my lord, no TET exam has been, my
we
lord.
can't help it. We can't help it. Have you prayed for a direction for TET? You have prayed for relaxation.
Relaxation.
We'll not do it.
Second, my lord, and first, my lord, remuneration part, my lord, 12,000, my lord. As schedule prescribed, my lord, as petition, my lord.
12,000, that is a wrong prescription according to this code. That cannot be given because it runs contrary to the definition of tutor. This was
At least, my lord, affidavit, my lord.
what? Just to waste paper. You satisfy me. 2 o'clock. You satisfy me on this. Others I'm discussing.
Next date, my lord.
No, today.
I
2
also,
o'clock.
my lord, another matter in the division matter, my lord.
2 o'clock. 2 o'clock.
Hello.
2:30, whenever it's possible. Come back. Just satisfy me on that point.
30, 31.
Do you still want to file an affidavit?
Lordship, here, Lordship is directed to produce the record, Lordship.
Today, just now, I have received a record lordship.
Just now.
Your lordship, today.
Wait. When did we pass this order? Arvata read
This
us.
was on last.
(13-6).
Lordship.
Where did the records come from?
It is from the district lordship, district elementary district.
So what did you find? You have not been able to go through.
Lordship, I did not go through, although that department.
Okay, Friday.
Inquiry report and everything.
Friday, you go through.
Lordship,
You go through, we'll have it on Friday.
Friday, lordship. Yeah. Problem.
Mr. P.N. Sharma, Learned Standing Council, Secondary,
Elementary lordship.
Elementary Education Department submits that the records in the matter as required to be produced by before this court has been received by him today. And he was not in a position, he was not in a position to examine the same. Accordingly, he prays that the matter be taken up on Friday for placing the said records before this court. Full stop. Prayer accepted. List this matter again. List these matters again on Friday. We'll see. Mr. Hawk, before you proceed with the matter, there was a earlier writ petition, 422/2017. What was that for?
Well, that was regarding transfer matter.
Huh?
Regarding
Same.
Same matter.
Same.
Same matter. Here, what happened, subsequently contempt case was.
Contempt case was then
The
closed.
contempt case, yes, said that let them approach the department, department will take the view. During the pendency of the that contempt petition, kindly come to page 54, madam. Page 54, Here, the director of elementary education, had written this communication to the district elementary education officer.
54.
54, Here, under the heading of subject matter, it is submission of formal transfer proposal of Selina Ahmed in connection with contempt case number so in WPC number 422 of 2017. References there, here, sir, with reference to subject cited above, it is for your information that as per GOP.
So it is on the basis of this letter that the contempt was closed.
Yes, yes. And subsequently, the proposal, page 55, your lordship will find as page 55, This is the letter from the director of elementary.
Where are you now? Still in a chore area?
No, it was in attached to a school, nearby the town, but that school has already been amalgamated,
But you have not been taken in.
No,
So you are without salaries from that day. You are paying salary.
In fact, I am posted still in the chore area,
You are getting your salaries.
Receiving my salary. I am being kept in attached.
So education department, this is what? Elementary. Nobody is interested. Okay, fine. You argue. We'll allow it.
Kindly come page 55.
Yes.
Page 55, Here, the district elementary education officer, had his letter dated 14/8/2020, had submitted the formal transfer proposal, to the district, to the director of elementary education,
So you are basically sitting at home today. You are sitting at home. No school.
No, school is there, I am just keeping attaching with some other school,
No, where are you working today?
I am right now at Batabari.
Batabari. You say Batabari is already.
Yes, that has already been amalgamated.
Then
still I was keeping a attached,
you're working there, signing registers.
I am working.
Attendance registers. Are you signing
Yes,
attendance? Signing?
Yes.
Sure.
Sure.
Lordship, I've got some instructions, Lordship. I would like to place it.
Okay. You were transferred on 21/10/2023 to Dui number Haldibari Sri Sri Sankardev School. Where is this school?
Haldibari.
Haldibari?
It is also rural area, but Haldibari, so far my knowledge, I know that.
Oh, you want urban area?
Yes, well, that is the that was the scheme, madam.
Okay.
That family teacher, madam, who was working in the shore area, just will come to the.
So this Haldibari Sri Sri Sankardev is also in the shore area. Shore area.
And
Sure.
Her distance, madam.
You know that?
Yes, sir.
Have you got this order? 21/10.
Not yet communicated.
Not yet communicated. Why was it not communicated?
Haldibari.
That I have to check up, man, whether he's been communicated or not.
You give him a copy. Mr. A.
I'll give him a copy, man.
A. Fukan, Learned Counsel for the Learned Standing Council Elementary Education Department has produced a communication received by him from the Director of Elementary Education Assam, wherein it has been stated that by an order dated 21/10/2023, the petitioner was transferred and posted from Batabari Part 1 EGS 2 to number 2 TO normal Roman 2 number Haldibari Sri Sri Eksar Sankardev School against a vacant post available therein. Also, Mr. Hawk submits that the said order was never communicated to the petitioner herein for compliance.
Is it instruction mallet or the transfer order?
No, transfer order.
And my lord, one thing I just want to point out, 8, 9 and 10 below, it has been given to the person concerned for information, that is him. 8 is the head teacher of the existing school. 9 is the head teacher of the newly transferred posted school, and also, as well as the person.
Just
so that I'll
see whether she has received
received
it. That'll do. Accordingly, in view of the above contention raised by the Learned Counsel for the petitioner, Mr. Fugan shall receive instruction as to whether the said order, transfer order dated 21/10/2023 was in fact served upon the petitioner hearing. List this matter again on 25/6/2024. Full stop. A copy of the order of the communication along with its enclosure dated, a copy of the communication dated 9/2/2024 as furnished by Mr. A. Fukan, along with the copy of the order dated 21/10/2023 are kept on record and marked as X Coley, COLLY.
Obliged.
Mr. Chaudhary, that day we were under the impression that there is no proceeding pending. You have a civil case for recovery.
The only thing is that the outcome of this case shall not affect the civil case. We are okay.
You substitute, you recover whatever you do. Yes.
My lord. My lord, as per my instruction, and pension proposal could not be forwarded because of no next of kin certificates and bank details, ID proof, and address proof specimen signature given to us.
Okay, when did you ask for this?
This is my instruction.
So,
as per
get a group photo, give it.
As per information from
That is the
principal,
minimum you should do. Also, Mr. U. Sharma, Learned Counsel for the Standing Counsel for the Standing Counsel Secondary Education Department on instructions have submitted that the pension proposal in respect of late Rona Kantodas could not be processed in view of the fact that his family had not submitted the next of kin certificate, comma, bank details, comma, address proof, specimen signature, etc. And only a copy of the death certificate of late Drona Kumar Kantodas was so submitted. Full stop. In view of the above position, full stop. And accordingly, ऊपर में लिखा है ना, pension proposal could not be processed. छोड़ो, full stop. In view of the above position, the present petitioners being the legal heirs of late Dronakanto Das, bracketed original petitioner, bracket over, are now directed to submit before the principal Morigaon HS and MP school the above noted requirements to satisfy the above noted requirements within a period of 15 days from today. Full stop. Thereafter, the principal Morigaon HS and MP school shall proceed to process the pension papers of the petitioner and submit the same to the concerned departmental authority in the secondary education department for onward processing. Full stop. It is at this stage required to be noted that with regard to a loan taken by the original petitioner and non-refund thereof, a recovery proceeding is pending before the court of civil judge Morigaon.
No, no, here.
Huh?
Here in Guwahati.
Guwahati, civil judge Guwahati in title suit number A29 2019. Can you ask your junior to just have it corrected and give it to her? Huh? So and so. Also, accordingly, they said proceeding being pending and there is no restraint order from there.
No.
And no restraint order being available from the civil court in this connection, comma, the same cannot be a ground for withholding the pension and pensionary benefits of the pensionary benefits in respect of the services rendered by late Drona Kantodas. Full stop. List this matter again on, we'll have it after vacations on 22/7/2024, on which date the Learned Council for the parties shall apprise this court with regard to the developments that have taken place in pursuance to the present order. Also, you must thank Mr. Chaudhary.
This matter may be take with my lord item number WPC number 2852/2021 in an analogous matter. We have filed in this case affidavit.
Okay. You give him a copy of that affidavit then. It will be covering. Mr. T.C. Sutia, Learned Counsel for the Seba.
Council, not council.
Higher Secondary Education Council, might.
This is Higher Secondary Education Council.
Yes.
Mr. T.C. Sutia, Learned Counsel, COUNSEL, appearing for the Assam Higher Secondary Education Council, COUNCIL, submits that a similar matter is pending before this court in the proceedings of WPC number
2852.
Is a similar issue also arises in WPC number
2852,
2852
2021.
of 2021, which is stated to be pending disposal before this court. Full stop. Accordingly, registry to list the present writ petitions, along with Uparwala double two on after the ensuing vacations.
Obliged.
Copy of the affidavit, I kindly.
Mr.
I will provide you.
I'm deeply obliged.
35.
Area salary 1/6/1998.
Initially, you was appointed, service was provincialized as paid for employee. After, my lord, 2 years of his service.
Mr. Sharma, file your affidavit.
Yes, my lord.
Mr. Sharma, learned counsel for the petitioner as a last chance, submit praise that he be given another 3 weeks' time to bring on record the stand of the authorities in the matter. Also, it is provided that in the event the affidavit is not filed before the returnable date, the writ petition shall be taken up for consideration basing on the materials available on record. 3 weeks. You make a mention after that.
6.
Yes.
On the last date, the respondents have stated that they have produced a communication dated 30/4/2024 regarding a proposal for the release of arrear salary, and today was fixed for instruction regarding the status law.
Matter reached the proposal has reached the director pension. Yes, who is appearing for the director pension? But not yet finalized.
Finalized.
Yes. What is your directorate doing with the matter from 2020, 19/5/2020?
Apart from that, Lordship, the leave salary, subsistence allowance and time step.
No. Then the 205/206, that was also done. 23. Then why the pension is not being released?
My lord.
You have got your pension. Then what is more left?
Lordship, the arrear salary, along with it, the leave salary.
Of the period of suspension. Yes, Mr. Sharma. You are satisfied with your pension?
Lordship, no, there is another mistake, Lordship, in the affidavit in October.
That is what I was waiting for. Yes.
My lord. Here, my lord, director.
Haste makes waste. You, maybe because you wanted to satisfy this court that everything is being done, you have created an error. Her salary, last drawn salary is around 25,000. You have shown it as basic pay is 22, right? 7,000-8,000 rupees difference.
So, my lord, director has written the inspector for a resubmission of arrear particulars in respect of the Bharat Chandra Das in connection with.
When did he write? When was it written?
It is written on 11/6/2024.
11/6/2020. And what, madam? You have brought a last pay certificate on record. Where, this is
11,900,000.
28,550. Right? GP grade pay page 73. So your pension has not been fixed at this, reckoning this one, right?
Lordship.
Yes, Mr. Soma.
My lord, since the instruction has not coming from the inspector of school, so some time is required. Yes, because
you have written on 11th only. It will reach him by 18th. He will reply by next month. By the time we will have vacation. Finished. No, I'm not on that. You have finalized the pension. Right?
Yes.
But you have taken her emoluments.
But my lord, fresh non-royal certificate.
No, I'm not on that. I'm not on that.
I'm
not on that. I'm not on that. There is an error in the basic pay, which was reckoned for pension.
Yes.
Because you have not regularized the period.
Yes.
Increments that would come to her at that period, that was not taken care of, and the pension proposal was submitted. That was around 23,000 as basic pay. Our actual basic pay would be 28,000. What do you say on this? Mr. U. Sharma, let us see how we can do it. Mr. U. Sharma, Learned Standing Council, Secondary Education Department shall receive instructions as to the basic pay of the petitioner, along with the grade pay authorized to her on the date he superannuated from his services. It will also be brought on record by Mr. Sharma as to whether the basic pay so arrived at was a basic pay as fixed with regard to the petitioner was so fixed after reckoning the increments that would now be required to be authorized to the petitioner for the period of her suspension. Right? When?
After vacation, my lord.
That's actually when? 19th?
Yes, 9.
19th.
Regarding the area salary also, they have.
Mr. Sharma shall also, Mr. U. Sharma has on his instruction submitted that the process for disbursal of the area salary of the petitioner is under active consideration, and the proposal in this connection has already been, a revised proposal in this connection has already been sought for from the jurisdictional inspector of schools. Mr. Sharma shall also on the next date apprise this court as to the developments taking place therein. Full stop. List this matter again on 19/7/2024. 19/7/2024.
Item 37.
Yes, madam. What is left here?
Pass over the matter.
Pass. Done.
After vacation.
No. Where is your counsels? Which court?
Sir, due to some personal difficulties, they are.
They have not come to the court today.
No, sir, they are in another room. Another court.
Another court. Personal difficulty. Another court. Some court is behind them.
No, sir.
When their personal difficulty is over, call them here. I'm here.
38.
This matter may not be taken up.
Hindi teacher.
No, Lordship, regarding pay scale in Hudud case, Lordship.
The earlier one. List before any other bench without me. Any more matter like that? I
No.
can finish off.
Okay.
Here I am supposed to file an affidavit, my lord. Affidavit was executed, but the registry didn't accept it because there now new notification has come.
Oh, that roll number.
I have to redo everything again, my lord.
So you put the blame on us only back.
No, no blame. I have to put it down now. I have to add it now again. Again, it everything. Let it come after a week, my lord.
We'll see. Laboratory assistant.
Lordship.
Where is that selection process?
Was it? I was appointed in the year 1991, Lordship.
91 also. You are not appointed. You are appointed from the.
Basis there.
You are not appointed from an AC room. You were appointed from the road. AC room means not in pursuance to a selection interview. Right? LDA, same thing.
I was regularized in it, about the
LDA appointment.
appointment.
Appointed. Appointed.
Appointed.
It's an appointed. How? So, if it is 2007, got nothing to do with your service as laboratory assistant of 97, how can you be under the OPS? You will be NPS, even if it is due to you. Prepare.
Plus,
Your Bora has saved you today. On the prayer of Mr. S. Bora, learned Standing Council SCRT lists this matter again after 4 weeks on a date to be fixed by the registry. These two aspects, the court earlier order in similar situation case by this court will not favor you, will not advance your case. So you will have to satisfy this court on that lines, right? Because your permanent appointment occasioned only in 2007.
Item 40.
Why was you not appointed? What is the reason?
My lord, I got selected for Nagaon district, and my lord, respondent number, my lord, got selected for Sonitpur district.
Ah.
Respondent number, my lord, appointed in my place, that is the Nagaon.
Who is appearing for respondent number 4?
my lord,
You are appearing? Where did you apply?
one of my senior is on leg in.
Who is your senior?
Yeah,
Get it. Mr. Chon, let's see. Huh? Mr. K. Ahmed is said to be on legs. Let him come. If what you said is true, he is Sonitpur, you are Nagaon.
Yes, sir.
There can be no amalgamation. It has to be distinct.
District wise, yes.
We'll get that clarification. Ask him to come. And when you, Mr. Ahmed comes, call Mr. Chauhan also. Mr. Chauhan, you can go to your room. They'll call you. Yes.
But the pleadings are completed in the matter and you're ready for the arguments.
Don't want to do it today? Okay. But Mr. Hasid. HISIEB, learned counsel for the petitioner, and also Mr. N. Gautam, learned counsel appearing for
The university lordship respondent.
for the respondent university, and Dr. P. Agarwal appearing for the UGC. It is stated that the pleadings in the matter is complete and can be considered for final disposal. Accordingly, issue ruled returnable 4 weeks. Registry to list this matter for hearing on the returnable date. Full stop. You want a date?
Yes.
Registry to list this matter for hearing on when?
It's possible in July, mid-July.
Huh?
Mid-July.
Yes, sir.
Oh, we are there. We start off working. Mid-July is the starting working for us.
Yes.
So when do you want it? Give me a date. 17th? No problem. 17/7/2024.
Kindly pass over the note for typing. Senior counsel, Mr. A.R. in court number 1.
Starting. You can wait. Yes, where is your affidavits?
Let's see, we file our affidavit.
Your file. Oh, pleadings complete. Yes.
Let's see.
You have something to say?
Hmm.
Then I stated in the bar that no more further pleadings are required.
Lordship, we have not filed our affidavit, Your Lordship.
As prayed for by the parties, list this matter again after 2 weeks on a date to be fixed by the registry. Respondents are at liberty to bring on record their respective pleadings, if not already filed, before the next date of listing. Full stop.
Can we fix a date also?
SHRI.
While here, we are supposed to file affidavit as per last order.
You
But
filed
kindly
the
grant
affidavit.
2 weeks time, my lord. 2 weeks time.
You filed the affidavit.
File 2 weeks.
Secondary is
Elementary.
Director of Secondary Education has filed, elementary.
How come both are involved here?
Order of termination is under challenge here. Director of Elementary Education has filed the affidavit.
It was secondary.
Secondary.
Lordship, here the case is that the petitioner, after 10 years of rendering service, she has been terminated from service on the ground that at the time of her applying for pursuant to the advertisement, she had suppressed her education qualification. That is the issue. She's a Hindi teacher. It seems what they allege is that she does not have Hindi as one of her subjects in graduation, and that is what she had suppressed. And after 10 years,
No proceeding.
no proceeding. A notice was given. After that, no proceeding in terms of the rules.
Okay.
And the director of, she's under the school in which was appointed.
That got amalgamated and then director secondary.
She comes under the director of secondary education. Now the elementary education department, they have issued a notice, and thereafter, without any proceedings, they proceeded to terminate her. Director of
Where's the termination order?
at page 46.
When was the amalgamation?
Amalgamation at page 48 in the year 2017.
Yes, Mr. Kaushik.
Hello.
Once it is amalgamated,
Hello.
what jurisdiction does your elementary education department have? Over her. Has everything gone? Or was an order passed by the competent authority carving her out, putting her back to you?
No, that's not the
Then-
case. But Assam decision. Assam.
Elementary education does not have any power. Also in terms of the service.
Appointing authority was Director of Elementary Education. By
That
way of-
appointment authority by virtue
by
of that
virtue of
amalgamation,
Amalgamation.
gone.
Gone.
Disciplinary authority becomes the director of secondary.
His
education.
service is placed under the
Not placed, gone. It's taken out from your jurisdiction. Everything is controlled now by the secondary.
but whether the secondary would, by virtue of the amalgamation, would become the
They will
appointing
become
authority.
the disciplinary
Appointing
authority, anything happening, they will be the one who will have to now take it up. Think.
Well,
Let him
Lordship,
think.
The definition of appointing authority under the service discipline applicants makes it clear, but it's.
He is trying to develop a point. Let him.
But
Give
they
him
filed
some
an
time.
affidavit. They filed an affidavit.
Fine. Let him argue. This is no affidavit is required. This is legal point.
Yes, yes.
He did not think that you will take up this legal point.
That is in my pleadings.
But he did not think that you will press it before me.
No, that is what they've taken up in the affidavit also.
He did not think. That is his problem. So let him work it out.
Next.
Mr. After vacations, you work on this.
Yes, yes.
No, they have already filed an affidavit. They have filed it on in that point itself. They have taken the plea that general clauses.
Madam, what is going to happen today? Deferred for 4 weeks. That's all. That is the one going to happen. But I want to give them an opportunity.
They have
Let us see.
given enough.
If it was some other thing, we would have understood. But amalgamation, what are the
Effect of the amalgamation.
effects of that? What is the problem? Let us, because if I pass an order today, it would be the law. So if I have to pass it, I should be confident that yes, gone. Everything civilian. That elementary has got nothing to do with here.
Yes, that is in my pleadings, and that is the stand taken up by them in the affidavit.
Immediately on reopening. Mr. B. Kaushik, Learned Counsel for the Elementary Education Department, submits that he be given 2 weeks' time to make his submissions in the matter with regard to the issue raised in the present proceedings by the petitioner, that the school having been amalgamated with the high school, the services of the petitioner would now be governed by the secondary education department and not the elementary education department, and accordingly, the order impugned in the present proceedings passed after the amalgamation of the school and placement of the petitioner in the secondary education department, by the elementary education department would not be sustainable. Full stop. Registry accordingly, registry is directed to list this matter again on 16/7/2024.
Simple prayer. Here we are challenging the impugned order on the procedural as well as on merits. On merits, not may I just submit merits. The cases that
Initiation,
NCT regulations mandate that
madam,
it should be
that initiation is bad. It is bad on many counts, and this is one of them.
no. Merits. Why I'm stressing on the merits, because if it goes obviously if it goes on the procedural ground, then again probably there'll be a second round arising because of
That you make your submissions.
No.
I have not put these words in your mouth. I put it in his mouth only.
No,
It's
what I'm
open to you. It is open to the petitioner to raise any further submissions or issues in the matter. Any other points of law as may be involved in the matter on the next date of hearing.
No, what my prayer is that let them place the relevant provision of the NCT regulation which mandates that Hindi is required as one of the subjects in graduation. Because
Madam,
all along
madam,
in the notice
madam,
as well as here,
madam.
everything is silent here.
As far as I know, with regard to NCT Act, you are one of the experts. You produce it.
But can it be on 18 melody?
18, no problem. 18.
Unfortunately, I do not have a hand in termination appointment.
No. You show me that
Nothing.
acts and tell us that it is not there, then they will respond.
That is already there in my minutes.
Forget it. That's all. Because the volume of matters you have done for NCT, you are a master on that. You're an expert on that.
44.
This is with regard to suspension. They were directed to bring the reviewing order, prolonged suspension, more than 9 months.
My lord, up to date instruction in AWS, sir.
Wait.
12/6. Kindly grant one.
Why? We gave you time on the last occasion. Miss Sutia had appeared.
Yes, sir.
Then what happened?
That instruction is awaited, my lord.
Why? How long?
My lord, 1 week, my lord.
Tomorrow.
Yes.
Friday.
Friday.
Spread for Mr. G. Pegu. List this matter again on Friday. By slip, what had you got? 20.
Otherwise, Lordship, if they do not bring their instruction, Lordship, this will be disposed of.
You reiterate your prayer on that day.
Has been given.
You reiterate your prayer on that day.
45.
In this case, last occasion, Lordship asked me to produce the SLC. Can it be taken at 2, my lord? I will produce.
2 p.m. 2 p.m., Mr. Ahmed.
46.
This case, my lord, the finance department has not filed their affidavit, my lord. Education department has filed, and we have also given the reply. But the finance department has not filed. Unless they file, my lord, after the disposal, my lord, they will make thousands of queries and queries after queries.
But there is no one making a prayer.
Finance. 46. My affidavit, yeah.
Why is the finance required to file an affidavit here?
Last occasion, when what happened, they have made the queries after queries.
Oh, that is their right.
Yeah.
They are not there to only pay. They are also there to protect the exchequer of the government. Your and my money. It's also their headache. It is stated in the bar that the pleadings in the matter are completed and can be taken up for consideration for taken up for final consideration. So accordingly, registry to list this matter again on 23/7/2024.
47.
Yes, what happened?
My lord, here compassionate family pension, that is released up to 31/3/2024.
Have you received?
No, my lord.
Then after 31/3/24, what will happen?
Then normal pension, my lord.
Why? My
31/3.
father will retire in 31/3.
No, my lord, my father who died, my lord.
No,
was
that
supposed
is
to die
untrue.
in-
When was his date of superannuation?
His date of superannuation was yes, my lord, it is 1/6/2024. 31/5 is correct, my lord.
Second page, my lord. Second page on the
No, I said 31/3.
31/3/2024.
That exact date, my lord, I need to verify from the petitioner, my lord.
Now the
By 31/3.
thing has been done.
31/3 retirement.
Oh, today is what date? 18th. 19th. It was issued on 15th. Where will you get it? It was issued for the court purpose.
My lord,
It will take you another 2-3 days to reach you.
my lord.
Mr. P. Soikia, Learned Counsel for the
Pension
Director of Pension Assam, has submitted that the PPO in respect of the petitioner, in favor of the petitioner, and including therein the compassionate family pension for the period with effect from 28/2/2018 up to 31/3/2024, and thereafter with effect from 1/4/2024, family pension at the normal rate has already been authorized by the PPO dated 15/6/2024. Also, Mr. A.R. Bhia, Learned Counsel for the petitioner, has also been furnished with a copy of the PPO as authorized to the petitioner in the matter. Also, Mr. Bhia prays that he be given a week's time to receive his instructions in the matter. Also, accordingly, registry to list this matter again on 27/6/2024. Just give him a copy. Just get a confirmation as to whether this has come. This has come and that date of retirement.
Retirement, correct.
Anyway,
Ultimately,
a
something.
good action, appreciable action taken.
That is.
We appreciate you for that.
Oblige.
We'll keep that in mind in a tight situation for you.
Oblige me. Highly oblige.
Massively. Huh?
Next item.
Material.
This person who had a challenge an order of attachment to a school lordship.
Huh?
That order has already been stated and they are supposed to file academic.
Yes.
Well, the instruction which I have received is, it is just a stopgap arrangement for the school ballot, as there was no senior assistant there. It's for my lord. Your lordship will find page 33, the impugn order. The order itself is very clear.
That is the issue.
As per letter received from so and so regarding attachment of senior in the best interest of the school, Abhijit Biswas, inspector, is temporarily attached to RZ Memorial. This is a stopgap arrangement and comes into effect. He's getting his salary from the inspector of school. Only for a till the senior assistant, some other.
Is there any restraint order from this court?
Yes, yes, Lordship.
Where is that?
Your Lordship, if your Lordship kindly tell the order dated 12/1/2024, your Lordship will get, actually, your Lordship will.
In this
Because
case,
that appeal order was passed during the operation of another interim order. Lordship.
that is what I'm asking.
Yes,
for.
Lordship. Page 20, Lordship.
Yeah.
Originally, they were transferred to different school, Lordship. That is the transfer order is page 15. Then interim order is page 20. And that order has been extended. Subsequently, another petition is filed challenging one notification, that is page 21. Both the petitions are pending and rule has been issued in those cases. Lordship. I have annexed the latest order of that.
15, where is your name?
My lord, page 15,
Hmm?
serial number 4.
Abhijit Biswas.
My lord.
Fifteen is a purely transfer order. Well. They were transferred and posted at the
Office. Oh, then he was brought here as a temporary measure.
yes.
And where is the impugned order, the order passed by this court?
My lord,
11/1, 11/1/24. Okay. 12/1/24. Then you are continuing in inspector schools.
my lord.
Then what is the headache?
There is no file in this case, that's why, Lord.
Registry, Mr. You want to file an affidavit here?
We'll file a-
Mr. B. Kaushik, Learned Counsel for the petition, Standing Counsel, Secondary Education
Secondary.
Department submits that they would like to file an affidavit on behalf of the said authorities in the matter. Accordingly, registry to list this matter after 4 weeks on a date to be fixed by it.
Interim may be done.
Interim not to be continued. Interim till the next date of listing.
Obliged.
What is the headache? Nothing is there. You are protected.
Yes, Lordship.
No,
that's why I'm
he
not-
is want some time, give him.
I'm not
Why
objecting, Lord.
confused?
That's why I'm not very, first time, Lordship, I say.
59.
Oh, why itu last episode nanti. Mari diutak.
I am appealing for the response number 4. Principal of the college. I need 1 week time for filing a petition.
Mr. H. Sharma, Learned Counsel, appearing for the response number 4 submits that he be granted 2 weeks time to file, to bring on record the stand of the response number 4 in the matter by way of filing an affidavit. So prayer accepted. List this matter again after 4 weeks on a date to be fixed by the registrar.
16 Lordship.
Item 16.
Oh, Lordship. Yes, yes, yes.
Wait, just wait, he'll be coming.
Oh.
Just wait. Serially, Mati. Oh, Mr. Fukan is here. Itu dia. Yes, Mr. Fukan. Which is the case?
That case is disposed of, directing the petitioner to file appeal before the state government against the order.
4652.
4652. Yes.
First para. Subject to filing such statutory appeal by the petitioner before the Secretary Department of School Elementary Education Assam on or before so and so as directed by above in terms of the interim observation made by the court on 29/2021 In the present proceeding, the provincialization of the respondent number 7 under the provisions of the 17 Act shall remain suspended till such disposal of the statutory appeal. Now,
Was any appeal filed against this judgment?
No, Lordship. They were directed to file an appeal, Lordship, but till that, nothing has happened.
my lord, what my
Can you give
instructions
us
are,
30 days
I'm awaiting more instructions that there is a appeal which is pending before the tribunal.
No. We are not concerned with that.
Because
What happened to this appeal?
There was a time period, Lordship, in 90 days they should dispose of.
And my lord, there is a problem which is going on. That's what I asked the officer concerned, that this Chayamiya as well as Rabiul Haq are both language teachers. So one of them has filed a case, man. I think
That is something which is action which you will take in future.
So because of that,
We are still in the past. Now, then okay, tell me, respondent number 7, Rabiul Haq is also provincialized? He's a petitioner here?
No,
Yes.
not petitioner. Not in this present petition, Lordship.
Rupsan Ali is provincialized?
Provincialized, Lordship.
Then why Rupsan Ali's payment is not made?
Not yes.
No, my lord, Rupsan Ali is not before us.
Yes, he is before us. Petition number 2.
Petition number 2.
Rupsan Ali, my lord, I'll have to take instruction regarding that because she's a science and maths teacher.
Be that as it may.
My lord.
Only I am concerned with the regularization order. No challenge to that today.
My lord, will give me some time, my lord, in the next week, my lord.
That's the only thing we are
My lord,
doing in
I'll
this
give
matter.
the proper instruction because
That is the only thing we are doing in this matter.
my lord, the
Giving you
salary
time.
was not given because that's what they told me, because of the fact that there's a this thing appeal pending before the tribunal.
No.
The-
Is there an appeal pending before the commissioner?
That I have to take instruction. That I'll take.
Then why? What is this?
That, my
What
lord.
is this? You make a phone call
I will fix it on some other date. my lord.
tomorrow.
Tomorrow.
Tomorrow at 2 p.m. Tomorrow at 2 p.m. If there is no appeal filed, by next week their salary should be,
Secretary.
before the secretary, next week their salary should be released.
Okay. I'll get that instruction.
Now, on the prayer of Mr. A. Fukan, list this matter again on 20 at 2 p.m.
2 p.m. Deeply appreciated.
Let's see. If there is no appeal, then that salary is
Yeah.
from the date of provincialization, within 1 week you release it.
My lord, for the second, the petition number 2, the one is, but there's a confusion there, my lord. That I'll
Oh.
get the thing.
If there is no appeal filed, then both will get it. If there is an appeal filed, then petition number 2 will get it. But one of them will surely get it.
One of them will get that much I can say. My lord, but
You get me the copy of the appeal,
one of
date of receipt,
my lord.
and then what happened in that.
My lord.
Your Lordship.
Hmm.
Lordship, as per the last order, the direction was given to the secondary education department to bring a specific instructions with regard to the case of this petitioner. After her case was recommended by the state level scrutiny committee in its meeting held on 02/08/2023, Your Lordship, for provincialization of her service.
Yes, Mr. Kaushik,
So place the instruction on it.
tell me what has happened.
Well, the state level scrutiny committee has recommended the petitioner's name and has a proposal was sent for creation of the 23 numbers of posts.
Where?
Meanwhile, the joint committee has directed for re-verification of the claims of the petitioner by an independent authority, my lord, as regards this genuineness.
You are taking remedial measures or should I come in?
My lord,
I
like you so much.
You will take remedial measures or should I come in and do?
I'll take.
On the prayer of Mr. B. Kaushik, list this matter on 26/6/2024, on which date the implementation order with regard to the recommendations of the state level scrutiny committee be placed before this court.
I'll
May it please your lordship. My lord, in last 2 occasions, my lord, State Council has taken time to give the instruction as to why, as to
Ali Tangani, Osmania.
And whether the university from which the MA degree has been obtained has been recognized or not, my lord. For that purpose, my lord, they have taken time in last 2 dates, my lord. Regarding permission, my lord, my instruction is this, my lord, no.
Yes, Mr. Sharma. Have you?
No, it is a matter of UGC, whether it is recognized by UGC or not.
UGC, everything, they'll file an affidavit giving the history of UGC, nothing they will bring on record. So it is you who have to take that initiative.
And moreover, my lord, during the regular service, he has not acquired any permission from the authority.
You want to take further instructions in the matter?
Yes, yes.
Mr. U. Sharma, Learned Counsel for the Secondary Education Department submits that he be granted 2 weeks' time as a final chance to complete his instructions in the matter. Full stop. Registry to according to list this matter immediately on conclusion of 2 weeks from today. Full stop. That is after the ensuing vacations. Full stop. In the event the instructions as sought for are not brought on record, full stop. Further orders as may be required to be passed in the matter would be so passed, considering the materials already brought on record. Only thing you just get a confirmation whether that institution from which he has taken his MA degree is a recognized unit, and whether it is a direct, you say it is not written as a distance education, so we will take it as a regular.
Yes.
Even if it is distance education, whether that institution not having a jurisdiction over Assam could have done that course.
Yes.
Ask Mr. Gogoi, he will help you. Just place that instruction before this.
Yes.
Wait, please, my lord, I am for the respondent number 6, my lord. 3 weeks time may be granted on filing affidavit.
Why?
Affidavit in opposition.
Why? Why? Why have you not filed it till now?
My lord,
When did you receive notice?
today is the first day for
No, that is the first day, it's okay. It is coming up after 3 months, that's a different issue. But when did you receive notice in this matter?
we Okalam file 4-5, my lord, today 24.
On the prayer of the Learned Counsel for the petitioner, for the respondent number
6.
Registry to list this matter again on 17/7/2024 in the event. So it is expected that by the next date of listing, the private respondent shall bring on record his stand by way of filing an affidavit. The state respondents are also at liberty to bring on record their respective pleadings in the matter.
Obliged.
This is a very familiar name for me.
Yes, sir.
Yes.
Unless their instruction is evident, my lord, so sometime is required. 2024 matter, my lord.
It's similar to that item number 13, man.
You have an interim order?
Yes.
On the prayer of Mr. U. Sharma, registry to list this matter after 3 weeks on a date to be fixed by it. Also, Mr. U. Sharma shall invariably on the next date of listing, before the next date of listing, shall bring on record the stand of the Secondary Education Department on record by way of filing an affidavit.
But it may come along with the WBC2.
Independently. Let us not create a series. The list after 3 weeks. Yes, Mr. Bha.
My lord, in this case, my lord, petitioner challenging his order dated, my lord, page 73, my lord. This honorable court order dated, my lord, page 69, my lord. There's an order, and pursuant to there, my lord, directed to the respondent number 2.
Mr. This is elementary.
Elementary, man.
Mr. B. Kaushik.
Would you like to file an affidavit here, Mr. Kaushik, or we'll proceed with the matter on the next day?
We'll file, madam.
Mr. B. Kaushik, Learned Counsel for the Learned Standing Council, Elementary Education Department submits that he be granted 3 weeks time to file to bring the stand of the secondary, the Elementary Education Department on record by way of filing an affidavit. Also, accordingly, registry to list this matter after 3 weeks, the interim that passed earlier to continue until further orders. Yes. Yes, Mr. Bego, what is your 68?
Lordship, instructions had come with regard to this matter, Your Lordship.
What is it?
May I be permitted to give a soft copy?
Yeah.
Yes, Your Lordship.
We'll take it up after some.
Against him, an inquiry has conducted, Lordship, and inquiry is concluded, Lordship, but till that he is not allowed to work, Lordship. And page 31 is inquiry report last occasion it was came and Lordship directed to obtain the instruction. And directly limited education inquiry and Lordship submit the report before the government, Lordship, Commissioner, that is 18th of January 24, page 30, Lordship. That, Lordship, the inquiry committee suggested 3 categories of punishment. No.
Who are they to suggest these punishments?
Lordship.
Who are they to suggest these punishments?
Lordship, they directly limited education officers. They inquired, Lordship, pursuant the government letter, Lordship. Page 31 can be seen, Lordship.
Oh, that torture of the minor girl. Yes, what do you have it?
In this regard, I need some time, madam,
Wait,
for instruction.
not in a position to take a decision. This was given on 18th/1.
Right.
What is happening? Why is your director sitting over the matter?
Then taking up all tomorrow, madam.
On the prayer of Mr. B. Talukdar, Learned Standing Council, Elementary Education Department, registered to list this matter again on 27/6/2024. On which date?
Salary from August, Lordship. But I am not I'm suspended also, Lordship. Not getting salary. That is the difficulty, Lordship. And not allowed to work also, Lordship. And there is a direction from this court to give the salary also, Lordship, from this court, Lordship. Order
Show me.
dated
Where?
3/5/24. Can you say 3/5/24? Last 2 para. 3/5/24. Last 2 para of the order.
Mr. Talukdar, please for time till so and so to bring on record the decision has arrived in the matter by the authorities with regard to the inquiry report submitted in the matter against the petitioner hearing. Also, Mr. B. Talukdar shall also apprise this court as to the steps taken in pursuance to the directions passed by this court wide order dated 3/5/2024 pertaining to release of the area salaries of the petitioner. 27.
Right.
Presently, Lordship, today I am appeared for the university, Lordship. So Lordship may give some time, I will file affidavit.
This is with regard to a cancellation of
Lordship,
appointment.
Lordship, I have.
So earlier the better.
Lordship.
When?
Lordship, after 4 weeks, in the meantime, I will file, Lordship.
Mr. T.H. Hajorika, Learned Counsel for the petitioner, and also Mr. K. Gogoi, Learned Standing Counsel, Higher Education.
Lordship, as a standing council, university.
Oh, as a standing counsel, what is this university?
Uninterrupted Sports University, Lordship.
For the respondent number 2, university, also. Mr. A.R. Tabildar appears for the standing counsel, Higher Education Department appears for the respondent number 1. K. Gogoi 2, 3, and 4. Mr. K. Gogoi, Learned Counsel, Standing Counsel of the respondent university submits that the affidavit of the said university in the matter would be filed on or before when?
Lordship, give this.
You tell me.
Last part of July, Lordship.
No.
Then third week, fourth.
Third week.
We commencing from 22, Lordship.
On 23.
20.
23/7/2024. The petitioner thereafter would file his rejoinder thereto before 29, by 29/7/2024, registry to list this matter again on 31/7/2024.
Applies.
This is the notification.
Yes, Mr. Khatonia, what is your instructions?
No, my lord, no. The instruction that I have placed last date, my lord, that is the instruction, my lord.
It will be wrong. Provisional salary dividend immediately. Provisional salary should have been paid, my lord, immediately. And regarding the treasury officer, my lord, he has stated that, my lord, he has not received any proposal.
Now, who should be held? Hold up. You have made a false statement. No, not you.
Yes, sir.
Your authorities. Now this is contempt. What do we do?
I leave it to lordship, my lord.
I want the officers here tomorrow. Who had given the instruction? Block.
No, I have received the instruction from the directorate level.
No, the
So
director.
they have collected, they collected from the block level, my lord. But I have received from the directorate level, my lord. Whatever I have received, my lord.
In terms of the directions passed by this court wide order dated 14/6/2024, Mr. B. Gogoi, Standing Counsel Finance Department, has placed before this court the office memorandum dated 26/8/2021 pertaining to the release of regular salaries to newly appointed government servants. Also, a perusal of the same does not reveal that for release of the salaries, a GPF account of such employee is mandatorily required to be opened. Also, Mr. Gogoi has further placed on record a communication received by him from the Treasury Officer Morigaon, wherein it has been stated that the salary bills of the petitioners herein were not submitted to the said Treasury till 13/6/2024. Also, on the last occasion, the Standing Council Elementary Education Department had placed a communication issued by the Director Elementary Education Assam, wherein it was contended that the salary bills of the petitioners were not being accepted by the Treasury Officer Morigaon in view of the fact that GPF account in view of the fact that GPF accounts in their name were not so open, and the same was stated to be necessary for processing the first salary proposal in the Fin Assam portal. Also, such a communication was made by the Director Elementary Education, basing on the communications made in this connection by the Block Elementary Education Officer Laharigat, wherein he had submitted that the the salaries of the petitioners were not being released on account of the fact that the Treasury Officer Morigaon was unable to release their current salaries. Also, such a contention now has been demonstrated to be clearly without any basis, basing on the office memorandum dated 26/8/2021, as well as the communication dated 13/6/2024, issued by the Treasury Officer Morigaon in the matter, and placed before this court by Mr. B. Gogoi, Learned Standing Counsel, so and so. Accordingly, the Block Elementary Education Officer, Lahorigat, Morigaon, and the District Elementary Education Officer, Morigaon, shall remain personally present at 2 p.m. tomorrow to receive further orders from this court. The above order, the direction for personal appearance of the said two officials shall be communicated by Mr. N.J. Khatonia to them, and Mr. Khatonia shall ensure compliance of this order. Tomorrow 2 p.m. At 2 p.m. 2 p.m.
Within your office, maybe I like to have the director also.
Along with the director, elementary education officer. 2 p.m. tomorrow.
Yes, sir.
And you still can be exonerated, provided by 1 p.m. I receive the first salary payment orders. Anything. I'm not saying arrears, salary, first salary.
Yes, ma'am.
If that is because everything is gone tomorrow, from here I can send them to jail. Because they have made a categorical statement before this court, which is now found to be false. So please take care.
Yes, sir.
1 o'clock, you give me those orders, I will consider not proceeding with the matter at this stage. If not, 2 p.m., we will be drawing up proceedings. Obliged. Oh, Mr. Chaudhary, we will have it, tomorrow is Thursday. We will have it Friday 10:30. Friday 10:30. I'm giving you 1 day, full 1 day time. Do whatever you want to do.
Yes, ma'am.
Push wherever you want to push. Get this thing done. If not, Friday we will draw.
Obliged.
Friday, mister. Now everything is clear. And don't come with a speaking order to me. Don't come with a speaking order.
Yes, madam.
I want action here.
Yeah, Lordship, we have already complied with the direction with the Honorable Court. Last occasion, I have submitted that we have already sanctioned that career assured program scheme, Lordship, that benefit, Lordship. And it is now pending before the Accountant General. And direction is at page 18, Lordship, may kindly see last.
You are relying on this communication dated 4/12.
Yes, sir.
Have you received the amendment?
No, my lord.
Now, that Accountant General is also a party in this contempt proceeding.
Who is appearing?
I think none has appeared. I think I did by feel that, Lordship.
Mr. Chisti, ask your officers to get in touch with them.
Yes.
This should have been done by now. We'll have it next week.
Anything.
Just say, now it's only the release of the amount.
Yes.
Have you got a copy of this order? 6/4/12/2023.
Yes, last time I have submitted.
You have given. Okay. Mr. Sisti has submitted that the sanction with regard to payment of the dues of the petitioner under the Assured Career Progression Scheme has already been sanctioned by the Governor of Assam. Has already been sanctioned by the competent authority, and the same has now been forwarded to the Accountant General bracketed A&E Assam for disbursal of the amount, so working out in favor of the petitioner hearing. Also, accordingly, Mr. Sisti submits that he will receive the necessary instruction as to whether the said amounts have been disbursed by the Accountant General in the meanwhile. Also, accordingly, list this matter again on 27/6/2024 for further orders.
Obliged.
58.
Yes, Mr. Gogoi, what is the development?
58 Lordships, the Dibrugarh University has again take Lordship 82 crores additional proposal, Lordship. Otherwise, last occasion I have placed on instruction, Lordship. That part was already released and that was already given for regular pension, Lordship. Now, Lordship,
Mr. Chaudhary, have you received any money? Not even a single. What is this?
As far as area is concerned, not even a single part.
Area, Lordship, they have 25th, they have given a proposal, Lordship. and it is pending for the government. So Lordship may fix it after.
You are receiving the regular pensions,
They are receiving. They are
current
receiving.
pension.
They are receiving. Lordship. They are receiving.
But what about the areas? That is
Area,
the
area on 25th, Lordship, 82.
only 82 crores.
82 crores, one additional proposal, 82 crores given, Lordship.
No, no.
And
What
all
is the total area bill now?
Total area is Lordship 82 crores.
82 crores.
Total.
82.13 crores.
That
Otherwise,
means if you get 82.13 crores, all the
Lordship,
clients of Mr. Chaudhary will be paid.
One goal.
One go.
Only. That will be done as because Lordship, there is a budget proposal of Lordship 13,827 lakhs, Lordship. Out of 13,827 lakhs, Lordship, 3,456 was Lordship already released, Lordship.
No, that was for the current pension.
Current.
Current
And other part, Lordship, 82 crores,
my
they have
lord,
given a proposal,
let them
Lordship.
pay the money in two installments, not in one.
No, now they are doing it in one installment. Let them do
They
it.
will get only one installment.
How long will you take? Give me a time frame.
Lordship may fix it the matter after 4 weeks, Lordship. In the
No.
meantime,
I want a date
Lordship.
by which you give me a date of your choice.
Lordship, then Lordship,
I am fixing it on Monday. Mr. Gogoi, I am fixing it on Monday. You receive your complete instructions in all aspects. That by which date? If you say it is 2030, no
already,
problem.
Lordship, there is
But
a,
tell me that.
already there is a budget proposal. There is no difficulty.
We don't
So
understand.
Lordship may fix one.
We don't understand all those things.
Lordship.
We only know our order requires to be paid.
Can I just come in?
Ah.
I have some idea of how the government works, my lord. There are three ways money can come. Either it is incorporated in the annual budget, then or
Supplementary demand.
contingency fund or supplementary.
Now
But
contingency fund.
contingency fund they can always do.
That proposal is for contingency fund. Lordship
Then
may
they can
fi-
always
fi-
do.
Contingency funds is
So,
because
my
there
lord,
is already
may I say this way, my lord. Let the
already there is
matter
a
be
there
called
was.
on immediately after reopening.
Contingency.
Let them, my lord, place that instruction.
Lordship may fix after 4 weeks or reopening, Lordship, as because it is a proposal for contingency funds and fund is also available, Lordship.
Kindly note that.
Where is that contingency fund?
It is there. It is
Where?
there.
No, just show me that.
Last paragraph, Lordship. Last paragraph.
ठीक है इधर हमको ले आओ My lord, in case of contingency fund.
No, I want it to be mentioned here. It's not mentioned here. Where?
Director's letter. Director's letter. Not university's letter. Director's letter.
How it is mentioned?
Last paragraph, Lordship. However, it starts from however, Lordship.
How it mentioned that a CF proposal was submitted to the
It's a
contingency fund.
proposal. Yes.
Okay.
Contingency
Mr.
proposal.
K. Gogoi, learned counsel for the petitioner by placing reliance on a communication issued by the Director of Higher Education Assam, dated 12/6/2024, has submitted that a proposal has been submitted to the government in the education bracketed higher department for release of an amount of rupees 82.13 crores only for payment of the area pension to the eligible retired employees of Dibrugarh University from the contingency fund. Full stop. And the same, it is contented, would be now processed and the payments made at the earliest. Full stop. Accordingly, Mr. Gogoi submits that the release of the funds
Lordship,
would.
proposal was already sent by the directorate to the secretary. My lord may indicate that part.
I've said that.
Lordship.
I've said that.
Lord can have it on 18th. my lord.
Mr. Gogoi submits that the said release of the amount would take at least a period of 4 weeks from today,
In
and
any
accordingly
case, it
prays
will be
that the matter be listed after 4 weeks. Registry accordingly to list the matter again on today is 18th.
Yes.
4
So
weeks.
next 18th of July.
On 25th or 24th. Lordship.
24th or 20, we'll give them a week's time.
24th.
24/7/2024.
My lord,
It is
24th I have difficulty. Could it be on 19th of July?
That week I have some difficulties. So that's why we commenting on 20.
Whenever you're convenient,
Then 26th.
26.
Yes.
26/7/2024. It is expected that the compliance order after payment of
that
the
will be
release
a-
of the said amount involved to the to the Dibrugarh University would be placed on record by Mr. Gogoi on the next date.
My lord makes kept the letters as a part of the record. Otherwise,
The communications as placed on record by Mr. So-and-so is kept on record and marked as X and Y respectively.
Deep.
Lordship.
We were supposed to close the speaking order. There was a hearing conducted.
That you were not initially not permitted, then that case.
Yes. On last occasion, on last order, loss, we have seen 31/5/24. Mr. Modi was supposed to give him after the status. Lordship, that I have been informed that the status has not yet come. Lordship, may kindly grant some time.
Oh, no problem.
Yes. And he's also.
Mr. Chisti submits that the process for compliance of the directions of this court is under active consideration of the respondents, is being actively done by the respondents, and accordingly prays for further 2 weeks' time to bring on record the compliance report. Also, accordingly, registry is directed to list this matter again on 18/7/2024, on which date the compliance report shall be placed on record before this court. Yes, Mr. Vakil.
On compliance of order dated 23/4, my lord. And in the earlier occasion, my lord, the respondent number 6 time for receive instruction, my lord. Respondent number 2, Director of my lord, Elementary Education. Authority portion, my lord, page 36, my lord, paragraph 7.
Who is appearing for respondent number 1?
Respondent number 1, my lord.
Nobody is appearing. 2 I am appearing, my lord. Lord, I have received the instruction. The Deputy Inspector of Schools, my lord, has resubmitted the pension proposal on 28/5/2024. To the pension department.
So, pension?
Pension institute.
Lordship, just with regard to that 28/5/2024, your lordship. Let me bring to their notice and will avail the necessary instruction on the.
Why have you to bring? Can't they do? Don't they have a notice of that?
Because it shows that they have sent it on 28/5/24. So after.
Mr. Pegus, Learned Counsel, appearing for the respondent number 3, submits that he be granted a week's time to receive instructions with regard to the revised proposal stated to have been submitted by the Education Department on
The inspection.
on
28/5/2024.
on 28/5/2024. So accordingly, list this matter again on 17/7/2024, on which date Mr. Pegus shall apprise this court with regard to the developments taking place. Be duty, sorry. Be duty.
All right.
One.
In this case, IFR impeachment has been allowed. IFR impeachment has already been allowed on 23/2024.
Okay, you have filed the amended cost title.
Yes, already filed.
Steps you take now.
Notice is to be issued.
It is seen that the petitioner has filed an amended cost title, bringing on record the newly implemented respondents 4, 5, and 6. Also, accordingly, petitioner is directed to take steps for service of notice upon the newly implemented respondents number 4, 5, and 6 by way of registered post with AD. Also, registry to list this matter again after 4 weeks with a report pertaining to the status of service upon the said respondents. Service of notice upon the said respondents.
Last week, your lordship ordered it 12/2024, lordship. 12/2024. Your lordship directed, my lord. On request, Mr.
Yes, where is Mr. Naik? Ms. Pidas, SSA. That dice code.
My lord. The order, my lord, page 26, my lord, onwards, my lord. There are 9, my lord. The second time minor is coming and same similar with the all are release minor, except on the region for which like the content case minor, they are in spite of earlier occasions, many times they appeared minor.
Wait for some time. If none comes, we will call the authorities. Hello, Kishore.
73.
Yes, although the service report is stated to be chaotic, but Lordship, I have a communication that they have received the copy, Lordship. Lordship, they have made some communication with some inspector, with the inspector. They have not entered the appearance. There is a reference of consultant.
This is by the director.
Yes, director to the IS.
We are concerned with the
Yes.
secretary.
Secretary.
So,
But perhaps after receiving the content notice, Lordship, the secretary has communicated to the director.
there is no reference here. Mr. Sisi, notices were issued long back.
Yes.
You just have a Mr. SMT 60, Standing Council,
Okay.
Department of School Education was who is present in the court was requested by the is requested to receive instructions with regard to this from the respondent with regard to the implementation of the directions passed by this court wide order dated 1/12/2023 in WPC number 5907/2023. Registry to list this matter again after 4 weeks on a date to be fixed by it. You can show Mr. Chisti this also.
Yes, Lordship, on 22/5, we have taken steps. My lord, service of we may be permitted to take Dusty, response number 6.
No, notices were issued only on 35, other day. It is seen that the service of notice upon the respondent number 6 is not complete. Raised to list this matter again after 3 weeks with an updated status pertaining to the service of notice upon the respondent number 6. Only on 35 it was said.
But a date may be
3 weeks. Yes, Mr. Mohan.
Has been taken in both the way, Hostel as well as Kalabana.
35 and 66. Just recently, we'll wait for some time. Notice registered post on 35 and usual process on 66. We'll wait for some time. Register to list this matter again after 4 weeks with an updated status pertaining to the service of notice upon the respondent number 4 and 5. Serially, Mata? You have not got anybody. Madam, you are appearing for the PWD. Huh? Madam, your name? Heard Ms. J. Bezburwal on a counsel for the petitioner. Also heard, Madam, your name?
M. Burman.
M. Burman, learned counsel appearing for the respondent number 3. None has entered appearance on behalf of the Public Work Department. Full stop. For the ends of justice, list this matter again on Monday. Monday. If nobody comes, we'll pass orders.
Okay.
Yes, madam, how can we help you here?
Here, some inadvertent mistake on our part, typographical error. So we need to file an additional affidavit.
What typographical error?
Here it should be the date of application. It's not 17/1/2024. It is just 1 month after the date of the father.
Accepted. Accepted. I accept that. Now tell me, after your father died when?
Yes, 17/12/2013.
13. Today, after 11 years, where is that compassion? Where is that compassion?
Hope Lordship that the given district level authority has later has never communicate with the
Sorry.
Lordship. Let us give a chance. We will satisfy in the next date. 1 week, Lordship.
Nothing is there, madam. Nothing is there.
Lordship, I insist, Lordship. I insist, Lordship.
No. You are insisting?
Lordship.
Okay. Do one thing. You may have a lifeline. You may have a lifeline. Sophie Goodin to go to say, keep on number. Sophie Goodin to. You wait. After item number 68, we will take this. I've asked the government stand in that. If the government stand is that they can make appointment anytime they want to, I'll allow your writ petition. Wait. But wait, it's not. Wait. But after some time, madam. 68, along with 68, I'll take up this matter. And where is Mr. Nutt? He's coming.
Coming. Yes.
Mata. Maybe Kiman, 28, 29. Okay. Yes. (28, 29). Who is appealing? We heard him little bit while before. Where is he gone? Okay, all of Bishop.
Clear, please, Lord.
Yes.
My lord, I was called for my lord, counseling, my lord.
That counseling exercise you could not attend. None of the headache of the department.
Due to medical, I not.
Then that session gone. Fresh session. What is left here?
Immediately, my lord, I filed one representation.
By that time it was closed. So they have said that also. They have written a letter to you saying that nothing more, because by this time the counseling process is over.
I got my lord on under defense quota. Under defense quota, I got.
Who is there? Your father?
My lord.
Father was a defenseman.
My lord.
Can't help it. Unfortunate. But we are not in a position to help you. I can't put the clock back. That course might have been over by now. It's a master's degree.
My lord.
Undergraduate.
Under.
UG. 1 more year is left.
Right.
Next time, better case. Shall I close it? Or will you want to withdraw it?
Maybe close, my lord.
Very close. Okay. Mr. S.H. Sigdal, Learned Counsel for the petitioner, and also Mr. S. Bhaiya, Learned Counsel appearing for the respond number 1 and 2. None has appeared for the respond number 3. Also, the petitioner, by way of instituting the present proceeding, has raised a grievance, has prayed for rescheduling, prayed for a direction upon the respondent number 3 university to reschedule the date for mop-up round of counseling and to permit the petitioner to participate therein for admission into UG undergraduate degree program in the said university. Also, as projected in the writ petition, the petitioner appeared in the common so Dangarobo in word Gita CETUG Dangarobo. It will apna common entrance test undergraduate bracketed CETUG 2022 conducted by the Assam Agriculture University for admission into various undergraduate degree programs in the said university. So the petitioner had applied for the said examination under the defense personnel quota in as much as his father is stated to have been working in the Central Reserve Police Force as a sub-inspector. Also, the petitioner was thereafter informed. The petitioner thereafter appeared in the examination held on 14/8/2022 and secured 92nd rank against the defense personnel quota. Also, the university authorities thereafter informed the petitioner that a mop-up round of the UGC counseling process, undergraduate counseling process, would be scheduled on 22/2023, and he was directed to appear in the same. Also, however, while proceeding for appearing in the said mop-up round, the petitioner was taken ill and accordingly required to be hospitalized. Also, for the said unfortunate development, the petitioner could not attend the mop-up round counseling on 22/2022. Also, the petitioner thereafter contends that he had submitted a representation in the matter on 21/2/2023. Also, and thereafter has instituted the present proceedings, praying for a rescheduling of the said mop-up round so as to facilitate his appearance therein. Also, perusal of the records reveals that the representation as submitted by the petitioner was duly answered by the authorities of the Assam Agriculture University, wherein by a mail. This is a mail. Dated.
March 14.
March 14, 2023, wherein the petitioner was intimated that the admission process for the UG degree program of the Assam Agriculture University has since been concluded and no mop-up round will be held for the purpose during the then prevailing academic session. Also, subpara. It is seen that the petitioner was called for appearing in the mop-up round, which is the last stage for filling up of the undergraduate seats available in various programs undertaken by the said university. However, due to the unfortunate incident of he falling sick and requiring hospitalization, the petitioner was prevented from appearing in the said mop-up round of counseling, leading to he not being considered for admission into any one of the programs so offered by the university in its undergraduate level, Also, it is seen that the mop-up round was so concluded and persons so selected were given admission into the courses available, and the whole process was brought to its conclusion. Also, in the above view of the matter, this court at this juncture would not be in a position to direct the consideration of the case of the petitioner for admission into any one of the programs, inasmuch as the academic session had already begun and the fresh academic session has now again started. In that view of the matter, the direction as sought for by the petitioner for directing the Assam Agriculture University to hold a fresh mop-up round of counseling for the petitioner would not be permitted to be granted by this court, inasmuch as this would have the effect of settling the already settled position with regard to admissions as affected in the university for the session 23-24, for the session 22-23-24. Or not 22-23 or 23-24? 22.
One of the
22. Also, in the above view of the matter, the writ petition is held to be devoid of any merit, and accordingly the same stands dismissed.
Lordship, I'm representing the Agriculture University on behalf.
You have any seat to give him?
Lordship, that because the session is already over, he was from 22-23, your Lordship.
22-23 session, huh?
22-23 session,
22-23.
Lordship.
Fine. Your name?
R.R. Gogoi on behalf of P.N. Goswami, your Lordship.
R.R. Gogoi. Heard Mr. R.R. Gogoi appearing for Mr. P.N. Goswami, Standing Counsel, Assam Agriculture University.
Obliged, Lord.
Sorry, can't help it. Sorry, can't help it.
Item 40.
Next, please, Your Lordship. Here, Lordship, I may be allowed 1 week time to file additional, affidavit, Lordship. Here, Lordship, the respondent number 4 is a widow having minor, so therefore some difficulty came to me in filing the affidavit.
No, I got it. The allegation is that the respondent number 4 applied for Sonitpur, but she was appointed in Nagaon. How?
Well, here some, I have got some documents, Lordship. Here, they have no locus standi to challenge my appointment, first of all, because the advertisement was published for Assamese medium schools, Lordship. And he, in his writ petition, also admitted that they do not qualify for Assamese medium school, Lordship.
But the school wherein the private respondent is appointed is a Assamese medium school.
Yeah, Lordship.
LOG, Hindi school.
No, medium is written, here written is Hindi, but.
Where is that appointment order, Mr. Chon?
No, Lordship.
Page 57. Whatever my learned friend has to say, my lord, that my lord, 1 year ago, my lord, 4 weeks time was granted for filing affidavit, and now, my lord, after 1 year, my lord, is going to file it.
She is a widow, she have to collect the document and the list which I have found, Lordship.
No, we'll give you time. There is no. It is Rashtra Bhasha HSS. She is posted in Rashtra. That's a Hindi school.
No, it is written there, Lordship.
No, you come to page 59.
55, yes, Lordship. I have seen this.
Then, will you have an appointment order with you?
The list which they have produced, Lordship, this list.
Forget it. Just tell me whether she was applied for in Sonitpur, because this was district-wise selection.
District-wise selection.
Did she apply for Sonitpur and she was accommodated in Nagaon? Is that the case?
Yes, that was the case.
Then,
No, she was not recommended for.
She was selected for Sonitpur also, Lordship. Subsequently, because his candidature was cancelled, thereafter I was posted.
why was his candidature cancelled?
Because this advertisement was for Assamese medium school, and for Assamese medium school, the diploma is required, Lordship.
The present school is not an Assamese medium school. It's a Hindi medium school.
The advertisement was for, Lordship, the Assamese medium school.
Show me.
Therefore, that documents I am having, Lordship, the advertisement, they have not enclosed in their petition. Therefore, I was seeking time to file the affidavit, Lordship, to bring on record.
Advertisement is at page 19,
Yes,
34.
But that list of schools, they have not enclosed.
No, we are not concerned with the list of schools. Where is that prescription? It only says that you must match with the language of that medium of the instruction in that school.
No, Lordship, if your Lordship may only turn to page 35, subclause 3A. In case of Assamese medium school, the
Must have so and so. Now you come to see, in case of Hindi medium school, must have passed HSLC or equivalent examination with Hindi language as one of the standards or read up to so and so in Hindi medium school.
No, at the time of advertisement, that post was not there, Lordship, the vacant post, which they are claiming. Because that is why I said, Lordship, that list they have not enclosed. Just for Lordship.
Show me,
to
show me,
have
show
an-
me, show me.
Okay. In the top, your Lordship will find that this is for Assamese medium. And he applied for Hindi medium. That his application is not in terms of that advertisement.
This is an advertisement of when?
Advertisement, Lordship. Page 34 in the date, Lordship.
Page 19 is the my lord from paper, my lord.
Year.
Yeah, just one. $22.
22.
22,
I think there was Hindi vacancies also.
22, my lord.
Okay, you file your affidavit by Monday. We'll have this matter on Wednesday.
My lord, Wednesday I have some difficulty, my lord. There are
Thursday?
yes.
Mr.
Yeah.
K. Ahmed, Learned Counsel for the respondent number 4 submits that he be granted a week's time to bring on record the stand of the said respondent by way of filing an affidavit. So, the affidavit of the respondent number 4 be invariably filed on or before 24/6/2024. Registry to list this matter again on 27/6/2024. Ms. D. Musahari shall receive instructions as to whether the post now against which the private respondent herein has been appointed, that is the post of Hindi teacher in Rashtra Bhasha Higher Secondary School, was also advertised.
See the instruction. The instruction is that that school is a mixed school, your lordship, because till class 10, it is a Hindi medium school, and after high secondary, it is an Assamese medium school, your lordship.
So it will be a Hindi medium school. This is a posting in a...
Lordship is the PGT teacher post, lordship, so it will be
Is
the
the
high
high
secondary
secondary.
school appointment.
For high secondary, there is
an
no.
Assamese medium school.
Yes.
My lord, whatever my learned.
Okay, you bring it on
They
record.
are, my lord, taking time. Why not they are filing the affidavit, my lord? This is the.
You give me that instruction, that will do. You give it to me on next date. Next date. 27th. Huh? This again on 27th. We'll see it on 27th.
Can I get the copy?
Right. And Mr. Chon, you also go through that list of schools that were advertised.
Well,
If the school is not there, it will be difficult. And their contention that it's a mixed school, that higher secondary part is a Assamese medium, then you will be in trouble.
this school, my lord, Hindi medium.
Huh?
Hindi medium.
No, that is the contention. And Miss Mushahari will show you. Madam, just explain to him, so he also gets it.
SLC minors and the hearing.
Yes, what is here? Where is the case of the petitioner?
My lord, second page, my lord. In case of Dhuburi.
We are in case of West Gospara Girls ME Madrasa, right?
My lord.
This is district. Hubli. Okay. Yes, where is the name?
My lord.
Serial number 2,
serial
Sahirul
number 2.
Islam.
Yes, my lord. And that it is constituted on the basis of Honorable High Court order, madam. As in application 1345, 2020.
We'll have it on Friday. Let me go through it.
Yes.
Lordship,
If you can go through it and tell me,
Lordship, I pray Lordship that
give me a copy on Friday.
so that
As prayed for by the learned council for the parties, list this
Friday
matter
or
again on
Monday,
Friday.
Lordship, please,
Monday,
because I have some matter other.
Monday.
Noted.
A copy of the minutes as of the state level scrutiny committee as produced by Mr. Talukdar, Learned Standing Council Elementary Education Department is kept on record and marked as X for the purpose of identification.
Lordship, whether may I get any, if any adverse is there, should I file any affidavit on that?
No need. Then we will ask you to
Lordship, no, on Monday,
challenge.
Lordship, then, much obliged.
Item 68 and 18.
Yes.
I'm sorry, Malad.
It's okay, Mr.
I have received some instructions.
Hmm.
In fact, Malad, the issue which has been raised by the Honorable Court, Malad, that by order dated 2/5/2024, Malad, why after so many years, Malad, these are being considered. That was the issue Lordship has framed, Malad. I have received some instructions, Malad, but the instruction is I find, Malad, it is not
To avoid contempt of court, the department has to place so and so, so and so. What is this?
Well, I find this instruction is little bit.
Because I've kept a case on hold. It's not very old. It's around 14 years, 13 years old
Correct.
case. I've kept it on a hold.
Well, these instructions basically they have said considering some of the orders of the Honorable Court, and I find, Malad, the issue has not been addressed. In fact, Malad, Lordship, to address the issue, Malad, I need some more time, Malad. They said that at various points of time, because earlier there was no time limit, that is why some orders came and they accordingly there.
Okay.
Well, in fact, I'm not pressing this. Some information has been
No,
given.
let us test it.
On 2/5/24, the Lordship wanted to know why the claims are being considered by the court, by the authorities, after a lapse of long period.
Now the father died in 99, right? There was a next kin certificate. Saifuddin. He was 16 years. So he did not even have the qualification. If I go by your prescription here, that everything will be on the date when you made the application, the rule applicable then. His case cannot be considered.
Correct. Correct. Well, I find the instruction is not adequate, Lordship.
I'm not dismissing any more matters in
But-
this line. I'm allowing it.
Well, the instruction.
Today itself, before you, I'm going to allow one case.
Well,
Appoint.
I find the
And I'll
instruction is
keep
not
it
adequate.
pending that till it is not appointed. What is this, mister?
But in fact,
You are depriving a genuine candidate somewhere
True.
on the name of compassionate appointment.
Correct.
I can give you one more date, but before vacations, I want this thing resolved. We'll have it on Wednesday next.
Lordship.
On the prayer of Mr. D. Nath, Learned Senior Government Advocate, raised it to list this matter again on 26/6/2024. What's up?
But for the time being, I'll not praise this instruction. Let me
Better.
let us have it.
Also.
Lordship. Oh,
Miss Som, today that matter not got concluded, so we are giving you a date on Wednesday. 18, huh? Huh?
I briefly applied.
18. And I assure you, if the government says that they can appoint at any point of time, I'll allow your application and see to that that is implemented.
Lordship.
26-6.
Lordship.
Mr. Not, this thing requires to be.
Correct. I have just here and there they have said something. Otherwise, it's not a decision.
Or you tell me who is the authority who can come and we'll call them for a discussion, not for a thing. We'll talk. Who?
Ultimately, the policy comes from the personnel department.
Call the secretary personal.
I'll talk to that. I'll talk to that.
Mr. This court requires Mr. Nath, learned senior government advocate, to request the. You're not calling him for any adverse thing.
Concern.
To have the secretary or the principal secretary, whoever, secretary, the secretary of the personnel department, government of Assam, to appear before this court for a deliberation on the issue involved in the present proceedings.
But there are 2-3 secretaries who is dealing with this issue.
Mr. No, 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 secretary, principal, secretary, personnel department, government of Assam, dealing with the issue pertaining to appointments on compassionate grounds, to appear before this court on 26/6/2024 at 10:30 a.m. for a deliberation on the issue involved in the present proceedings. Ask him that this is not a, you're not calling him for some misconduct, but we want to have a first-hand information. And kindly ask him to come up well prepared. Because his word that we can make an appointment at any point of time would be the Bible for me. I will record it and I'll proceed. Yes, Mr. Naik.
Sorry, my lord, my name was not appearing. That is why I missed the case. Lordship, instruction I received in this matter, Lordship, I have forwarded one.
You tell me.
Lordship, so far as my instruction is concerned, it says, Lordship, U Dias Code for Kauimari Nopomo LP School is found against Dias Code number so. And so from the year 2013-14 to 2015-16, the school name is not found in U Dias prior to 2013-14.
Why?
Para 11 manner, specific man, except 2009-10. Para 11 man.
Yes. What about this finding of this court?
Lordship.
Finding of this court. Para 11.
Lordship, I am not in this matter, Lordship. My role was only up to this much, Lordship.
Who is involved?
I'm not a party in the matter.
Yes, who is appearing? Yes, Mr. Mr. Chisti.
Yes, Your Lordship. Here, PK Bora and Ms. Anne Fukan, they were engaged.
No, fine. You are there.
Yeah, I'm here.
For us, it's enough. Now tell me how you have just received instructions, how para 10 and 11. Para 10 is the requirement for you to do in the light of the observation in para 11. Right?
Right.
Yes. Mr. SMT submits that the instructions in the matter are awaited. However, he undertakes to place before the court the manner in which the directions as passed by this court wide order dated 27/11/2020 in WPC number 2184/2017 is being so implemented. Registered to list this case again on 19/7/2024.
Like if Lordship records my instruction on next day, my presence will not record.
You need not be. Mr. will not record it. What we do is, we will give him a copy.
Lordship, one order was there, that is why I am saying.
Okay, Mr. P. Naik, learned standing counsel SSA has, in terms of the directions passed by this court in the matter on the earlier date of listing, has submitted a communication received by him from the Executive Director, SSA, wherein it has been stated that the name of the school as Kawaimari No Pomua LPS. Is not found against UDICE court number 18120416914. No, is not found from the year 2013-14 to 2015-16. It is further highlighted in the said communication that the name of the school is not found captured in the UDICE prior to the year 2013-14. Also, the said instruction as produced by Mr. Naik is kept on record and marked as X.
Two dice codes are there. 13 portal, they are given a new dice code. And earlier, my lord, 04169111, my lord, for entire.
Let him get his instructions.
Mark.
Very good. No, sir.
5829.
Delivered. खाली ये माजर to dispose करिए बाकी yes.
My lord. Petitioners are the my lord, having graduate degree my lord, with DLF my lord. And in view in persons of the my lord, new amendment act of
Now what is your prayer?
Prayer, my lord.
Should not be issued directing to treat the petitioners as headmasters of their respective school, pay the salary, relaxing this one. So how can this be?
My lord, my humble submission is that my lord, I got education and qualification my lord, as per my lord.
Under that, if it is there under 17,
But
you apply. If you have the qualification, apply.
But in case of professional qualification, that my lord,
We can't help it. We can't help it.
not got my lord.
Anyway, okay, fine. You file your affidavit. Ms. S. Chutia, Learned Council, Elementary Education, Learned Standing Council, Elementary Education Department, prays that she be granted 4 weeks' time to bring on record the stand of the said department by way of filing an affidavit. Prayer accepted. Registered to list these matters. Duta said it. Item 28, 29, after 4 weeks on a date to be fixed by it. All right. Yes, Mr. Sukia.
Petitioner has been working as a casual worker, sweeper, night chowkidar, conductor in GAUHATI Engineering College. Accordingly, some certificate has been issued by the respondent authority, Lordship, College Authority, Lordship. And thereafter, Lordship, affidavit has been filed by the respondent number 3 and 4. They have categorically mentioned an admitted fact, Lordship. The respondent number 2 has stated into their affidavit, Lordship, that they have admitted that the petitioner has been engaged into their establishment or as a contextual or casual worker, Lordship, and sweeper, hostel cook, conductor, purely on temporary basis, Lordship, without issuing any appointment, engagement letter ordered by the competent authority.
What right do you have?
But Lordship, we taking only for minimum scale of pay, Lordship, as because we are entitled to get such relief. Lordship. That
In
is
some
our-
of the employees, Lordship, the borderers are paying and they have been.
Mess dues from the mess dues they are paying.
Yes, Lordship, they are working and they are expending their helping hand.
Okay, we'll not discuss it before vacations. We'll take it after vacations. Heard Mr. M. Soikia, learned counsel for the petition, and also Mr. A.R. Tabilda, learned standing counsel,
Higher
Education Department. As prayed for by the parties, registered to list this matter again after the ensuing summer break.
Your Lordship, on hearing date, Lordship, can you be please?
Okay, on 18/7/2024. Good?
Okay.
মুখ খালি এই বাকিটা দিয়ে দিদি মাজতো মুখ দিদি
How like that?